Good morning, everybody. I think we can start our conference, although we are still waiting for some people of the morning session, but I think otherwise it will be it will become too late. Welcome to this conference that is co-organized together with the University of Milano Bicocca, the School of Law, and the editors of the book series Biolaw in the 21st Century in collaboration with the Triven Publishing. I am Silvia Salardi, and we are hosting this conference with a great pleasure. So as you have seen from the title, this is a topic that is very relevant because it's at the center of our institutional debate, both at international, European and national level. I'm very glad of the fact that the editors-in-chief and the members of the editorial board promoted the idea of making a conference and then a publication on this topic. I will keep it short. I will just give a couple of infos about organizational infos, and then I will leave the floor to the people who have to make the institutional greetings and then to the editor-in-chief of our book series. So the first information is that we had a slight change in the program. So the afternoon session will begin with the third session at 2:30 p.m. Not at 2 because Ismini Kriari was available and was available to speak in the morning, as we had to anticipate a little bit the keynote speech. The other information is that if there are questions during the question time, please put them in the chat, and Douglas Luis Bindafilo, who is here with me, and I thank him a lot for his support, will read these questions, and so will give the possibility for answer. My role in this conference will be to actually ensure the transition from one session to the other, but then the moderators will take the lead of each session. So I thank you very much, all the speakers, all the people who signed their interesting abstracts, the discussants, the moderators, for accepting our invitation. Now I leave the floor to Professor Gabriella Pasi, who is a pro-rector for international relations at the University of Milano Bicocca. I'm very glad that she could join for give us an institutional greeting. So please, Gabriella, the floor is yours.
Thank you very much, Silvia. Good morning to everybody. It's always a pleasure to introduce events organized by Silvia Salardi. She's a very good colleague who I estimate a lot. And especially besides her value and expertise and competencies, I believe that what she's working on is very important nowadays. We are surrounded by technologies. I work on artificial intelligence and language. And a main point today is that technologies should serve the purpose of making our lives simpler. And the topic of human rights within this context is extremely important. Today you are talking about neurotechnologies. All technologies can bring big benefits, but human beings should be at the center. So technologies must support our lives, and we should not be dependent in a blind way on technologies. This is particularly difficult for certain AI-based technologies. And I want to be short, and I just want to outline how I think the topic of this conference is valuable and important. So on behalf of the University of Milano Bicocca, I wish you a very profitous conference. And thank you again for coordinating this meeting today and for inviting me to open this conference. Thank you very much, Silvia, and I wish you very propitious conference and to work well toward the direction of human rights in this important context. Thank you very much.
Thank you. Thank you very much, Gabriella, for your time, for your words. It was very nice for me to have you here. Now I leave the floor to Natasha Marchei, who is the director of the School of Law of the University of Milano Bicocca. I know that she had some problems with the camera, so I've tried to, I don't know, Natasha, if you hear me.
Buongiorno a tutti.
Okay.
Scusatemi moltissimo, ma purtroppo vi vedo molto bene, però non riesco a attivare la mia telecamera. Quindi non so se ci sia un problema di compatibilità con lo strumento informatico, ma non riesco. Cioè, mentre vi vedo benissimo, mi dice che è impossibile attivare la mia telecamera.
And I don't know if Douglas is going to, are you able to activate her? Because he is the host, he has the host. No,
I
he's
try
not able,
to, I
so
try to, but I cannot.
no. Well, but if you, Natasha is going to give the greetings in Italian. So, Natasha, se vuoi comunque fare i saluti, perché non
Certo.
riusciamo. Ok, grazie. Non
Certo che li
riusciamo ad
faccio molto
attivarla, mi
volentieri e
dispiace.
mi scuso due volte, cioè mi scuso sia per l'italiano, che purtroppo mi trovo decisamente meglio a farmi saluti in italiano, quindi preferisco utilizzare l'italiano, e sia per questo inconveniente che sinceramente non mi aspettavo e mi disturba molto, perché avrei gradito moltissimo farmi vedere. Comunque, sono molto contenta di essere qui, sono onorata di portare i saluti del Dipartimento di Giurisprudenza a questo evento internazionale, e davvero è una occasione molto molto importante, di cui ringrazio moltissimo la professoressa Silvia Salardi per il nostro Dipartimento, perché il tema è un tema centrale, un tema innovativo, un tema che coniuga davvero moltissime discipline, quindi in questo senso rispecchia decisamente l'afflato multidisciplinare che il nostro Dipartimento ha sempre avuto e ha sempre voluto tenere, quindi insieme un tema centrale, un tema nevralgico e anche un tema interdisciplinare che unisce le discipline più varie, e a questa multidisciplinarietà si aggiunge in questa occasione il fatto che siano presenti studiosi da ovunque. Davvero è difficile vedere un insieme di studiosi così variegato, proveniente da tutti i paesi, e quindi davvero sono doppiamente felice di darvi il mio benvenuto e di augurarvi buon lavoro. Grazie, scusatemi ancora.
Grazie Natasha per il tuo intervento. Thank you very much to the director of our department. Now I leave the floor to Takis Vidalis, who is the editor-in-chief of this new book series, Bio Law in the 21st Century. So please, Takis, the floor is yours.
Yeah, thank you so much, Sylvia, for your introduction. Now, from my side, I would like to welcome you to this exceptional event. Thanks to Professor Salardi, we have the opportunity to listen to and discuss presentations on a wide range of topics in a field that is increasingly relevant to law and ethics. Just because today as you know, we are witnessing rapid developments in neuroscience that promise significant benefits for medicine, but also pose serious risks to our self-determination. And this concern is, in my view, so intense that arguments are already being made for the recognition of a new category, even of a new category of rights aimed at protecting the freedom of thought and expression of the individual will. So we will discuss, of course, these and many other issues thanks to your contributions. But let me for a moment emphasize how important could be to set up a permanent forum for these kinds of innovative explorations of the law, not just in neuroscience, but more broadly, modern medicine and the life sciences. This is the ambition of our book series, Biolaw. Its title is, as Sylvia mentioned earlier, it's Biolaw in the 21st Century. And it's a series of International Publishing House driven, Budapest. So Professor Salardi, Professor Priari, Professor Spranger, and I wanted such a forum in the field of scientific publishing with two main goals. First, highlighting the value of interdisciplinary dialogue so that law does not lose touch with the reality of new technologies. And second, encouraging original research, mainly by young scholars from Europe or elsewhere. Our book series will host the studies presented at our event, of course, making them known to a wider international audience. But thanks to the excellent support and the ideas of our editor, Theodora Artimon, I hope that we will soon have the pleasure of presenting two more collective volumes covering other very, very interesting subject areas. So we will continue our efforts in this spirit as a new branch of law, biolaw, is already in full swing and deserves for sure our attention. So I'm really grateful to Sylvia for her fantastic initiative. And once again, I thank you all again for your participation. Thank you.
Thank you very much, Takis. Thank you also to Tadej Spranger, who is already connected, and to Ismini Kriari. Now I see that Peter Kirchschläger is already online, so I am very pleased to introduce him. Peter Kirchschläger is a full professor at the University of Lucerne. He is the director of the Institute of Social Ethics. He is a very high-level expert of digital transformation. I had the pleasure to spend a visiting period in Lucerne this year, and I really appreciated the kind of environment, the environment that the Institute offers to people who visit it. Peter has written many books. I would like to recall one that I liked a lot, so Digital Transformation and Ethics, edited by Nomos. But again, check his bibliography because he has a lot of interesting book. So he is today with us to speak about neurotechnology and ethics of human rights, some considerations. So Peter, thank you very much for being with us. He will keep his speech shorter, so we'll try to have at least 5 minutes time for questions. So Peter, the floor is yours, and thank you.
Well, thank you so much, Silvia. Buongiorno a tutti, buongiorno a tutte. It's my deep pleasure to be here today with you, and I wish to thank you, Silvia, and your team for organizing this wonderful conference and also for taking care of us so carefully. I'm very much looking forward to enter in discussion with you today on this topic of new technologies from an ethics of human rights perspective. And as Silvia was mentioning, for me, it's really important that we have also time to talk to each other after my talk. So I will keep it in time. I will share some slides with you. What I will do right now. You should see it now, if that's correct. Does it work? Perfect. So I would like to start my talk with indicating some publications or research I'm basing my talk today on. The first one is the one Silvia just mentioned. Then I've done this book on ethical decision making, which will be influential for my talk today. And there's a new book coming out at the beginning of October on the impact of digital transformation and so-called AI on human work. What I would like to start with is introducing you to the ethics samba. Ethics samba, unfortunately, it's not a dance, but rather a model of ethical decision-making, embracing 4 steps. The first one, S, means see and understand reality, so that we are invited to get as objective as possible perception of the reality we are facing in order then to reflect in the second step, analyze the reality from a moral standpoint, to reflect on the question, what exactly is our moral standpoint? So which theory of ethics, which approach with ethical school, which ethical principles would we like to apply on this reality? And after that, the second step would then be to really analyze this reality then with the help of these ethical points of reference, leading then to the third step, be the ethical judge, where we are invited to make an ethical assessment, to make an ethical evaluation of the reality we are facing. And last but not least, the fourth step, which is important from my point of view, act accordingly, so that ethics is not only about criticizing the reality and identifying, the ethical positive potential and the ethical negative potential, but it's also the task of ethics to design or propose some possible ethically informed solutions and actions. So if we apply now this ethics samba on neurotechnologies, what would be now the next part of my talk, we can say see and understand the reality. So the reality is that neurotech is advancing tremendously, impressively. The Brain Initiative talks about that we are able to understand, I quote, the inner workings of the human mind and to improve how we treat, prevent, and cure disorders of the brain. So we have a huge medical impact there. The neurotech also embraces the possibilities of human-computer interfaces implanted in the human brain, but we have also to consider non-invasive nanotechnologies, where we are considering technologies based on nanoporous graphene, which is then a non-invasive possibility of influencing neuro procedures. And of course, we have to consider in this advancement of neurotechnologies also the possibility of converging technologies so that we can combine nanotech, for example, with neurotech, which of course needs to be then also considered from an ethical perspective. And that's exactly what the next step is about, analyzing the reality from a moral standpoint. There, I would suggest, as my title already indicated, that we apply the ethics of human rights. And of course, the question can come up, why exactly the ethics of human rights and not other ethical schools or other ethical theories or other approaches of ethics? Now, I would like to offer you the 3 main arguments why I would suggest that we apply ethics of human rights. First of all, human rights represent a minimum standard, not a higher ethos, guaranteeing only survival and a life with human dignity. So therefore, we are not expecting too much from technological progress. We are not expecting too much from your tech to respect from an ethical standpoint. Second argument is that human rights itself are protecting and fostering research, science, and innovation. So you could argue that neurotech itself is depending on the protection of human rights, for example, freedom of expression, but also access to all information protected, guaranteed by human rights, and also crucial for research, science, and innovation. If you imagine, a research institute where you're not allowed to express your opinion freely, where you don't have access to all information, it will be hard to be innovative. It will be hard to gain new academic and scientific insights. And third argument for human rights being the ethical point of reference for an analysis of neurotechnologies is that human rights are protecting and fostering plurality, which is essential for innovation as well. So by protecting each of us in our freedom and autonomy, that we can choose ourselves what we would like to be and what we would like to do with our lives, this is a source. This protection of the autonomy and the individual freedom of every one of us is the source of plurality, of diversity, which is then also promoting innovation. As we know that, a heterogeneous team is more able to be innovative than a homogeneous one. Now, if we then apply in the next step, be the ethical judge, we need to make an ethical assessment of neurotechnologies. We understand that there is a positive potential. It was already mentioned in the introductory and remarks and greetings that we see a huge potential in the field of medicine, for example, where we expect from neurotechnologies that it can help us to overcome medical challenges, to overcome some mental disorders. So there is a positive potential also from an ethical point of view, informed by the ethics of human rights. At the same time, though, there's a huge also negative potential, from an ethics of human rights perspective. I think here on, for example, on the problematic aspect of neurotechnologies, that it opens a door of manipulation. So the ability to manipulate people, which is, of course, an essential and substantial attack on human freedom, so the human right to freedom, but also, the human autonomy is here at risk. So the possibility of manipulation in different spheres, be it economic, so that we are manipulated as consumers, be it as, citizens, so in our political opinion forming and decision making processes, is from an ethics of human rights point of view an enormous risk of neurotechnology. So the ones who then hold these new technologies in their hands can basically control what we think and what we develop, what we create. And that's, of course, from an ethics of human rights perspective, terribly problematic. Now, I don't want to leave you with just this ethical assessment, but I would also respect the fourth step of Samba, which is act accordingly. So what could we do based on this ethical assessment that we understood that we have, a positive potential, but we also see a negative potential from an ethics of human rights perspective. Now, before I go into some very concrete measures which we could take, I would like to emphasize the necessity that we are not saying, okay, we have positive potential, we have negative potential, so we don't have to do anything about the negative potential because we are just still enjoying also the ethically positive potential of neurotechnologies. I think that would be a mistake, if we would think and present the argument that way, because if we look very closely at the negative potential, we understand that there are human rights violations occurring. So if someone is manipulating the human brain of someone else and is by that attacking the freedom of that person, the autonomy of that person, that's not just this negative potential which we can balance with the ethically positive potential of neurotechnologies. It is a human rights violation, and as such, it needs to be addressed very firmly, and we can still identify and enjoy and benefit from the ethically positive potential. So we often see in this discourse about new technologies that people say, well, we have positive potential, we have negative potential, and the two are kind of balancing each other, so we don't have to take care of the negative potential. I would instead argue that we should be very precise in identifying the ethically positive potential and to foster that, but at the same time, we need to be very precise in identifying the ethically negative potential and do something about it. We cannot just say, well, we just continue doing and advancing new technologies while not taking care of this ethically negative potential. And ways we could do that is actually first, and that's now the first concrete measure I would like to suggest to you, is that we should strive for an interaction between ethics and neurotech right from the start of every research and innovation process. What we do so far, you see below. So we just do what we do. We try to do everything. We try to achieve the technically possible as much as we can. And at a certain time, sometimes, an ethics board, an ethics committee, an ethics group jump in and stop the process. And we waste a lot of talent. We waste a lot of resources. And what I would suggest we should do, you see above in the illustration, where you see that we have like this interaction between ethics and neurotech going on right from the beginning of an innovation process, of a research process. And therefore, all these tiny, small ethical decisions in our daily business of research can be taken ethically informed, and therefore we are able to avoid the ethically negative, and we can together achieve then the ethically positive of neurotech. First concrete measure I would suggest to you. And of course, everything then is open to discussion right after my talk. Second step, I would like to suggest to you that we should think new technologies with ethics. So it should be informed in the way we are thinking new technologies, also the way we are setting goals and aims for new technologies, that ethics plays a role there. And of course, within ethics, then we have to make a choice which ethical theories and schools and approaches should be applied here. And as I said before, I would suggest that we integrate here ethics of human rights in this process, because for the three arguments I presented to you, that it is a minimum standard, but actually ethics of human rights are protecting research and innovation and science itself. And third, because ethics of human rights are fostering plurality and diversity, which is then enabling and fostering innovation processes. So new technology thought and being formed right from the beginning with ethics and the entire process. And we should already think, when we are setting the goals and aims for new technologies, that this setting of priorities, setting of parameters, setting of goals and aims should be informed by ethics. And last but and beyond that, I would suggest that that's something I was suggesting for the field of database systems and so-called AI in general, which I would also see applied now for new technologies in particular, is that we should think human rights-based database systems. We should think human rights-based new technologies. So we should not only just focus on the technologies itself, but already start at the beginning of the life cycle of these technologies, which is uncomfortable for all of us, because then we should look at the excavation and extraction of natural resources we need for these technologies. And already there, we need to apply ethics of human rights. So we should organize this, extraction of natural resources in a way which is respecting human rights. And at the moment, that's not the case. We have slavery, working conditions, we have human rights violations, we have child labor, we have massive destruction of the environment. And at the same time, we should also look at where these technologies are produced. Usually on sites where cheap labor is applied. So also there we have human rights violations, we have slavery-like working conditions, child labor is occurring, but also the massive destruction of the environment. And also there, we need to organize differently, informed by the ethics of human rights. And then, of course, the design, the development, and also the use of these technologies should be informed by the ethics of human rights and should respect human rights, and also the non-use, so that we have the option that we are not using what is technically possible and feasible because of ethical concerns, because of concerns of human rights. Because we can imagine that there are technologies which, of course, they are technically possible, but we shouldn't apply them from the ethical point of view, informed by the ethics of human rights. Now, the idea behind this is that innovation is not always just good as such, but we always have to make a choice between what is technically possible versus what we really should do, informed by an ethics of human rights perspective. And let me close my talk with the last concrete measure I would suggest. I'm not expecting that this is happening by itself, that research institutes, that companies are just choosing to be now, respecting human rights just, for fun. I'm not expecting them to do that by themselves. I'm not so much confident that, self-regulatory mechanisms are really working, in front of all if there are enormous economic benefits at stake. So therefore, I would suggest that we need to build an international database systems agency, IDA, at the UN, which is making sure that human rights are enforced and implemented in this field of new technologies. You might think that this is naive if you look at the if you look at the geopolitical situation at the moment. But if you look back in history, and if you compare new technologies with, for example, nuclear technologies, when you look at what we have done in the field of nuclear technologies, we have done the research, then we have built the atomic bomb, we have used the atomic bomb several times, and then we have understood, okay, if we continue like that, we're going to destroy humanity and the planet. And we have come together as international community, as humanity, and we have created a global regulatory framework for nuclear technologies, global regulation. But we have also established an International Atomic Energy Agency at the UN, probably the only UN agency with teeth, which can really enforce and sanction this global regulation and enforce the regulation and sanction if it's not respected. And of course, I'm aware of the fact that it's not perfect. It is instrumentalized for special interests in front of all of the superpowers. But at the same time, we have to acknowledge that worse was avoided. And that was exactly the goal why this International Atomic Energy Agency was built. And I would expect the same from IDA. IDA should avoid the worst which could happen in the field of neurotechnologies by fulfilling three key functions. First, access to market approval process. So that, for example, a company like Neuralink cannot just do what they want to do, but they need to first pass an access to market approval process, which is examining if the product they want to present to the market is not attacking humanity, it's not attacking the planet, it's in respect with human rights. And if that's not the case, it shouldn't be even possible to present that product on the market. Something which is absolutely normal in other industries. Think about the pharmaceutical industry. Novartis, Roche would never be able to just present a medical drug on the market and sit at home and hope that no one will die from that drug. No, they need to first run through an access to market approval process. That would be the first key function of IDA. Second, to monitor if new technologies are used to violate human rights, and if that's the case, then to intervene. And third, to foster global technical collaboration in order to enable us that we can achieve faster together the ethically positive potential in the field of neurotechnologies. You see the website indicated, there is a button, Join IDA. That's definitely not a charity event, but rather if you want to join IDA, it's just that you support ideally this initiative, an initiative which is supported also by UN Secretary General Antonio Guterres, which is also supported by Sam Altman, the founder of OpenAI and CEO of OpenAI. It's also was supported by Pope Francis. It is supported by His Holiness the Dalai Lama, and a fastly growing international and interdisciplinary network of experts and also, companies who are supporting this initiative in order to create a sustainable future for all of us, for humanity, and for the planet. I thank you so much for your attention. I'm very much looking forward to our conversation now. Thank you.
Thank you, Peter, for your very insightful presentation. I ask all the participants who would like to ask questions to put them in the chat, but except for the member of the editorial board that can ask directly questions. So I have just a question, then I leave the floor to Takis Vidalis because I've seen he raised the hand. The question is just, you talked about neurotechnologies with ethics, which I, of course, agree. I agree with the majority of the things that you said. But the question is, how far or how near are we to this goal? So from really an empirical viewpoint, what's going on in that sense? Thank you.
Well, thank you so much for your question, Sylvia. I mean, it's hard to respond with 100% certainty what's really going on. But at the moment, I don't have the impression that new technologies advancement is very much informed by ethics so far. I think there is a very impressive, discourse in ethics about new technologies. And we also see first guidelines and recommendations coming up. But I would, to put it positively, I would love to see that discourse first intensify, and secondly, what of course then needs to happen is also that it has impact in the field of new technologies, and that part is definitely missing. So I still have the impression, but please correct me if you see that differently. I perceive it that everything which is possible is done in the field of new technologies, no matter what, and at whatever cost. And that's always, if you look back in history of humanity, it's always a dangerous situation if that's recurring. If it's just like everything which is technically possible is just striven for, is just try to be, try to be achieved. And I think we have a very clear idea that innovation per se is not ethically positive. We can imagine several, innovations which are ethically negative. So we need to step up and understand that even if we are able to do certain things in the field of new technologies, that we still have to make this choice. What out of this technical puzzle we really need to achieve, and that should be, ethically informed in a sense of, the scientific discipline of ethics should inform that. It shouldn't be just like a gut feeling or, someone might fear in general technological process. We're not talking about fears here. We're talking about, rational arguments, rational justification of why something is ethically positive and why something is ethically negative. And if something is ethically negative, we should leave our hands from it.
Thank you. Thank you very much. So now Takis Vidalis has raised his hand. Please, Takis.
Yeah, actually, Sylvia, it was not just it was for uploading this wonderful keynote speech, but thanks a lot, Peter. But with this opportunity, a very brief question, if you allow me, Tade, to Peter. So my question is whether IDA has teeth, as you mentioned, example of nuclear energy. Does it have the power to impose sanctions on those violating human rights? And from now on, Sylvia will shut up and leave the floor to the younger scholars, rather young participants. Thanks a lot.
Well, thank you so much, Takis, for your question. Indeed, IDA would have these teeth. So the idea is exactly that we build IDA in a way so that IDA can enforce, can sanction, because if that's not the case, and you're probably, you're probably familiar with, UN discussions, and if you build a beautiful expert group, exchanging arguments and nothing is happening. So IDA would definitely go down another road. And that's exactly the idea. And that's also exactly what the Secretary General of the UN wants. He says, well, we have enough bodies of, beautiful exchange of expertise. But then at the ground, in the research institutes, in the companies, they still proceed as, all these, discourses are not taking place. And therefore, it is important to build IDA exactly in that way and following the model of the International Atomic Energy Agency, where we were able to build that. And I think it's helpful to remember that, and that from nowadays perspective, it's hardly impossible to imagine that. But when the first ideas came up to build an International Atomic Energy Agency, there was massive opposition by the industrialized states and by the private sector. They really presented the argument that every one of us should enjoy the use of nuclear technologies. And we should leave it to the individual self-responsibility what we're going to do with this nuclear technology. Can you imagine from nowadays perspective? And so what I'm trying to say here is also in the field now of new technologies, I think we need to make this step up to say, okay, that's something maybe we shouldn't just put in the hands of everyone, and there needs to be some kind of global regulation, and that global regulation needs to be firmly enforced also because if we enforce regulation very strictly and very precisely, that can be also a source of innovation and of technological progress, because then everyone knows what the rules are and can move within this space. What we have now right now, everyone is moving, but no one knows what exactly is allowed and not allowed, and you just try out, but you're not sure. And that's, of course, not really helpful for an efficient free market economy. Thank you.
Tade Spranger, please.
Yeah, just a short remark. Peter, first of all, thank you so much for your excellent talk. Just really enjoyed that. I just wanted to say, of course, as a lawyer, I love the idea of, following that human rights-based ethics approach. And I just wanted to add maybe an additional argument in favor of your point of view. I think it's always good to use law as some sort of, backup. Yeah. So, when you try to implement ethics standards in the world of politics, it's always a good idea to have some, legal arguments at least, as some sort of additional argument at hand. And I think this is another advantage that really speaks for your approach. And I just wanted to add that. And once again, thank you so much for this.
Well, thank you so much for your so kind feedback and also for this additional thought. That's definitely very helpful, and I will take note of that. Thank you so much, Dan.
Thank you. I don't know if Douglas sees some other questions in the chat or someone who would like to speak directly for a last question. No? So thank you very much, Peter, for being with us today, and really very, very nice and insightful talk. Thank you very much. So I now leave the floor to Ismini Kriari, that I thank a lot again because she rearranged her schedule in the program. Ismini Kriari is a professor at the Pantheon University in Greece. She was and is a member of the UNESCO panel that drafted the recommendation on neurosciences. So she will talk about this recommendation and the process of decision making that was made there. Thank you very much, Ismini, and the floor is yours.
Buongiorno, grazie per essere invitata a questa conferenza in questa università. Thank you very much for being invited to your university. It's a great honor and a great pleasure for me to be here. Actually, I was not a member of the panel that drafted this neuroscience proposal, but I was invited as member of the Greek Bioethics Committee to be one of the persons who attended it and could make their remarks. So this recommendation has already a 2 years history, and it is not finished. It is not actually accepted by the General Assembly, but it is very interesting to see how it deals with that new field, so promising, and also a field that challenges our way of thinking and our way of addressing scientific progress. The recommendation begins already at the preamble, stating that neurotechnology can offer innovative solutions for better preventive, predictive, diagnostic, therapeutic, or rehabilitative purposes, benefiting humanity as a whole and providing opportunities for health promotion in all countries. And also it says that the application of neurotechnology raises ethical, legal, and societal issues and questions related to human dignity and human rights, And it might have medical and non-medical use, and it might be used for treatment, and also it might be used for enhancement. I think it is one of the positive points of this document that it gives a very good definition of what is the nervous system, central and the peripheral nervous system, and also because it defines what it is neurotechnology, devices, system, and procedures encompassing hardware and software, but directly measure, access, monitor, analyze, predict, or modulate the nervous system to understand, influence, restore, or anticipate the structure, activity, and function. And also the medical and non-medical applications. And the way that it operates, it analyzes physical, chemical, and biological signals associated with the structure of and functional signals from the nervous system. So I think that these definitions are very useful because it gives us a way to begin talking in a rather, I would say, in a very rational and practical way, how to advance our discussion, because there we have the main definitions, and what is new is how they define neural data. Neural data include qualitative and quantitative data about the structure, activity, and function of the nervous system, gathered through neurotechnology and defined in this recommendation. And neural data is not only that, but they are data which might be obtained by biometric data. They call them indirect neural data. So you have neural data which are data about the structure, activity, etc. of the nervous system, and biometric data which are called indirect neural data, and also non-neural data allowing mental states inferences, because there are data which are not neural and not biometric, but they might have a role in allowing mental state inferences. So they are treated in the same way. And the new definition also is the whole life cycle. They speak of neurotechnologies of their whole life cycle, which means they should be considered from the early stage, starting with its conception, design, algorithm development, decision logic, mining and obtaining raw material for materials, research, prototyping, design and development to deployment and use, including maintenance, operation, trade, financing, monitoring, evaluation, validation, disposal, and recycling. So when they say many places in this document, the whole life cycle of neurotechnologies, they mean from the point that somebody begins to think of a neurotechnology, how he or she proceeds, how they think of why and how they think of proposing that neurotechnology, what are the means, what is the team, how they go on, and how they make the experiments or the trials, and how they come to the final stage to have a product, and then how they go on in recycling in the end and disposing. I think that this is very important because it shows that when we talk of neurotechnologies, we have a continuum. We don't have the product, the final product, but we have a continuum. We begin with an idea about a new neurotechnological device, and we end up with the way that we have to dispose it. Then the recommendations says that what are the aims and objectives, which are, of course, the protection, respect, and promotion of human rights and fundamental freedoms in this field, and also the protection of present and future generations, and to define what are the ethical principles which should govern that domain. And it begins with what is actually the same in all the recommendations of UNESCO, values and principles. And it differentiates between values, which are actually heading towards laws and measures, and they are the founding pedestal on which you have the principles. Of course, these two notions sometimes intertwine. You cannot differentiate what is a value and what is a principle, because they say it is a value to have, for instance, respecting diversity and fairness, which includes actually the principle not to stigmatize and not to discriminate, and then we have the principle of non-discrimination and non-stigmatization, but this is not of great practical importance. The importance is that with values and principles, you have the ideas that are already enshrined in human rights catalogs, and in ethics catalogs, and in the bioethical Convention of Oviedo, in the declarations of UNESCO. You have all of these ideas which have been developed mainly after the Second World War. And first of all, it is the importance of human dignity, which comes from Kant, and which means that a person should be treated as an end and not as a means. So human dignity is the first and the most important principle value that is actually here enshrined. And then you have the promotion of health and well-being, ensuring the respecting diversity and fairness, cross-cultural perspectives on human knowledge and its sharing, because as UNESCO is an international organization, this is always in its documents that you have to think that we're not living in an island. You have to think about populations in other continents, in other social conditions, in other ways of government. So you have to share what you have as knowledge about neurotechnology also with these populations, in order not to augment the social divide and the scientific divide that is already existed. You have to think about global solidarity, international cooperation, and sustainability. And then you have integrity and responsibility. And as for the principles, they go on with beneficence, proportionality, do not harm, autonomy again, and freedom of thought. And you have to think about indigenous people, because this is also a thing that is in all UNESCO's document, but you have to think about the rights of indigenous peoples and their sensitivities and the way they think about certain aspects of technology which are not familiar to us, but they mean a lot to them. And then to have the protection of neural data, as well as indirect neural data and non-neural data along the mental states inference, non-discrimination and inclusivity, and accountability, trustworthiness, transparency, and epistemic justice. And in the end come the best interest of the child, protection of future generation. I must say that as far as the best interest of the child is concerned, UNICEF has actually published 2 months ago in July a very important document about the childhood and the protection of children and adolescents till the age of 18 in front of neurosciences. It's a very good document, and it is actually, I think, the best. Here you have only some very scarce ideas, but that document of UNICEF is really the best with regard to childhood and adolescence. What actually I found not very convincing is the fact that UNESCO does not hint the idea of introducing new rights. Although there is a long discussion about it, and although there is the pioneer work of Ianca and Adorno about the introducing of new rights in order to cope with the threats that are actually facing the human being with regard to neurosciences, UNESCO does not address that issue. Apparently, they believe that it is a bit premature to consider the drafting of a new right, to introduce a new right, and they think that it would be better to expand the focus of the protection of other rights, the right to integrity, to human life, to personal and psychological integrity, the right, the protection of privacy. Of course, they talk about the neural data and the protection of neural data, but they don't put it in the frame of neuro rights. They don't consider it a new neuro right. They say that neural data should be protected. They should be processed in a certain way. There should be measurements in order to find the best way, in order not to insult the person concerned, in order not to take information that the person does not is given his or her consent. But they do not talk about new rights, which is actually a bit, I think I had waited more, because there is a lot of discussion some years now about mental privacy, the personal neuro data that should not be sold and stored without consent, about personal identity, that the neural technology should not alter mental integrity and individual sense of self, but free will in that regard should be also safeguarded, the decision-making control without manipulation via neurotechnology, but there should be a fair access to mental augmentation, but cognitive enhancement neurotechnology should be accessible to everyone, foreseen, and if we can accept that they will be secure, and there should be protection from bias. All of them perhaps would be a flood of new rights, and they should be not desired or necessary, but at least mental privacy, I think that, and personal identity with regard to neurotechnology, I think that these two rights should be at least hinted. Of course, we should not forget that actually the manipulation of the human brain is not something new. Let me give you two examples, one from literature and one from history. From literature, everybody knows the drama of Othello, the innocent man who happens to have beside him a non-innocent man, Iago. And Iago begins by talking to install in Othello's mind, step by step, hour by hour, the seeds of mistrust towards his young wife. And so in the end, Othello is convinced that his wife has cheated on him and he kills her. So no neurotechnology was used, but only the ideas of another person and the words of another person. And this is actually a master plan, how you can manipulate one's mind. And this happened years ago, and Shakespeare put it in that wonderful drama, wonderful in the way that it depicts how you can manipulate one's brain. And the other example comes from history. After Klemperer's diaries were published, we know La Lingua Terti Imperii, the language of the Third Reich. We know how Hitler and his entourage managed to change the mentality and the way of thinking of the whole people by distorting the use of words. I am not going to flood you with the 500 words that they used, but only with two. Let's say the word fanatical, which in every language has a negative connotation. You say you are fanatical and you mean that you believe too much and without prior thinking in this or that idea. But in the frame of the Third Reich, fanatical began to be used in quite another way. It began to be used that it is heroic not to have scruples. It is actually heroic not to have intimidation, not to think too much. It is heroic, and it's something that you should do, not to wait in order to see if your actions have this or that result. So fanatical began to be used as a very positive quality of the human being. We are fanatics, which means we have the central quality, good quality of a human being. And the other word is the word people, das Volk. What is people? The people who live in a country, the people who have the right to vote. No, it's not that. It's the people who can claim that their ancestors come from the old German tribes, that they belong in the old German myths. They are das Volk. All the others, they are not das Volk. So it does not play any role if how we behave towards them. Das Volk, es ist uns. It is only the people who can claim that they have German relations. So I mean, it's not so important to. We should not overestimate the importance of the possibility of brain manipulation, because brain manipulation can happen without any technology. What is important, however, is that by neurotechnology, you can manipulate the structure of the brain. You can insert into the brain, and there you don't have the ideas, simply you have capitalism, because it is these great firms who work in ways that nobody knows, and which produce products that nobody knows why they produce them. That's why they have put in this declaration the whole cycle, which means that it has to be transparent how you think to develop something in order to come to the final result. So I think this is the main problem, and I think that for this reason, one should think of the introduction of the right to mental privacy and to personal identity. And actually, there are countries where that step has been taken. We know that in Chile, there is a bill that has been already presented to the parliament about that issue, and also in Chile. And what is more important, there is a decision of a Chilean Court of Justice where a man has brought the following case. He had a headset which could write down the waves of his brain, and he went to the court claiming that his data had been actually given for a research program without his permission, and he won the case. So to speak in the legal way about these rights is not so far from reality. I suppose that the drafters considered it to be premature to talk about that, but I'm not so sure that it is so premature, and that we should wait to see how we would actually understand all these issues. Of course, I can understand that it is a matter of interpretation, how we understand what is where are the boundaries between thought and manifestation, where is the line between legitimate influence and manipulation, can risky thoughts ever be used to predict risky behavior, what can be considered as consent for an interference in the forum internum in the context of neurosciences. I can understand that all these are questions that have to be answered, but in my opinion, I think that in this regard, it should be better if the declaration at least made a hint towards the direction to introduce a new generation of rights in that context. And then, of course, there are areas of policy action where there should be the government, what should the government do? And then come the whole arsenal of the UNESCO proposals, which is that there should be oversight organizations, there should be public debate, there should be monitoring instruments, that all of these new possibilities should be scrutinized in the best and in a holistic way. And as far as the justice system is concerned, then there should not be any possibility to compel somebody to justify against themselves or to confess guilt. And any use of neurotechnology in judicial proceedings should have strong and robust oversight mechanisms, including strong data protection, privacy, consent, and the freedom of thought protection. So there also neurotechnology shall not be used for any kind of social control, also something that the states should have the responsibility to address. And then the UNESCO proposes that they should themselves actually draft some instruments in order to have a human rights impact assessment in that film with regard to neurotechnology, economic and social impact assessment, benefit risk assessment, policy privacy impact assessment, and ethical assessment, so that by means of these instruments to come, they will be able to see how neurotechnology can be harnessed, if it can be harnessed at all, in a societal way. And then there are data policy procedures, which are almost the same as all the other data policy procedures, also with concern to genetics, and the issues that are about education, about labor market, and about commerce, which are very, very important, because the commercial use of neurotechnology is something which will be a threat perhaps in the near future, because if there are benign possibilities, then everybody should have access to them, and this is far from real, because we know that there is already the gap between the countries with wealth and the countries, less developed countries and poor countries. So I think that no matter what the good intentions of UNESCO are, it will be a very difficult process. But anyway, one should hope that we will have in the future a better division of the technology, and that also people who are not in position now to prosper and to take advantage of its possibilities will have that in the future. I think it's a document that is worth reading and studying. I think it is a document that addresses many of the issues that are inherent in that realm. I was surprised also to see that for enhancement, there's only one paragraph. I am surprised because enhancement is one of the dangerous parts of neurotechnology. Everybody thinks, what if per enhancement via neurotechnology, you have another division of people. As of now, you have people that are born rich and people that are born poor, and the poor perhaps might try to get rich. But if you have enhancement, then you have people who are born rich and have the possibility to get richer, and people who are born poor and who cannot use that possibility. And nobody knows how, via enhancement, this possibility will be used after all. So the use of neurotechnology to improve mental or physical traits through controlled procedures, they might also happen only with regulatory frameworks and with respect to equality, consent, individual and community autonomy, societal impact. All these things are very good as ideas, and what comes next is only one phrase: member states should encourage research regarding the potential risks and significant ethical implication of such use of neurotechnology, both for individuals as well as society as a whole. I think that this is too little for enhancement. I would have expected something more. Enhancement is a possibility that no one knows where it might bring us, and perhaps it should be dealt with, if not in this document, not in another document, if not in this organization, then in another organization. Thank you very much.
Thank you very much, Ismini, for this very precise reconstruction of this document, which is a very important document. The majority of us knows it, or I assume everybody knows it. And it was very helpful also listening to your other critical interventions. I have 3 questions. I started to break the ice with my questions, and then we see if there are other questions in the chat or from our colleagues. What you think, because the document talks a lot about, of course, the obligations of the states. Okay, so what the states have to do in relation to this neurotechnological development. But do you think that these obligations have to be posed just on the states or also on those private actors that are so powerful and that maintain actually the development, the production, and the market of this technology? The second question would be how feasible are these recommendations from your side when it comes to states implementation? And the other one is there is a part dedicated, as you mentioned, to enhancement, but the impression is that it is short or not so expanded. In comparison to the use that is possible in that field already at present. So is there a reason for that? So you were involved, and is there a reason for that? Thank you.
Thank you very much. As to the first, you are right. Of course, the problems do not, the regulations should not address only the state. They should address also the private actors, because it is the private actors which are now working in that field, which produce constantly new devices, new ideas. They bring new, and in conjunction with artificial intelligence, they bring new waves of treating not only problems but also of new ways of information, new ways also in the field of recreation, in the field of sports, in the field of arts. They flood us with new products. And of course, it is them who have to be made cautious, and they have to be made responsible. I think that this is something that will come perhaps with another document, and I think that it might come also from the European Union, because as we get there, the AI Act, which regulates the issues of artificial intelligence, I am almost sure that they will have to regulate that too in a way that it will be mandatory, because the recommendations of UNESCO, as you know, it's soft law. It gives a direction, and the direction they give mainly is in the form of educating public, conducting public dialogue, and trying to create a consensus. And this is very important, because there is not only a literacy gap, but also a neurotechnology gap. There is a gap in the understanding of all of these new technologies. So that they stress all these things, especially the dialogue. I think it is very important, but it's not enough, of course, because it's not only the dialogue is good to understand an issue, but in order to convince a firm, which a billion firm, which is sited so many kilometers away, public dialogue in Greece does not help to convince people in Silicon Valley to do this or that. I think that you should have another kind of reaction in the United Nations, perhaps in a mandatory, in a document that mandates and not only recommends. Perhaps that would be the possibility. And as for the third issue, the issue of enhancement, I think that they tried to debate on medical and non-medical and interventions, and that was the focal point. The enhancement is another issue. It's a much more demanding issue, I think, and this is the way that they wanted to close a subject, to present a document that at least addresses some of the issues, and leave it for a later discussion only with that short paragraph. I think that that was the idea. Because if you begin talking about enhancement, then you need the whole document about it. You cannot put it in 2 or 3 articles. So they just made the hint. Another professor wrote to me, but it disappeared from my screen. Can you please read it?
Yes, now we check what are the different questions. Perhaps are there questions from our colleagues, from the members of the editorial board as before, or can we switch? Douglas, do you find the question that is in the chat?
Yes, Francesco asked, you argued that for the introduction of the right to mental privacy and personal identity, in your opinion, which is the best way to introduce such rights? Through introducing a completely new right, or to the reinterpretation of already existing instruments?
Well, in my opinion, it is better to introduce a new right, because if you put it in the interpretative umbrella of existing instruments, then you have to see how the whole literature in the field has actually worked, and what might be the pros and cons. And there you cannot be sure that this right addresses also these new realities. Of course, there is also the other argument that the American nation lives with a constitution which is 250 years old, and they have survived. They have changed the interpretation from one century to another, and so this could be a way. But in our countries, I think in Europe at least, I think that it would be better if we have a new right, which new right should focus on that, and there, even in a pedagogical sense, you can direct the interest of the public in that new possibility, in that new threat, in that new necessity. If you decide, if you wait till a case comes to the courts, and this case have to be solved, and then you have to look for a right to interpret it. So I think that it's not the same. But if you put it, if you begin by arguing about it, if you bring it to the parliament, if you bring it in the constitution, then you just direct the interest of the public to that new problem. And I think that this is also essential. Thank you.
Thank you. Are there other questions? What do you think about public engagement? So is it mentioned in some way directly or indirectly in this in the recommendation? And
yes, it
how
is
could it, yeah.
Yes, it is mentioned because public engagement should be the main thing. But what do we mean under public engagement? Because the first thing in order to engage the public is to educate the public. Otherwise, they will not be engaged. And now we live in a period where to play with all of these devices for a child of 15, 16-year-old is considered something that he's born with. You have to educate them that it's not so innocent as it seems, that it might not be so innocent in the future, that they have to think of the collateral results. And I think that after they have been educated, then you can imagine that they might build circles, societies, they might read the documents and deposit them and submit them to the parliament. You have to educate them first and then to see how they might react. In different countries, there are many institutions, there are the consensus conferences, there are some other ways, there are the referendums, there are some other ways to mobilize the general public and to talk to them and to see what are their reactions and how they decide on them. It is known that in Switzerland there are the referendums which are an everyday practice and where everybody gets information and feels obliged to read that information and then decide on these issues. But Switzerland is actually one country and a unique country. In the other countries, we don't have so widespread possibilities to influence the public debate, but only by means of societies, of manifestations, of rallies, of the submission of documents, only this way.
Yes, thank you. Thank you very much. So I don't know if there aren't any other questions. I think we can have 10 minutes break before starting the next section that is scheduled in about 10-15 minutes. So we will make sure that everybody for that session is there. So we meet again in about 10 minutes or so. Okay, thank you very much.
Thank you very much.
Thank you much. Thank you.
Bye-bye.
So, welcome back. I see Roberto Andorno is there. Before I've seen also Marta, and I don't know if Gina is there. Ellen Webster is there. I see her. And Miranda Wang was also there. Hello. We had a slight change in the program, as I mentioned to Roberto. So Elisaveta Murajeva is not going to take part. I don't know if Laura Slocca is already present or not. But we can perhaps begin and then see if she joins before the end of the talks. As I said at the beginning, my work here is just to ensure the transition from one session to the other, but then the work is from the moderator side and the participants, discussants, and speakers that I thank a lot for accepting the invitation. So I just introduced Roberto, otherwise nobody would do that. Roberto Andorno, although I think he doesn't need any presentation because he is well known. Roberto Andorno is professor at the University of Zurich. He has participated in many high-level expert groups on neurotechnology. He actually was one of the person who initiated the debate on neuro rights. So thank you very much, Roberto, for joining us, and the floor is yours.
Thank you, Silvia. Good morning, everyone. I'm very pleased to moderate this session on neuro rights. So we'll have 3 presentations and 2 comments by 2 discussants. So I will briefly introduce the speakers, all of the speakers. Just a few words about the structure of this session, which will last 1.5 hours until 12:15. So my task is to try to keep track of the time. Each of the speakers will have approximately 15 minutes. We have a little flexibility because we have one speaker less than the initially planned. To introduce the speakers, first the three presenters. We have Helen Webster, who I can see she's connected already, and she's very courageous because in the US it's very early now. So thank you for your effort. I think it's around 4 in the morning, something like that. Okay, so Helen will talk about reconceptualizing neuro rights as fundamental aspects of human nature in order to better understand eventual rights. She's a doctor of law. She's doing a PhD. Please correct me if I'm wrong. She's doing a PhD at the University of St. Louis University, Department of Healthcare Ethics in Missouri, US. She's a lawyer, and she's also teaching at the St. Louis University in the fields of neuroethics and healthcare ethics. The second speaker is Miranda Wang. I'm not sure she's already there.
Yes, she is. She should be.
Yeah. Now I see. Sorry. Miranda is a researcher at Durham University in England. Her doctoral research is on the ethical and legal implications of neurotechnology in clinical context, with a particular focus on emerging neuro rights frameworks. She's she has a Bachelor of Laws degrees, and she's she's in the field originally in the field of criminology, and she serves on the postgraduate student council of the Institute of Medical Ethics. Her broader research interests include female offending and the ethical governance of AI in medicine and healthcare. And finally, the third speaker is Laura Zwoska. I check on the internet how to pronounce her name because it's not so easy. She's from Poland, Wrocław, Poland. She's a Master of Law and PhD candidate at the Faculty of Law of the University of Wrocław, Poland. She's a lawyer. She specializes in personal data protection, medical law, technology law, international information security standards. She also serves as a data protection officer for a company in the gaming industry, and she's preparing a doctoral dissertation on neurotechnology and the right to privacy. The title of her presentation is "Do we need an EU Neurotechnology Act?" And I forgot to mention the title of Miranda's presentation, which is Interdependent Rights for Independent Minds, Conceptual Overlaps in Neuro Rights. So I remind remind you that you have approximately 15 minutes for your presentations, and after that, the two discussants will make their comments, and in the end, I think we'll have a few minutes for questions and discussions from all the participants. So please, Helen.
Thank you so much. I appreciate the introduction, and I will share my slides. Okay. Let's see. Okay, thank you very much. I am Helen. I'm happy to be here. Thank you for having me, and I'm excited to share some ideas regarding neuro rights. These are some initial thoughts I have that will hopefully become my dissertation for my PhD program, but still in the initial stages of that. So I'm curious what you all think. What I'm interested in talking about today is kind of some of the conceptual work that I would like to do to add to the neuro rights conversation. Largely where the neuro rights movement, as we all know, is kind of happening is in defining the several different types of neuro rights, defining risks and invasions to the human person that we're concerned about and how those relate to rights, how neuro rights will interact with each other. Do we need new rights? Do we need to expand existing rights? Human right at the human and at various levels of state, national, international, government, or human rights at the international level. There still seem to be several different formulations of neuro rights in the literature. Some people think we should have one right to cognitive liberty that encapsulates mental integrity and mental privacy. Some think perhaps there are these large three buckets: mental integrity, mental privacy, and cognitive liberty. Others think that in addition to those three, there are also the right to, maybe we frame it differently, like cognitive liberty is a right to free will, or the right to mental augmentation, or the right to be free from algorithmic bias. So there's a lot of different formulations of rights that still exist. And we're talking a lot about the rights themselves, and that's where the conversation has begun. And there has been a lot of conceptual work too, but there is obvious natural connection between neurotechnology and concerns about neurotechnology and human rights. And so that's where we sort of started. And I'm interested in going backwards and understanding more conceptual understandings of what we're trying to protect to make the eventual protections, which may be rights and other ways to protect, more right-sized, more to ensure they aren't under or over protective. And I'm going to give an example of why we need to do that. But again, I do want to mention there is some, the literature is sort of trying to delineate what the rights are, how many rights there are, where does one right end, another begins, which is all helpful. And but I think the more conceptual work can help understand some of that. So here's why this is important. Joseph Fins is an American bioethicist who wrote a critique of the Chilean mental integrity constitutional provision. And the reason he's concerned about the way mental integrity was written, and let me just make sure I have the time down, is because Fins works with patients who are in a minimally conscious states. They may have had a brain injury, so they're not conscious, but they can engage in some movements. They can move their limbs and respond to some stimuli, more so than patients in persistent vegetative states. Because the Chilean mental integrity provision is concerned with the negative right to mental integrity, ensuring people do not interfere with mental integrity, Fins is worried that his patients can't take advantage of a positive right to mental integrity. What if he wants to use brain technology to probe their brains to allow low levels of consciousness to be detected? If if we care about mental integrity and a right to it, we also care about that positive right to mental integrity, which differs from the negative right. You could similarly think about it, and I'll get into this, but in some human rights documents, there's the question of whether mental integrity includes an individual's right to mental health. And there's the same sort of idea of someone with depression maybe does not feel as though they can engage with others in the world in the way they could without their depression. So perhaps they have a positive right to their medication to enable the mental integrity to do the things they usually do. So by conceptualizing mental integrity solely in terms of the risks and invasions, we're very worried about the risks and invasions. We've forgotten about what do we have a right to? Do I have a right to mental integrity, not just to be free from invasion? So all aspects of mental integrity need to be, and this last statement is a little strong. It's not necessarily the case, but there are different aspects to mental integrity that are beyond just risks and invasions that would make for a right that can account for the positive aspects. Basically, we need a mechanism to recognize the good uses of neurotechnology that we want. We know of using BCI for people with locked-in syndrome or ALS, and those are important uses too. So I think that there are some conceptual gaps in some of these rights. And because we're so focused on the rights part, the protections, we're going to miss some places where we can protect or enable. I think we might want to enable too, not just protect. And so that means we need to go back a little bit or continue on the conceptualization of what are we protecting? What about the human do we care about? We care about enabling and protecting. So my goal today is to introduce you to some conceptual ideas that how to slightly reframe the conversation in order to lead to more robust neural protections in the future. And that includes not only defining rights by the invasions and risks that we're worried about, but also continuing to outline the conceptual basis of these rights. Okay. So I'm focusing on the first part today. So we sort of conflate in the conversation interests, risks, invasions, rights, human rights. I really, in my dissertation, want to tease these apart and really clearly understand what we're trying to protect, where one right starts, one right ends, so that we know how to do that protection, because how to eventually formulate rights that are right size for what we're trying to do. Part two is something I'm really interested in. I'm not going to talk about today, but I think is certainly something I want to talk about in my dissertation. The type of right, there are different types of rights. Human right, and we know this, human rights are a type of right where we sort of talk, we're sort of still in a conceptual stage where we're talking about the states of affairs that we want to bring about, or the states of affairs we don't want to bring about. And there's room in human rights language to sort of describe what we're interested in. But operational legal rights, directing people to act, is a different type of right. So what happens when you have a conceptual, more human right sort of language that you try to operationalize, you're going to miss certain settings, such as like the Finns' critique of the mental integrity. I think that neurorights is still sort of in this conceptual rights language. And so it's really hard to operationalize that kind of language because we haven't considered every single situation that may come up, which you can't really do until, sometimes until cases are taken by courts or otherwise. So anyway, I think part of the problem too is it's hard to operationalize generalized language, although human rights sort of have so there's sort of different goals with like human rights language versus operational language. So I have sort of thoughts on that and I'm curious what people think, but that's not totally what I'm going to focus on today. I'm really interested in teasing apart a lot of these ideas and being really clear on what is a human interest that we want to protect, what are the risks and invasions to that interest that we're concerned about? And then what are possible protections or operationalizing? But I find that we've started with the operationalizing, and that's great. And when you need sort of movement and like attention to a movement, it's important to talk about rights. And I think in parallel, I hope to do some work where I'm going back and sort of understanding what we're doing and why we're doing it. Because I think that'll make more robust rights or protections that aren't rights, which could be just as could achieve our goals just as well. So my talk is actually pretty it's sort of initial and basic about what are we trying to protect when we talk about these rights. So let's see. When we talk about a right, so I think I'm sort of putting together just these three categories: mental integrity, cognitive liberty, mental privacy. And I think they're each distinct, though there is overlap, and it sort of sometimes when these butt up against each other, you think about which wins out. I think cognitive liberty probably because of the like my cognitive liberty over another right that butting up against it, but I'm not really getting into that here. So instead of thinking of these first as rights, I want to think of these categories first as interests of the human person. And each of these are a different step of cognition, sort of, that we're concerned about. So mental integrity, I want to rethink of as a precursor to cognitive activity. And a lot of this is from the literature too, but the literature seems to jump straight to rights, which makes it hard to see underneath what we're trying to protect, and also sometimes frames rights as like, it's the right to be free from this invasion. But I'm trying to get rid of that language first and really stick to the human person. What are the interests we're concerned about? My sense is that mental integrity is the precursor to cognitive activity. Not really, kind of a substrate. I think precursor is the word that makes more sense. Neurons can fire. I have brain waves working. I have conditions for consciousness. It's like this initial state. And there are positive and negative aspects to that, as Finn's pointed out. I want to be free from someone interfering with that precursor state of my mind. But can I also somehow have access to enable those capabilities or capacity for cognitive activity? Then cognitive liberty, once I have this precursor, I am able to think, and I'll get into this. I can think, I can change my mind, I can learn, I can have a couple different thoughts in my mind, but I act on one of them. And that's my free will and self-determination. That's the actual activity that's going on in my mind. And that's what makes up sort of my agency. And I'll get into this too. Then mental integrity is an output of cognitive. I think what we mean by a right to mental privacy is I have an output of cognitive activity in terms of my thoughts and mental states that, because of my unique humanness, that is just uniquely private, just because of our minds are inside our heads, and I don't share something unless I say it. So that's the interest of the human person that we're interested in with human privacy. So I'm trying to change these. So I'm trying to think of the rights in terms of human interests, and really trying to outline all the interests related to each of these categories, and then thinking of risks and invasions to them, or how we want to enable each of these. Then think about how to protect these interests. And I forget, I haven't looked at some of this literature since about the spring, but I know there are some calls in the literature for some more conceptual work, and so I'm hoping that this is something I can add to the conversation, in parallel with the sort of lobbying for the rights and doing the work that we need to do to get the rights on people's minds. So I'm just going to briefly go through each of these categories, and I'm trying to to get at precisely what each one is in the terms of interest instead of before examples help, but some of the examples will come in later in my paper in the risks and invasions part. So teasing apart these interests, mental integrity sometimes is conceptualized just in terms of sort of the risk to it, but I want to think about what is it really? It seems to be the structure that enables brain activity that eventually occurs. A precursor, sort of a preservation of neural processes and brain waves. There must be like perhaps a mental versus a neural integrity, my mind, brain, the extent that those are kind of the same, there might be the physical structure versus the mental health aspect to things. Psychological continuity is often in the conversation too. So these are all interests related to my mental integrity. And I find mental integrity for me to be a little trickier to define in terms of interests. So I'm trying to not yet talk about the risks and invasions to really get at this is what's important to humans is the capacity for eventual brain activity, and that's why it's important. Cognitive liberty, I see as the activity of the brain, distinct from integrity and distinct from privacy. Thinking, updating your own thoughts. There's conscious and unconscious thoughts. I should perhaps, I don't know all of the thoughts that I'm having. Taking in information and sifting through it, choosing which actions to take, choosing which thoughts to act upon. These sort of make up self-determination, free will, agency, as is talked about in the literature. But I think thinking of cognitive liberty as the protection of the activity in my mind, more so than like a final thing that I say or a final sort of output that we see in mental privacy. And I think the idea of privacy is the capability of keeping the final output of my cognitive activity from cognitive liberty private, because that's how things have naturally worked prior to our internal worlds being accessed by neurotechnology more so. We're usually in control of the output, and that's what we want to maintain, because choosing the output of our cognitive activity also defines and contributes to our personality and identity. So that might be my time. This is pretty, early work and sort of basic on this, but I really am interested in kind of expanding the conceptual work in neurorights to make for better, more right-sized protections and rights, and to address Finn's critique. Because I don't think it's a problem with rights, but I do think it's a indication that there's more to think about in terms of not just positive and negative aspects of a right, but all the human interests that we're interested in addressing with these rights. So thank you, and I really hope and look forward to comments and questions. Thank you.
Thank you very much, Helen. It was a very rich and, for me at least, a very original presentation. I never heard this view on mental integrity, and I like it very much.
Thank you.
Thank you also for emphasizing the importance of positive rights. It's true that neuro rights were developed more thinking of negative rights, to be free from certain threats. At the same time, I would say positive rights, neuro rights could be problematic in some areas in the field of therapeutic. When the purpose is therapeutic, is generally accepted that you have a positive right, etc. But if you think of enhancement, neural enhancement, that's in my opinion is more problematic to recognize a positive right to get enhance your cognitive capacity, etc.
Yeah.
But thank you very much. This is really very useful, very helpful. I will follow your. Are you publishing now on this, or?
I am submitting my paper through this.
Excellent.
Through this conference. Yeah, thank you.
Excellent, excellent. Thank you very much.
Thank you.
I think we'll leave the questions for at the end of the session. So after the discussants make their own comments. So we'll move to the second speaker, which is Miranda Wang. Miranda, please.
Thank you. Let me just quickly share my screen. Okay. And are we seeing the screen? Yes, okay, thank you. Hello, everyone. My name is Miranda, and I'm a PhD candidate at Durham University. The title of my presentation today is Interdependent Rights for Independent Minds, Conceptual Overlaps in Neurorights. My talk today has 3 parts. So I'll begin with a brief introduction to what neurorights are. Then I'll set out my thesis, which is neurorights are not isolated protections, but are inherently interlinked. I'll focus on how these rights overlap and how violations in one area often trigger cascading effects in others. Finally, I'll summarize why recognizing this interlinked nature is crucial, especially for law and policy. So, neurorights, we've already touched on this many times since the conference started, but just very briefly, they are proposed fundamental rights designed to protect the brain and mind from unwanted intrusion or control. So in 2017, Yoste and colleagues highlighted key ethical priorities for emerging neurotechnologies, including mental privacy, personal identity, free will, and equitable access, arguing that these require new human rights protections. That same year, Ayenkan and Dono formally proposed 4 specific neuro rights: cognitive liberty, mental privacy, mental integrity, and psychological continuity. And these ideas quickly moved beyond academia into policy sphere, with Chile led the way in 2021, amending its constitution to recognize protections for mental integrity and brain data. Since then, other Latin American countries, especially in recent years, have made their own neuro rights bills, including Argentina, Brazil, Colombia, Mexico, as well as the Latin American Parliament, Palentino. While international bodies such as the Council of Europe and UNESCO, as we've already talked about, have opened global discussions on this topic. So, because neuro rights are proposed as 4 or 5, if you're counting the Neuro Rights Foundation, as like 4 distinct rights, much of the scholarship tend to treat them in isolation, so defining and justifying each one separately or discussing them in turn. Likewise, legislative proposals often set them out as standalone clauses. And my argument is that this approach misses something important. I think neuro rights are not discrete silos, but conceptually entangled and practically interdependent. Each one presupposes and reinforces aspects of the others. So to genuinely safeguard the mental sphere, analysis and policy need to acknowledge these overlaps, because in practice, a threat to one neuro right almost always implicates others. So first, let's talk about cognitive liberty and mental privacy, which I think represents 2 sides of mental autonomy. Cognitive liberty is the freedom to think, to make choices about one's own brain and mental sphere, and mental privacy is the right to keep those thoughts or brain data shielded from unconsented outside scrutiny. And their overlap is, I think before talking about overlaps, I need to introduce the Hawthorne effect, which is a very well-documented psychological phenomenon that tells us being observed changes how people behave. Even subtle cues of surveillance can make people act less freely. Now, if we transpose that into the realm of thought, if someone knows or even suspects that their thoughts are being monitored, they may start to self-censor. They might avoid certain ideas altogether, fearing they might be detected or judged. So the mere possibility of mental surveillance undermines the liberty to think authentically, because being observed creates this pressure to conform. So I think the right to mental privacy is an essential correlate of cognitive liberty. Without a private mental space, true freedom of thought cannot exist. Next, mental privacy and mental integrity are two facets of mental inviolability. Both concern unwanted interference with the mind. Privacy deals with unauthorized access, while integrity concerns unauthorized alteration or harm. And access is often the first step towards interference. Still, I think it's important to clarify this relationship, because there is debate over whether privacy and integrity are truly distinct rights or just one combined concept. So Lavazza and Giorgi in their 2023 paper argue that privacy and mental integrity constitute one concept and one right. So they suggest that making an individual's inner thoughts public, which is a privacy violation, is equivalent to harming that person, undermining their identity, autonomy, and value. In other words, they contend that any breach of mental privacy simultaneously damages mental integrity, because it exposes the mind to external influence and judgment. While this reasoning highlights the close connection between privacy and integrity, I think the two should still be distinguished, because a violation of mental integrity does not always follow from a privacy violation, and vice versa. Say an individual consents to a procedure designed to treat PTSD by targeting a very traumatic memory. Now here, because the person consented, access to that part of the mind was authorized, so there's no mental privacy violation. But if the procedure goes wrong and inadvertently alters the person's, say, emotional regulation or personality, causing harm, then their mental integrity has been compromised. And in this scenario, the harm arises not from unauthorized access, but from unintended alteration. And conversely, breaching mental privacy does not always produce an immediate integrity harm. It depends on what is done with that access to information. So I think the most productive way to view the relationship between the two is to see privacy and integrity as distinct yet interdependent. They are distinct because each protects a different interest. Privacy safeguards the undisclosed contents of the mind, while integrity protects the unimpaired functioning of that mind. Yet they're still interdependent, they still overlap, because in practice, serious violations of one almost always implicate the other. Sorry. Okay. So the relationship between mental integrity and psychological continuity is perhaps the most straightforward. So psychological continuity can be understood as a subset of mental integrity, specifically concerned with preserving personal identity. If mental integrity is about preventing harm or interference in the mental sphere, then psychological continuity focuses on that particular kind of harm, the disruption of identity or the coherence of one's personality over time. In other words, continuity addresses the most profound violation of integrity, the one that alters who you are. So we might think of continuity as nested with integrity. Every violation of psychological continuity is a violation of integrity, but not every violation of integrity rises to the level of threatening continuity. So having looked at the overlaps, I think it's quite clear that each of the 4 neural rights addresses a different dimension of mental protection. So cognitive liberty is for freedom of decision. Mental privacy is freedom from observation. Mental integrity is free from interference, and psychological continuity is the preservation of self. They still have their own specific focus, but they all converge on the same underlying aim, which is safeguarding the inviolability of the mind in the age of neurotechnology. And I think this unity is why infringing on one neural right often endangers the others. They reinforce each other conceptually. So cognitive liberty underpins the rest as a necessary condition. Mental privacy creates the space needed for that liberty and also mental integrity. And mental integrity ensures the stability needed for continuity. And psychological continuity secures the core self that can exercise that cognitive liberty. So each right informs and reinforces the others, and taken together, they function as interdependent guarantees for independent minds. And I think recognizing this unity has real impact for theory, law, and policy. So theoretically, it shifts the frame from siloed entitlement.
I'll send you something.
Okay.
To
I might have already sent it.
should I continue?
One.
Good. Okay. So theoretically, it shifts the frame from siloed entitlements to a unified architecture, clarifying that liberty depends on privacy, integrity, and continuity, all as co-conditions. And I think legally it cautions against piecemeal drafting and points towards a more integrated provisions, ones that treat neural access, processing, modulation as a single regulated event. And this approach, I think, closes gaps that arise where privacy only or integrity only rules or remedies are applied to compound intrusions. The impact, I think, is clearer duties and enforcement for neurotech companies, developers, and institutional oversight, fewer loopholes for bad actors, and stronger prevention of cascading harms where a breach of one neural right threatens the rest, all in service of protecting our mind in the age of neurotechnology. Okay. Yeah, that's all. Thank you.
Thank you very much, Miranda. I really enjoyed your talk. It's very illuminating about this relationship between neural rights, because they were developed more as, you're right, as separate notions, but it's true that they are very much connected, interdependent, and there are some potential overlaps between them. So I really like your talk, and this is an approach that still needs to be developed. So that's very, very valuable what you said.
Thank you.
I ask you the same question that I asked to Helen. Are you planning to publish on this?
Yes. So this is I'm drafting this.
Okay, very good. Very well. Very well. Excellent. So now we can move to the third speaker, if she's there. Laura. Ah, yeah, I see her. Very well. The floor is yours, Laura.
Can you see my screen?
Yeah, yes.
Perfect. I'm so sorry. I don't know what's happened here. Just 1 second. Thank you very much for an invitation, and I would like to talk about EU Neurotechnology Act, and I would like to answer the question: do we need an EU Neurotechnology Act? And right now, I will maybe use the answer that lawyers like the most. So it depends. It depends from the moment when we want to look at this act. And first of all, I would like to talk about the problem of definition, because right now, basically, we don't know what neurotechnology is because it's not regulated in any law. So here is some kind of definition that I use and I like because it's very broad and it covers a lot of types of neurotechnology. However, I think if we talk about rights and neuro rights and neurotechnology in the context of law, we should develop some kind of legal definition of that word. It will help us, and also we have to somehow look at the terms that we have already in the existing law, and a lot of neurotechnology will be covered by medical devices regulation. So the regulation on medical devices is applied to medical devices for human uses and accessories for such devices, and it also is pointed here that it's not only medical but also non-medical purpose covered by this regulation. And of course, a lot of neurotechnology that will be used for medical purposes will fall under this regulation and under medical law. So this area, we can say that it's somehow covered. However, we should remember that the definition of medical devices applies to software, implants, appliances that can be used by human beings, but just for the specific medical purposes. So not all uses of neurotechnology, for example, if we use neurotechnology for entertainment or for authorization and so on, it will not fall under the definition of medical devices, probably. Of course, it depends, because if we have a very advanced brain-computer brain interfaces that can be used for entertainment also, but also for some kind of diagnosis or monitoring some diseases, it will fall under this regulation also. So here we have some kind of definition for some types of neurotechnology that can be used in a European Union law. If we don't have medical devices, we still have some regulations that cover the area of neurotechnology. And of course, it will be General Data Protection Regulation, which also applies to data collected by medical devices. However, here we have another problem with definition, I would say, because of course in GDPR we have a very good definition of personal data, very broad definition, because GDPR says that personal data is any information that can be somehow linked to a natural person. So if any information can be somehow linked to a concrete person, it will be a personal data, even if we will link that information not directly. So that gives us a huge area for personal data processing covered by European Union law. However, here we have a problem, maybe something to discuss, because we have neurodata that can be divided into brain data and mental information. And those informations basically in most cases will be personal data. However, not always, because if we will end with anonymization, we will have some brain data that are not linked to a natural person, but they will still give us a lot of information about how our brain works. And if we have some processed data that will be a mental information, basically in most cases they will be personal data, however not always. And maybe the problem of brain data and mental information versus personal data is not so difficult. However, if we will ask if neurodata are special categories of data, here we have, I would say, an area to discuss, because not all brain data and mental information can be as special categories of personal data. I mean, brain data basically can be classified as a health data, because they will tell us how our brain works, and that's more obvious. But if we process those brain data, and from those processed data, we will get some information about the person. For example, information like where they live, or when they have their birthday, or some data about their bank account. Those informations are not special categories of personal data, so they are not covered by the general prohibition of their processing. Of course, general data protection regulation gives us some situations that when we can process some special categories of personal data. And if we talk about neurotechnology, basically it will be to protect the vital interest or explicit consent. And that consent is a bit tricky, I would say, if we talk about neurodata and neurotechnology, because as we know, a lot of companies will try to somehow give our customers something in exchange for their brain data to process and to gain some information about our decision-making process, for example, and that can be very useful in marketing area. So here we have a lot of problems with that consent that can be somehow maybe not very obtained from aware people, and somehow it can be even bought, I would say, by the companies. So if we talk about the neurodata, we should remember about those two definitions that are already covered by GDPR, because there was some ideas to add some definition of neurodata to GDPR, and I think we should at the first step think about the terms that we already have here, and some neurodata will be covered by biometric data, and most of them will be covered by data concerning health. But still, we have some cases when we will not have a specific definition for those neurodata on the ground of GDPR. And I tried to find some cases when GDPR can be applied, or when GDPR is not applied. And first case is it's obvious, because if we can anyhow link information from those neurodata with a natural person, of course GDPR will apply. But there is another, I think, interesting case, because if we acquire some brain data today and then we use machine learning technology, we can have in the future some new information about the person. And here we have a problem of applying GDPR, because at the moment of acquiring those data, we will not be able to, for example, inform the person about the categories of data that we will process. But after, for example, 6 months or 2 years, we will be able to decode more information about that person. And in that moment, we will have to be compliant with GDPR once again. So basically, it's a context privacy concept. So if we have some changes and if we have another information about the person, we will need to for example, send another information obligation. So we will have to somehow update our privacy policy and so on. And there is a third case that, in my opinion, is very dangerous to our society, I would say. It's not to a specific person, but to our society. Because if we will be able to remove from our database any information that allows us to identify a specific person, then we will have a huge database with information about how people react, how we make our decisions, and it's about our behavior. And this information is very, very useful and valuable for many companies, and companies in most cases are not ethical. So they just think about how to make money and how to do it quickly and how to make more money. And they will not think about all those things. So maybe there is a potential to regulate the use of data after anonymization, because in the perspective of GDPR, if we anonymize those data, and if we really anonymize those data, and we will not be able to reverse that process, we will not have to be compliant with GDPR with those data anymore. So then we have another regulation that I would like quickly just to mention. It's Artificial Intelligence Act. It's really good. It's really good act if we would like to think about Neurotechnology Act, because it was created in a way that can be transferred, I would say, to neurotechnology area, because artificial intelligence started developing, and then we had some kind of moments when it was a really fast process, and then EU started to working on this act, and it was some kind of reaction to everything what was going on the market. And I think it's a good idea for neurotechnology, because right now we don't have all information to regulate it properly. But I think if we will look at that technology, we will have an opportunity to regulate it properly, as with AI. So if we talk about neurotechnology, of course, we will have some kind of AI systems, some kind of AI that can be used to process some neurodata. So in most cases, AI Act will apply, and that's I think a good idea, because we have some prohibited AI practices, and I think it's really important that our EU legislator prohibited using some techniques beyond a person's consciousness or any type of manipulation. And also it is prohibited to use some vulnerabilities of a natural person or a specific group of persons due to their age. So here we have, for example, children or disabilities, and this area is very important to neurotechnology that will be used for people with some diseases, some disabilities, because they are very, they can be the aim of different attackers. And then we have, just 1 second, because... And then we have another, in my opinion, interesting regulation in European Union, and it's quite a new one because it's European Health Data Space Regulation. However, it aims to facilitate access and resource cross-border sharing of health data, including neurodata for healthcare provision and for research, innovation, and policy making. It will not cover everything. So here we have some rules for cross-border sharing of neurodata that can help in developing neurotechnology, but of course it doesn't solve our problems with neurotechnology. So I would like to come back to my question. So do we need a Neurotechnology Act? I would say yes, we will need Neurotechnology Act. It's not something that should be regulated really quickly right now because we already have some regulations that covers neurotechnology and using of neurotechnologies, basically in the area of medical law. So if we use invasive BCIs, we have some protections that arise from medical law. If we use it in different areas, we have GDPR, we have AI Act and other regulations, but still we have some areas to regulate. And I was thinking about those areas, and I just have some few remarks on that. And first of all, I would like to see in that act some definitions about definitions of neurotechnology and neurodata, because we need to know what neurotechnology exactly is in the view of making a law and then applying a law. And then I think we should deal somehow with risks that are associated with the use of neurotechnology. So we should not only assess the risk, but also have some plan for those risks. And all companies that are using neurotechnology should be able to show how they did their risk assessment process. Then we have this very difficult topic of rights of users of neurotechnology, because it's an international debate how to regulate it properly. And of course, we have some ideas from, for example, Chile and USA and other countries. However, I would like to say that a law in Chile and the approach to privacy in Chile is a bit different than here in European Union, because they started working on that neurotechnology law when they did not have any regulations similar to our GDPR. So they were in a different, I would say, stage of this process for taking care of privacy of people. They are doing a great job because they are talking about this neuro rights, and they are regulating that rights in a really good way for their legal systems. However, in our European Union system, I think we should first of all compare our rights already existing with the ideas of neuro rights. And also, I think it can be considered to appoint a neuro rights officer, something like data protection officer. So the person that can be able to give some inputs and to give some advices to the people in the company responsible for creating this neurotechnology and using it. And also there is an area, in my opinion, to regulate the reuse of neurodata. So if we want to use data obtained from neurotechnology in another purpose, and of course for that we have GDPR, but also I think it can be regulated a bit differently than right now. So just not only the consent for another purpose, but maybe here we should regulate it somehow differently. And I think the problem of consent here is huge, because we have really private information here, and basically, if we will use consent, it's very difficult to assess if the person was aware of everything, and if the person was really willing to give their privacy, or they were maybe somehow or maybe they just get something in exchange. And then I would like to consider some restrictions on a type of neurotechnology for practical uses. I think that using of very invasive BCIs for entertainment purposes is not a good idea. But I don't know if it should be in a law. I think it's something that should be discussed. And also, we should have some rules to ensure appropriate updates and parts if a company will stop producing their neurotechnology. Basically, it's very important for those invasive BCIs, because those people will have a huge problem with their already put it on their brain parts. And then I think we should have some authority in each member state that will somehow check if everything is okay, I would say, with this neurotechnology in different companies. And also civil and criminal liability. It is already covered by many different laws, but I think sometimes it should be regulated a bit differently, and maybe we should have some information here, some rules for example, obtaining evidence from the neurotechnology producers. And also, it is very useful if our EU legislator would give us some direct information how to use an existing normative acts when it comes to neurotechnology. And also, I think there is some kind of area for integrating the purposes of neurodata processing. I mean here, if we have some neurodata, some brain data, some mental information about one specific person, I think it is really good to define how this kind of data can be processed in connection with another database about the same person. And of course, there is an area for another rules in this Neurotechnology Act, but I think it's some kind of point that we can start working with. And so yes, thank you very much for your attention. And as I said in the beginning, I think we need an EU Neurotechnology Act, but not today, but maybe in a few years. So right now we should start working on that.
Thank you. Thank you very much, Laura. Also for this overview of these different regulations, which are very difficult to understand. I'm not an expert on GDPR and EU Act, but to combine them, to understand them, and to know whether they are, or to what extent they are applicable to neural data is not an easy task. So thank you for your effort with this, and for your suggestion that we will need, at least in the future, specific EU regulation on neurotechnologies. So I assume that you think just by way of amendments to the existing regulations, it's not possible to cover these new challenges. Is that your view?
Yes, I would say that we need something new, because amending a lot of acts will be very difficult, and I think there is still some area that will not fit in any act, already existing act.
Okay, thank you very much. I think we need to move now to the two discussants. I will briefly introduce them because I didn't do it at the beginning, although I think most of you know them. Marta Sosa Navarro comes originally from Spain. She did her doctoral thesis at the University Carlos III from Madrid, international law, and she's currently a researcher in international law at the University Milano Bicocca. And she has published a lot on topics related to neurotechnologies, human rights, artificial intelligence. Gina Gotze is Greek. She studied law in Athens, and then she and in Paris, and she did her doctoral dissertation in Lausanne, Switzerland, on criminal law and neurotechnology. She was also a researcher in Lausanne. I had the opportunity to organize with her some maybe 10 years ago, so a workshop in Geneva on these topics before the discussion on neuro rights started. But we discussed.
It must have been in 2013.
13.
Yeah.
Okay, so 12 years. Exactly.
12.
Early or 12. Yeah. Okay. Okay. So we discussed about the ethical and legal implications of neurotechnology. So I'm happy to see you again. And she was also a member of the Greek National Bioethics, or she worked for the National Bioethics Commission in Greece. Is that right?
I did my internship as a young researcher there.
Okay, research. Okay, thank you. Well, the floor is yours. I don't know who wants to start. Marta? Or...
Yes, thank you very much, Roberta, for the introduction, and thank you the three for the three excellent and thought-provoking presentations. I really have a lot of questions, but I'm gonna try to focus and just concentrate on asking one question each so that we can keep the debate going. So first of all, I'm gonna start with Helen, and maybe I can just present my questions and then you can answer afterwards, so I can just, if that's okay, if that works.
Mm-hmm.
Okay, so congratulations for an excellent presentation. I have a question regarding your critique to the absence of the positive rights perspective in general within the neuro rights debate. And I am wondering whether you have considered, this is just something that I'm just curious to know since you have gone so deeply into the topic, whether you have considered exploring the introduction of this positive right perspective using the right to science. On one side, like I have two questions that I have been thinking while I was listening to you. The right to science, so the right to enjoy the benefits from scientific progress for general, so for all individuals, and also from the perspective of the rights of people with disabilities. Whether these two kind of boxes or these two kind of frameworks could somehow enable the introduction of the positive rights perspective in your reasoning. So that's my question to you. I don't know if you want to take turns and answering, or I'll just give my three questions and then you can answer if that's okay. Then for Miranda, I also appreciate very much your
your acknowledgement of this, the complexity of the discussion and of this entanglement, this connection between the rights, because this is something that is not always obvious, and it gives a lot of problems when you come to operationalize the rights. This non-recognition of how mental integrity implies also challenges for mental privacy. And so this is super interesting. I think it reflects very well the reality of how these rights work and what these rights could potentially be protecting. But I am wondering whether you have thought about the practical side to this reasoning. So how do you think these thoughts that you have so very clearly articulated could be reflected in the law, in the human rights law specifically? I know it's a very, very difficult question, but since you have looked at it from a theoretical perspective, I'm just wondering whether you have thoughts in this respect. And then I have a question for Laura. Well, I really liked your proposal, the courageous and the brave decision to propose a model law in this sense, and the way you have like kind of broken already down the parts that should be included in this law. From your list, which I imagine that you will develop more thoroughly in your article, I am wondering whether you're going to give particular attention to consent in terms of whether you're going to consider the differences, and how are you thinking of articulating the differences of what consent means depending on where technology is used, because there are giving consent in a workplace scenario or in a education scenario where there is an imbalance of power is not the same thing as giving it in a completely free environment. So I was wondering if you have had considered this, and this is like the beauty of this kind of discussions. I noticed that you don't incorporate the positive rights perspective that the first speaker, Helen, insisted a lot on in your model. I was wondering whether this is something that you're thinking of doing, whether you have purposely left it outside, because I just noticed that you from the positive right perspective, you just refer to the rights regarding the explantation, or the possibility of having pieces outdated and how this has to be granted, but not the positive framework that was presented in the first speech. So these are my three questions. Thank you, and congratulations for excellent presentations. Really, really inspiring.
Thank you, Marta. I can go first, and I really appreciate your question. And I hadn't thought of this right to enjoy science, or the rights of people with disabilities to enjoy science. So I really appreciate bringing that up, and I'm going to look into that. But yeah, the positive rights, I agree, is difficult. At least in the US, most of our rights are not positive. It's easier to enact negative rights. So even though, yeah, I talk a lot about like enabling and not just freedom from. And in some ways I bring it up to talk to understand like the concepts of each of these interests. And I'm not sure about once rights are operationalized about the positive aspect, besides like perhaps more in a a therapeutic setting. So, so I bring up a lot, I almost bring it up more to think broadly about what we're interested in. And but I agree there are challenges to the actual implementation of positive rights, although I'm interested in these things that you brought up, so I can sort of understand how like work from there or something. But yeah, I am still sort of also unsure about the operationalizing positive rights, although I think Finn's brings up, the positive aspect of mental integrity. And that sort of got me thinking about just like, if we say a right to something, doesn't that have these other aspects? But I almost haven't gotten quite yet to the, like that's part of the conceptualizing, but I don't know how that works into the actual operationalizing. So I appreciate the comments about positive rights, but I hadn't thought about the right to science and that stuff. So I need to do more work on like existing conversations around certain positive rights. Thank you.
Okay. Thank you for the question. And yes, you're right that what I was presenting is more a on the conceptual or theoretical level. And I think when it is reflected in the law, I'm not really advocating for not having separate clause and just proposing one right in general, because as I said, I think even though they are interdependent, they are still distinct rights, and we should recognize their specific focus. Just like with international human rights law, we could just propose the right to human dignity and leave it at that. But we need that specific focus, and I think the value of conceptualizing it that way in law could be more reflected in the application of it. When you have a case in front of you, you don't just, okay, so this part is about mental privacy, this part is about access, this part is about interference, this part is about integrity. This conceptualization helps viewing an event as a single regulated event rather than fragmenting each, and that have implications for legal remedies and what rules can be applied in that specific case. And when you recognize that like cascading harms, their interrelated nature, you have a broader ground for legal remedies. And when you're assessing a case, it's a more holistic protection and application of relevant legal rules. Yeah, I think that's my thought on that.
Tina, I think now's your turn.
Okay. Thank you very much, Roberto, for the presentation. I appreciate it. Many thanks to the organizers for this very interesting conference, which is consists of very different levels of analysis of this discussion concerning neurotechnologies. It's really, really valuable. And of course, to our speakers for their insightful contributions. I won't have very specific questions rather than comments or very general points. I think that this session, this introductory session, is crucial because it sets the conceptual stage for the entire conference and for any work on neuro rights. When we speak of neuro rights, what exactly do we mean, and how should law, how should ethics respond? Are we dealing with genuinely new rights? The classical question remains vital for me, or with the reinterpretation of long-standing protections under new technological conditions. We heard three very stimulating and diverse contributions, which illuminate the central philosophical and legal questions, as I see it, raised by the emergence of neurotechnologies. These three papers, and that's particularly valuable in my opinion, together illuminate this discussion from three different perspectives, complementary perspectives: conceptual clarification, theoretical grounding, and of course, at the end, the regulatory design. Helen focused on the conceptual, Miranda on the theoretical and the conceptual as well, and Laura on the regulation. And taken together, they offer a layered approach, pictures of what is at stake when we speak of neuro rights, and they raise important questions of how we should think of them in both theory and practice. Let me start with Ellen Webster's contribution. First of all, I would like to point out that she identifies a genuine gap in the literature, the need for more rigorous conceptual work on what neuro rights are actually trying to protect. And I congratulate her for this I encourage you to go on with the research because it's really valuable. If I'm not mistaken, you reconceptualize neuro rights as fundamental aspects of human nature, it says, talk about mental integrity, mental privacy, and cognitive liberty. This is a valuable reminder that before we rush to legal protection, we must first understand the very concepts we claim to protect. Some general points that not concern only exclusively Ellen's presentation, but when we talk about the free will or personal identity, I am not sure that this could be protected under the framework of a new right. Free will and psychological continuity, in terms like that. I come from philosophy of law, so I might be influenced by this, but there are conceptions of, for example, the psychological continuity is a specific metaphysical conception of personal identity. We're far from having a consensus there, and actually we're on different levels. We're talking about the philosophical level, and then we actually have to translate in a sort of way this discussion into policy. So we should be careful. I'm not saying that the philosophical discussion is not valuable. On the contrary, it is very valuable, and it should precede any policy making. It's the precondition of policy making, discussion, and also philosophical insights, contributions. But we should be really careful when trying to translate, allow me the expression, from having philosophical jargon to legal protection. It sort of relates to, I think, Marta Navarro's question to Miranda of how does it translate to law. Helen mentioned that the risks are important and the invasions are important. I think, as simple as it might look, that it's very important to define the risks of the new neurotechnologies. And this calls for a really interdisciplinary dialogue with actual scientists. Sometimes I feel, and I might be a bit provoking there, but I feel like the push, the narrative to introduce new rights is a bit urged by a sudden urgency of based in some technology that is not yet founded. So I would like your comments on that. I really appreciated the distinction between mental integrity, cognitive liberty, and mental privacy. I would like to know more. I'm looking forward to reading your paper. And I found extremely interesting the rights talk and the operational legal rights distinction that you made. I'm not sure I quite got it, but still I'm looking forward to your paper in order to, I was wondering if you have a philosophy of language theoretical basis for that. So very nice. Thank you very much for this useful presentation, and I'm sure it will lead to some very interesting results. Miranda's work, so the focus shifts from defining the content of each neuro right to understanding their interconnections, their internal connections, and that's also very valuable. Miranda critiques the isolated, siloed approach that treats every neuro right differently, as separate and discrete. And instead, she argues that these rights are interdependent and must be seen holistically. And this is an important insight, because indeed, in practice, violations rarely occur in isolation. A breach of mental privacy can simultaneously threaten cognitive liberty, and it can undermine mental integrity. Miranda Wang shows that the unifying aim of neuro rights is to preserve, maybe I'm taking it, I'm imposing my own interpretation, but I will do it a bit provokingly, to preserve the autonomy of an individual's mental life. But here we might raise a question still. If all neuro rights share a common aim, perhaps what we are really protecting is a single value, autonomy, let's say. If that is the case, do we really need an entire new family of rights? Or can autonomy remain the good old traditional concept of autonomy remain the organizing principle. So this holistic view reinforces for sure the need for conceptual clarity, because understanding the overlaps allows us to see that all neurorights share a common goal. But does that reduce the case for creating distinct new rights, or does it strengthen the case for a unified systematic framework? So what about the holistic argument? What about this? Could be read in two directions, either as strengthening the case for a new bundle of rights, or as evidence that new rights should be integrated within existing broader human rights. And that might be an important tension that needs to be resolved. And finally, and I will finish with that. I'll try to be brief for the sake of the conversation. Laura Sloka's paper brings us to the regulatory level. Very rich presentation. As Roberto Andorno pointed out, it requires a lot of work and a competence to go through the AI Act, the GDPR, and see which provisions are relative to the neurotechnology data. So also looking forward to reading your paper. The ambitious proposal for a comprehensive EU Neurotechnology Act. What I find interesting in the same line of thought is that the distinction between the need for regulation and the need for new rights. If we accept, and that's the path that I think Laura chose, if we accept that current legislation is not adequate, that does not necessarily entail that we must enshrine neuro rights as a distinct category of fundamental rights. And regulation and rights creation is not the same move, and perhaps the challenge is to clarify where one ends and the other begins. So these comments, very general comments, hoping to initiate the debate or bring about reactions. Thank you very much again for your presentations. Very valuable.
Thank you, Gina. We have only 2 minutes until the beginning of the next session, so I'm afraid we will not have much time. You will need to organize another conference only with these speakers, Silvia and Marta. So I don't know, maybe just one very quick question to one of the speakers and one quick answer. Who would like to?
We have a question.
There's a question in the chat from Francesco Stocchi. A question for Laura Swolska. When you say that we need a definition of neurotechnology, do you mean a definition produced by the European institutions? What is your opinion on the definition that has been used by UNESCO?
Yes, I was thinking about the definition that will be produced by European Union legislation, because I am focusing on our EU law. So I think here we have a neurotechnology that sometimes fall under the medical devices regulation, and sometimes it's just some kind of product. So it's some kind of product that is offered to customers. And I think it's a bit more than a product, if it's not a medical device, of course. And that's the reason why I was thinking about the new definition, but of course it should be in this Neurotechnology Act, because if we will go with amending already existing acts, what is, in my opinion, very difficult, and it will not be possible, but we will see. We will not maybe need this definition, because we will somehow adjust already existing different definitions. But if we will go with the idea of new Neurotechnology Act, I think this will be a crucial part of this act to define what will be covered by this regulation.
Thank you, Laura. And just to conclude this session, thanks a lot to the 3 speakers for their really illuminating presentations. And we close this session with this. Thank you.
Thank you.
Thank you very much. Thank you to everybody. So we now go to the second session. I'm not so sure how many, if everybody is present, just to see whether the moderator is there, Professor Fernando Llano Alonso. I don't know if he already connected.
Yes, I can see him here.
Okay.
Yes.
Okay.
Good morning. I'm here.
Good morning. Okay. And so we have the moderator. So I just ensure this transition between one session and the other. And I introduce you because otherwise there would be nobody introducing you. So I'm very happy that you accepted to moderate this session. I know you have to leave after. I will substitute you when you leave. So no problem about that. Professor Fernando Llano Alonso from the University of Sevilla, Spain. He is full professor in that university, and he is an expert of philosophical reflection, legal philosophical reflection on technological development, and I'm very happy that he could participate. Thank you, Llano. The floor is yours.
Thank you, Professor Salardi. I would like to thank Professor Salardi for giving me the opportunity to moderate this panel entitled Ethical Challenges of Neurotechnology in Vulnerable Cases, Autonomy, Disability, and Prediction. That said, it is my pleasure to introduce the discussants, Professors Philipp Kellmeyer, University of Mannheim, Germany, and my friend and colleague, José Antonio Seoane, University of La Coruña, Spain, distinguished and admired colleagues who are specialists, as you well know, in bioethics and biolaw, and who will speak to us today about the ethical challenges of neurotechnology in vulnerable cases. I would like to thank Professor Salardi, who will be, as she said, be replacing me at 1 p.m. Next, we will listen after Professors Kellmeyer and Seoane. We will listen carefully to the presentation by the doctors who follows to the discussants. Doctors Beatrice Piccolo, Tamani Fukushi, Hitoshi Shimada, Nobuyuki Shirakawa, and Carlos Daniel Granados Domínguez, and last but not least, Giordana Truscelli. Well, the floor is yours. We are listening to you very carefully. Thank you very much. Professors Kellmeyer and Seoane, you have the floor. Thank you.
Sorry, thanks, Professor Llano, my dear friend Fernando. But I think we should wait for the presentations of the papers, because it would be more interesting that the four colleagues present your papers, and then Professor Kellmeyer and me could comment everything. But you made the final decision, of course.
Mm-hmm. That makes sense. Yeah.
Yes, they are attending us, perhaps.
Yeah. So you can introduce, if you want, Beatrice Piccolo as the first speaker. Yeah.
Yes.
Hi, good morning, everyone. Can you hear me? Okay. So just 1 second, I share my presentation. Okay. Can you see it?
Yes.
Yes.
Okay, perfect. Thank you. So good morning, everyone, and thank you in advance for listening. My name is Beatrice Piccolo, and today I will present my work on the topic of self-determination and the availability of neurocognitive self. This work addresses the intersection of law, neuroethics, and human rights, focusing in particular on the fragility of consent in vulnerable contexts and the urgent need to rethink our legal categories when the mind itself becomes the object of intervention. So let me begin with a provocation. Where does genuine autonomy end and institutional, legal, or social pressure begin? More radically, what happens when the mind itself becomes the object of intervention? This is not simply a philosophical question. It is the legal and ethical challenge posed by neurotechnologies nowadays. So traditionally, medicine has been conceived as a science aimed at curing. Yet the development of neurotechnologies, from brain stimulation to neuromonitoring devices, shifts the boundaries between therapy and enhancement. In healthcare and in prison systems, this creates a particular tension. Individuals who are already vulnerable are placed into a situation where their autonomy and can be limited or distorted. Here, the core issue is consent. So can a person in a psychiatric institution or a prisoner hoping for parole truly express an informed and free choice? Or is that consent always structured at risk of being flawed? So this is why I'm talking about neuroconsent. Neuroconsent is not just informed consent as we already know it. It is a specific model adapted to neurotechnological interventions. It requires not only adequate information, but also guarantees that the individual retains intentionality, freedom of choice, and mental integrity. It is a way to fill a normative gap, ensuring that decisions are not conditioned by institutional pressure, clinical dependency, or manipulation of cognitive processes. In this sense, neuroconsent does not merely act as a safeguard. It is also a functional procedural tool to prevent flawed or vitiated consent, and in the most risky contexts, such as healthcare and penitentiary institutions, for example. On that point, I would like to consider the case of chemical castration. We already know that in several European countries or states, it is used with sex offenders, sometimes as a condition for parole or sentence reduction. So my doubt here is this one. If the choice is framed as undergo treatment or remain in prison, can we really talk about free will? Is it even possible according to human rights? That is not just a reflection on what we could do to prevent this kind of crimes. That is about how it is, what is lawful or unlawful in our legal systems, according to the principle of human dignity. This case demonstrates how fragile consent becomes when individuals are placed in coercive settings, how it's easy to deceive individuals. What appears is that voluntary medical choice may be a hidden form of punishment. Also, we can also call it neuropunishment, where the line between therapy and coercion collapses. So this debate, of course, leads us to neuro rights. I don't want to deepen too much on the matter, but just say a few things that could be useful. In this case, on one hand, they offer stronger protection for autonomy, self-determination, and privacy. On the other, some argue they risk inflating the catalog of rights. But in practice, traditional frameworks such as privacy are often inadequate. The complexity of neurotechnologies shows the limits of whole categories. This is why some scholars propose a reinforced version of consent and an explicit recognition of cognitive liberty as a right and more. So the goal would be to try to adapt these categories that we already have right now and transform them into something that could be a better protection, including the possibility to recognize the mind as an asset, as an autonomous asset. That leads us to the theory, of course, of bundle of rights, not a single new right, but a cluster that updates existing protections. This shows the need to adapt rather than simply repeat what we already have, especially at a procedural level, when neurotechnologies can be used to obtain evidence. Here I would like to spend a few words on the concept of self-determination and the principle of self-determination and the protection of the body that I think is very important to outline. Self-determination means freedom of expression, protection of the most intimate sphere, and free choices in relational life. The principle evolved through the centuries, and his influence growth was fundamental to ensure many of our rights nowadays. We have an absolute respect for the inviolability and untouchability of the body. The body is a legally protected asset, but is the same for the mind, not yet, at least in Italy. Indeed, there is no mental protection that corresponds to the principle of bodily self-determination or the acts of disposal of the body. Here I would like to expand the concept of habeas cogitationem, literally meaning you should have the thought. It is conceived as a prerogative action aimed at contesting illicit neurotechnological interferences with a person's mental processes, and whether they come from public authorities or private actors. So, like habeas corpus, habeas cogitationem would function as a procedural right with a negative sense, compelling others to refrain from invading the mental domain. Its role would be to act as a procedural level, not considering a new substantive right, but enforcing existing neuro rights in urgent situation. It will be governed by already existing principles, allowing quick access to protection without new formalities. So, habeas cogitationem safeguards freedom of thought, understood as a cognitive liberty, mental self-determination, and free will. It would apply to other neuro rights except for fair access to enhancement. Plus, it targets direct interferences in thought processes, such as those produced by neurotechnologies, and it applies both to private actors like states, police, judges, and to private actors, corporations, lawyers, or individuals. So briefly, habeas cogitationem provides a rapid and effective response to violation of the mental sphere, ensuring the freedom of thought is not just theoretical, but enforceable. Okay. At this point, we must also consider the procedural tools that we already have and that are emerging in both healthcare and penal contexts. For example, implicit association test and autonomous resonance test aim to measure implicit attitudes and responses, raising concerns about voluntariness and accuracy. Or another kind of tool like brain fingerprinting techniques claim to detect recognition of information in the brain. These tools are sometimes suggested for criminal trials or risk assessment, but they raise question about reliability and, of course, about violations of mental privacy. There is no a specific discipline regarding their use in Italy, at least, as they are a kind of new entry in our legal system. That's one of our problems. In legal systems, such as the Italian one, they are classified as atypical evidence, which means evidence not directly foreseen by the law. Due to that, they are raising constitutional concerns. So the core issue is again autonomy. Forcing someone to undergo this test may be considered as an intrusion into the mental domain. Thus, habeas cogitationem could work as a possible solution, could become the legal filter determining where these technologies cross the line into unconstitutional or unlawful interference. And my last words are about balance and about the role of the judge. That could be central. It has to ensure that any neurointervention respects fundamental rights and that consent is genuine and not the product of coercion or dependency. And in this way, the judge becomes the guardian of cognitive liberty, just as courts once became guardian of physical liberty through habeas corpus. So I want to conclude with these bullet points, and I want to summarize this with a key question I leave you with. That is, are we truly protecting freedom of thought in the age of neurotechnology, or are we relying on outdated legal tools that cannot keep peace? So I ended my presentation. Thank you for your attention. And it was my first work on the topic, so any advice or information are welcome.
Fernando, are you there? Fernando? I don't know if you can hear us. In any case, I take the lead in this moment of transition, and I would like to introduce the second speaker, Tamami Fukushi. That she is a professor in Japan. I had the pleasure to meet her in many occasions. So she is going to talk about screening the silent ethical dilemmas of predictive amyloid PET in Japan. Please, the floor is yours.
Okay, thank you, Sylvia, and thank you, Chad. Can you hear me and see my slide?
Yes, it's perfect.
Okay, so then I will start my talk. Okay, thank you again. And it is my great honor to be involved in this conference. And thank you very much for your kind invitation to Professor Sylvia Salardi and all of the conference organizers. I, Tamami Fukushi, experienced the neurophysiology research using monkey to investigate the cognitive and motor function in my graduate and postdoc days, and shifted my career to the neuroethics in its early days of the academic establishment. So by the way, this building is my current workplace in the Shinjuku, Tokyo. So if you have a chance to visit Japan, please stop by. So today, based on the theme of the session 2, I will introduce the case study regarding the Alzheimer's disease with ethical dilemmas in Japan. And this is the table of contents of our manuscript. And I will introduce our study along with this. So let's start the first part. The name of the Alzheimer's disease is quite famous, and simply we can imagine the condition of the patient in a cognitive context, I think. But it is a typical multifactorial polygenic disease, and its neurobiological nature is very, very complicated. Since the bookmaking report by the Alois Alzheimer in the early 20th century, scientific approach has been advanced, and nowadays in 2020s, biomarker and early detection research and development are key elements for developing preventive and therapeutic technology to overcome this disease. One important thing we need to mention is that the onset of the Alzheimer's disease does not mean the onset of the dementia per se. Alzheimer's disease itself is just one of the causing diseases of the dementia, caused by the long-term accumulation of the age-related structures such as amyloid beta protein and the reduction of the volume of the brain structures. Then it takes for a while, like a couple of years, from the onset of the Alzheimer's disease to the onset of dementia. And this period will be very important for clinical and scientific challenges to prevent the severe conditions. In the socio-economical context, we may use the index called DARI to estimate the burden of the given disease or injury to the society. This chart is picked up from the report of the Global Burden of Disease 2021, published last year, in which we can find that the Alzheimer's disease and other dementia is highly ranked as the top 10 laboratory causes by DARI's rate increment between the year 2010 and 21, especially in the high-income Asia-Pacific and Western Europe. So focusing in Japan, yeah, it's a world-leading super aging country now. And it's from the 1990 to 2021, the ranking of dementia is getting up and kept the top as the cause of death in the society for this decade. There are another data indicating the socio-economical burden of the dementia in Japan, like more than 7 billion euro annual cost and burden to the caregivers. Both are so critical for the Japanese society, and that's why Japanese government works so hard in both policy making and scientific research promotion in this area. Here, we would like to introduce the important imaging technology called amyloid PET, which can visualize the amyloid beta in the brain to have the definitive diagnosis of Alzheimer's disease dementia onset. The diagnosis of the dementia give a chance for the treatment selection for us. In 2023, lecanemab, a pharmaceutical effective to the early stage of Alzheimer's disease dementia, was approved in Japan. And for suitable patient selection purpose, amyloid PET test became to be covered by the national insurance system in Japan. And in the current guidelines of the appropriate use of amyloid PET, the use of this test is limited to symptomatic individuals. This chart is a selection of the brain imaging tests and their purpose in the clinical scene in Japan. You can see that the amyloid PET is a technique requiring high-level expertise and adherence to strict clinical guidelines to ensure appropriate resource allocation and efficacy. So it is not adequate to apply for potential asymptomatic populations on demand right now. On the other hand, the recent progress of the scientific approaches to Alzheimer's disease might make precise prediction about the onset of dementia in addition to the early diagnosis. Indeed, several studies combining biomarkers, imaging, and longitudinal cohort data indicates the varied prediction methodology of Alzheimer's disease. Even such expectations and achievement, applying the predictive technology to asymptomatic individuals remains complex and ethically sensitive. So the latter part of my talk will treat ethical issues by applying the predictive technology of Alzheimer's disease to asymptomatic individuals using the Japanese case. First, we summarize the pros and cons. about the profound. Early diagnosis and onset prediction enable us to do the preventive action in clinical and healthcare context, and we can reduce care costs in various levels of stakeholders, and we can support patient autonomy and life planning at an individual level. On the other hand, the cons contains the point that amyloid PET has uncertain clinical utility yet in asymptomatic individuals, which means that disclosure of the positive result of the amyloid PET may bring ethical concerns involving the psychological stress, lack of treatment linkage, and the financial burden to the individuals. In terms of such ethical concerns, Japanese guidelines restrict the amyloid PET screening unless the therapeutically actionable pathways established. In terms of the neuroethics, such ethical conflicts arise between the right to know and the risk of harm from the uncertain information. So more concretely talking, lack of standardized procedures for informed consent and the result disclosure of early diagnosis by amyloid PET may bring inconsistency across the PET imaging facilities. And positive result may lead to stigma, disadvantaged insurance, employment discrimination, and psychological burden to the given individuals. Thus, the unified protocols and ethical frameworks would be urgent need. Considering this, we would like to propose several points to apply effective and efficient amyloid PET. First, cost effectiveness and resource allocation using the risk-based screening procedures. Second, unified protocols for informed consent, disclosure, and psychological follow-up in nature. And finally, supportive social infrastructure and anti-discrimination measures to positive result individuals are important for the ethical implementation. So as introduced at the beginning, Japan is a super aging country in the world, and the government has tried various policy challenges as introduced in the slide. In 2023, we finally have the Basic Act on Dementia, which was preceded by the National Framework of Promotion of Dementia Policies a few years ago. So both of them aim to build a society based on the dual pillars of the prevention of dementia and coexistence with dementia patients. So we hope those actions and future scientific challenges would be a good practice and suggestions to other countries, including the Italy and the other countries in Western Europe. So now I close my talk, and thank you very much for your kind attention.
I don't know because Fernando.
Sí, yeah,
Okay.
No. No, your turn, Silvia, please. Who will be the next?
Carlos Daniel Granados Dominguez, who is going.
Carlos Daniel Granados.
Yeah. Who is going to talk about neurotechnology and disability, mapping concepts, ethical dilemmas, and legal frameworks. It's from your university,
yes,
as I see.
University of Seville.
Yeah.
Carlos, are you here? Well, what would you say, Silvia?
I think he's trying to share the screen.
Okay.
So yeah, as for what
I'm going to try to share the screen. Let me know if you are seeing right now.
Okay. Silvia,
we can see.
Would you mind to present Giordana Truscelli?
No, he's
after
here.
Carlos, because I have
Yeah,
to leave
because
after
you're
Carlos.
going. Yeah,
Thank you
okay,
very
no
much.
problem. No
Thank you very
problem.
much, Silvia.
Thank you to you. So please, Carlos, go
Well,
ahead.
thank you very much. Well, first, thanks to all people connected today with us. My name is Carlos Granados. I'm a predoctoral researcher in the Department of Law at the University of Seville, currently working on the project analysis of the effectiveness of rights related to long-term care in the context of the increasing digitalization. Today, I will give you a brief presentation about neurotechnology and disability, mapping concepts, ethical dilemmas, and legal frameworks. Well, first, this is an introductory approach on these subjects. This paper, this presentation, studied the intersection between these two subjects and analyze how these innovations may impact the right of persons with disability. The aim of the research is this to offer an introductory analysis, and I seek to critically evaluate the advancements in neurotechnological ecosystem and their interaction within their diverse community of persons with disability. First, a small introduction of the conceptual and historical terrain about neurotechnology. People here know that neurotechnology emerged a multidisciplinary subfield of science that seeks through technological tools to understand the most complex aspects of human cognition and behavior. Neurotechnologies, in a simple way, represents a technology from the brain, for the brain, within the brain, inspired by the brain. An interesting definition that I found is in the recent UNESCO draft that neurotechnologies currently refers to devices, systems, and procedures encompassing both hardware and software that directly measure, access, monitor, analyze, predict, or modulate the nervous system to understand, influence, restore, or anticipate its structure, activity, and functions. Also, neurotechnologies can be seen as a collaborative platform for technological convergence. They can converge with artificial intelligence and robotics. From a scholar perspective, the relationship between neurotechnology and AI is frequently described as a symbiotic one. Neither can be fully understood without the reference to the other, because AI endows neurotechnology with the computational and algorithmic capacities required for processing a huge amount of data. And also, robotics contributes the essential physical interfaces and adaptive control mechanisms that enable neurotechnology to establish bidirectional sensory motor interactions within specific anatomical regions. So after this, I'm going to talk about the second subject. That I will start mapping the historical terrain about how disability have been historically treated. So the first model I want to address is the disregarding model. The name itself reflects how disability was considered. Its core assumption are that disability was explained through religious belief and often regarded as a divine punishment. The second point is that persons with disabilities were seen as having no value or contribution to society, being considered unproductive or a burden, whose life deemed meaningless or disposable. We can find this approach in classic antiquity, like in Roman and Greek societies. The second model is the medical model or the rehabilitation model. The consolidation of this paradigm occurs in the 20th century due to two fundamental condition factors: the aftermath of World War I, which generate many disabled individuals, and two, the struggle of labor rights with the creation of the fair laws in the societal security system due to a high number of workplace incidents. This model operates under the premise that the foundational element of disability originate from individual deficits. It transitions from religious explanation to a scientific understanding. This paradigm situates the person with disability with the health, illness, the dichotomy. And the third one, the social model. These movements disseminate the conceptual premise that independence should not be measured by one's capacity to perform basic daily activities, but rather to the ability to direct the course of our own life. So the foundational postulates upon which this model is based establish the causal factors generating disability are neither religious or scientific in nature. Rather, this paradigm posits the determinants are principally and predominantly social. Is this social model that has enabled the analytical treatment of disability through a comprehensive human rights analytical framework that positions these collectives as autonomous right holders. So this is grounded in principles and inherent human dignity, liberty conceived as an individual self-determination, and the intrinsic egalitarian status of all human subjects. This right-based approach materialized juridically through the Convention of the Right of Person with the disability. So right now I'm going to try to make the connection between the two subjects. As I mentioned in the historical terrain of disability, historically, persons with disabilities have experienced a reduction in their moral status compared to other individuals possessing traits that are considered standards, which are grounded on notion of normality or universality, perfection. This notion imposed like a singular way of life, conveying the idea that the farther we move away of these supposedly universal traits, the less meaningful life becomes. Consequently, disability as inherently has construed as inherently negative. So this stems from social construct developed from religious belief, but also from scientific advances, leading to cruel outcomes for these groups. The population of the collective has been subjected for eugenic practices, marginalization, institutionalization, and medical experimentation. So it becomes like imperative to recognize that also neurotechnological developments can be designed within frameworks shaped by embedded social values, medical paradigms, and normative judgments regarding how minds and body ought to function. So if you analyze neuroscience and neurotechnology through disability lens, persons with disabilities were subjected to paternalistic approach, particularly the rehabilitation model that precipitate like coercive intervention, including lobotomies, electroconvulsive therapy, also forced institutionalization, all justified as a therapeutic curve. Scanning the technological ecosystem, diverse innovative technological products are being systematically designed to develop and are demonstrating significant potential to enhance the social inclusion and independence of this collective. Within the technological ecosystem, we can find the proliferation of brain-computer interface, which exhibit significant growth in restoring communicative faculties. Also facilitates persons with physical disabilities for controlling external devices as computer, cursors, wheelchairs. Despite these potential transformative capabilities that the neurotechnologies innovation have, this development cannot be detached from the previous historical things that I mentioned before. It becomes like essential to identify the potential risks that neurotechnology may have for the rights of the person with disabilities. So these are some of the examples that I mentioned before about the potential or the benefits that these technologies can have. And here are like some risks, identified risks that also these new technologies can have. I divided by these 6 topics, but obviously there are more. I just going to use this one. First, equality and non-discrimination. It can be organized by 3 points, like bias, access, and accessibility. So in terms of bias, it involves the bias embedded with research objective and presumptions of normative assessments. Identified bias emerge that reflects determining conceptualization of what constitutes a normal cerebral function. Also, these research perspectives manifest in their capacity to reproduce and perpetuate and amplify prejudicial assumptions predicated upon these presumptions of normality. Also, we have the other bias that we can find here are the bias reference about algorithm bias. So the neurotechnological advancements demonstrate like they are susceptible to this algorithmic bias. As I mentioned, the 2 technologies are closely related to each other. This can be for the introduction to the limitation of the utilization of non-representative training data sets for people with disability. And also we have other socioeconomic determinants like financial barriers for this group, absence of public coverage for assistive neurotechnologies, the digital divide. The second point, identity and agency, I will choose both. Neurotechnology such as DBS or BCIs results in significant alteration to brain structure. Different studies have identified some changes in personality behavioral modification in which consciousness becomes diminished or confused. Moreover, agency refers to the individual capacity to make and communicate decisions and to act upon them in ways that influence our own life. In this point, we can find the risk in 2 dimensions. The first one is that neurotechnologies must not be proceeded without informed consent under a paternalistic medical approach justified in grounds of best interest. This can affect rights, principles like autonomy and liberty. It should be a perspective centered on the individual with will and preference, according to the general comment number 1, that neurotechnology may have the provision and support for the legal capacity of these individuals.
Sorry, Carlos.
Yes?
Do you have more or less 1 minute? Otherwise, in case if you
Okay.
can come to the conclusions. Thanks.
Well, yes. Well, closing reflections. These are 5 closing reflections that I consider that are really important, that neurotechnologies present a dual nature, the dichotomy. They have a transformative potential for independence and autonomy versus this significant risk to fundamental rights. As I mentioned, also the current legal frame will remain very fragmented and inadequate to address the risk that neurotechnology poses for these collectives. So it requires this convention of the right of person with disability as a primary normative foundation to policy development. So also the new governance framework are essential, demanding active participation of these communities in both technical development and also in regulatory formulation through the third sector of social action as crucial intermediaries in this subject. Also, strategic participation mechanisms must be included in digital literacy initiative. Also, all these reflections are guided in this Nothing About Us Without Us, created by the collective of people with disability, because neurotechnology, this group is neurotechnologies are focused. A lot of neurotechnologies are focused on people with disabilities, so they have to have the voice in all this implementation. And finally, a human right-based approach across the entire neurotechnology life cycle, I think, is indispensable. Human rights approach give an ethical, legal, and political basis theory that it is always in evolution that can counterattack reductionist approach while enabling the construction of inclusive societies where persons with disabilities are recognized as a complete right-bearing subjects. And that's all. Thank you very much.
Thank you, Carlos, for maintaining the time. Very interesting presentation, as also the other two that preceded you. And now we come to the fourth presentation by Giordana Truscelli, who is a PhD student at the University of Teramo. She is going to talk about non-replicable consciousness, an ethical and scientific problem in the age of AI. So I leave you the floor, Giordana.
Thank you very much. Good afternoon, everyone. I would like to express my gratitude to the organizers of this significant event, and in particular to Professoressa Salardi. The present day will see the discussion of a matter that is both highly relevant and contemporary: the replicability of consciousness by new technologies and artificial intelligence. We are currently experiencing a period of technological advancement with tools that have cognitive abilities encompass a wide range of activities, including facial recognition, language translation, autonomous driving, and the creation of artistic works. This prompts fundamental questions regarding the nature of these machines. Are they merely sophisticated tools, or could they possess true consciousness? For the purposes of this debate, consciousness is hereby defined as the condition that makes it possible for anything to have meaning for any of us. The fundamental questions pertains to distinction between behavioral replication, wherein a technological apparatus emulates conscious human behavior, and authentic subjective experience, a feat that presently appears unattainable for machines. As as will be demonstrated in the following discussion, this contemporary debate necessarily encompasses ethical, philosophical, and technical and legal issues. The concept of consciousness has been the focus of extensive scientific and philosophical discussion for centuries. Despite these efforts, a definitive answer remains elusive. Nevertheless, it is possible to identify the areas of greatest theoretical tension. The concept of consciousness has been conceptualized in various ways through history. For example, in post-classical Greek thought and St. Augustine's writings, it was conceptualized as an inner voice or the conversation of the soul with itself. Finally, reductionist theories, as posited by philosophers such as Gilbert Ryle and Daniel Dennett, seek to explicate consciousness in terms of physical, behavioral, or computational processes, thereby issuing any residual mystery. In this regard, David Chalmers' distinction between easy and hard problems of consciousness is fundamental. The concept of easy problems pertains to cognitively solvable functions such as memory or attention. The so-called hard problem pertains to the existence of subjective experience and the feelings. The fundamental questions pertains to the fundamental questions pertains to the possibility of replicating consciousness. The replicability of consciousness is a concept that has been subject of considerable theoretical discussion. For instance, functionalism, as proposed by Hilary Putnam or Jerry Fodor, posits that consciousness emerges from organizational and functional properties of information systems. According to Tononi's integrated information theory, subjective experience is a property of cause and effect configuration. In his seminal work, Antonio Damasio proposes a graded conception of consciousness, distinguishing between nuclear conscious and extended consciousness. The objective of these theories is to demonstrate
We can't hear you, Giordana. I'm the only one who... No, she went out.
No, I think the connection is not working.
Exactly.
Oh.
Okay, sorry.
Are you back? Okay.
Okay, perfect.
I have 5 minutes, huh? 5 minutes.
Okay. However, a philosophical and scientific tradition asserts the fundamental impossibility of replicating consciousness through artificial systems. Searle's thought experiment, the Chinese room, demonstrates that syntactic manipulation of symbols, even when guided by instructions, does not generate a genuine semantic understanding. Searle is a proponent of biological naturalism, which asserts that consciousness emerges as a causal property of specific neurophysiological processes of the biological brain that are not reducible to a computational implementation. In summary, while new technologies have the capacity to simulate conscious thought, theoretical objections categorically rule out the replicating of authentic subjective experience. From this perspective, it is posited that consciousness is exclusive to biological system. In the event of accepting for the sake of argument the premise that artificial intelligence has the capacity to express authentic forms of subjective experience, the ethical, philosophical, and legal implication would be profound. This would give rise to a number of crucial questions. For example, the question that arises from this is whether an artificial experience could be considered as authentic as a human one. The question of how a digital system would be punished or rehabilitated is a complex one. These considerations demonstrate that the recognition of consciousness in an artifact would have a substantial impact on jurisprudence. This would necessitate not merely superficial amendments, but rather a comprehensive overhaul of the philosophical and normative assumption underpinning the societal structure. In conclusion, despite the extraordinary advance of modern science, the phenomenon of consciousness remains uncharted territory. As demonstrated by Searle and Chalmers, it cannot apparently be reduced to mere calculation. It is imperative, in my opinion, for technological societies to reevaluate their relationship with artificial intelligence, achieving an harmonious equilibrium between efficiency and individuality. This reevaluation must be accompanied by a steadfast commitment to the fundamental role of law in safeguarding human dignity and serving the interests of human beings. In order to navigate the intricacies of the AI era with phronesis, practical wisdom, it is imperative that a dialogue is initiated among lawyers, philosophers, and technicians without losing sight of the fundamental values that characterize our civilization of law. Thank you. And I'm sorry for the problem with connection.
Thank you very much. No problem. Also, thank you for keeping the time, actually, also with the problems you mentioned. So now I'll leave the floor to the two discussants that were presented before by Professor Fernando Liano, who had to leave. I would leave the floor to Philipp Kellmeyer from the University of Mannheim, thanking him a lot for being here. So, Philipp.
Thank you so much, Sylvia, for having me at the meeting, and congratulations for such a fantastic program and also the inputs that we just heard. So first of all, heartfelt thanks to all the presenters for these really excellent and sometimes thought-provoking contributions. So I'll just go presentation by presentation to make sure that I can acknowledge each contribution. So Beatrice, I think I really liked your presentation. I think it was conceptually and ethically very rich. I like this terrain, this idea of neuroconsent and habeas corpus. And maybe wanted to sort of start with your final question, whether we're really protecting freedom of thought or just adapting outdated tools, because I think it goes to the heart of the neural rights debate. So from my perspective, I'm a clinical neurologist, neuroscientist, but also working a lot on digital technologies now and participatory research, especially also with disability communities. I would say sort of not a legal expert also, but I've worked in this space for a long time now. I would say that right now we are sort of still largely relying on outdated frameworks like informed consent, so from a clinical perspective, because they were mostly designed for bodily interventions and are particularly fragile when applied to interventions in mental processes and identity. But the challenge, I think, from having been part of this debate really for a long time, is now not to invent entirely new rights. So I'd be also on this boat with you from scratch, but to refine and deepen existing ones so that they genuinely protect mental life and our mental processes. So to break it down, I could say we are adapting old tools in your framing, but we need to reforge them into instruments that are kind of capable of safeguarding freedom of thought in the age of neurotechnology. And I think the urgency is really clear also in practice, because let's take the case of DBS for treatment-resistant Parkinson's, or even now depression, other situations. The patients there are especially vulnerable because they're often desperate. And desperate consent, in my experience, makes autonomy especially fragile. And so we need to acknowledge that these situations, dementia and neurodegenerative disorders, create a special version of vulnerability that we need to acknowledge in our layered approach to how to protect the mental life. This would be that. For Tamami Fukushi-san, thank you so much. I really like this paper, the input, and also the framing around the challenges, demographic challenges that you face in Japan with an aging society. So again, here I would like to frame it in a broader clinical context, because as you also know, there has been a lot of disappointment in the dementia community and the research field around the sort of limited success of disease-modifying drugs, especially biologicals. If you compare it with the successes that we had in cancer medicine, oncology in the past 10, 15 years, major disappointments with all the clinical trials in Alzheimer's. And so I think one key lesson from this experience has been that we need to stratify dementia subtypes much more precisely and detect, or even now, as you showed, also predict onset much earlier. And so PET imaging is great because it's very grounded in pathophysiology. It's very interesting, but on the other hand, it's also a very high-tech approach that raises sort of ethical tensions around access and cost. If we look from a sort of global brain health perspective of the problem, so it might be very viable approach to industrialized country like Japan, where these machines could be accessed widely. But in parallel, we see so many developments in blood-based biomarkers that are emerging that may be far more economical and scalable, and potentially allow us to predict Alzheimer's many years in advance. These studies in UK Biobank data that are now coming out, where you find with unsupervised machine learning, basically often a physiologically, neurobiologically unclear set of proteins that are highly predictive for onset of Alzheimer's a few years down the line. So these biomarkers often operate with deep uncertainty, sometimes even beyond our current neurobiological understanding of disease dynamics. So they're kind of highly predictive, but epistemically opaque. And this is, I think, where PET is a little better, because it really works at the sort of neurobiological level. But I think the dynamic will shift towards these more scalable, maybe low cost and highly accessible biomarkers from a global brain health perspective. And I would say that this creates a new class of ethical challenges, like how can we responsibly communicate and act upon predictions that may be statistically accurate, but conceptually or clinically difficult to interpret, because it's like unclear what it means from a neurobiological perspective, but has high predictive value, because in a 10-year timeline, you may modify your dementia risk by physical activity, by stop smoking, alcohol, and so forth. So there's a lot of implications with this. And Carlos, I was really fascinated also by your presentation, because we have this project together with Roberto Andono, with others, on neurotechnology and disability at the moment. So I think this is really rich and historically grounded, because you clearly showed how easily neurotech can reinforce ableist assumptions and the dangers of normalization in this context. And I also especially welcomed your emphasis on participation. And I just want to build on that. And I would add that the most recent debate, sort of what we are now looking at in disability studies, push us to go beyond the sort of this critique, justified critique of normalization towards even a more affirmative stance to sort of affirm neurodiversity as a valuable model of human variation, right? And so from this perspective, participation should just, is good, but the question is always what kind of participation, how deep and how sustainable, right? In the sense of, do we mean consultation or genuine co-design and decision-making power for people living with disabilities involved in study design or neurotechnology design? So I would say ensuring that persons with disabilities are active co-creators in shaping neurotechnologies. This would be where the promise of neurotech innovation could lie for this community, not in correcting deviation from a norm, but sort of building tools that expand capabilities, agency, and diversity, and then sort of affirm the fundamental fact of neurodiversity and neurophenotypes, just as a sort of building on the points that you said. And Jordana, also your reflections on replicable consciousness, I think is great because it brings us back to so many first principles in the debate around sort of biological versus artificial consciousness. Liked how you distinguish between simulation and authentic subjective experience, but just wanted to, as you know, point to this point that authenticity itself is notoriously tricky, right, from a conceptual and philosophical perspective. Now, digital technologies emulate almost every domain of our human self-expression, right? Language, speech, art, poetry. And this, I think, puts increasing pressure on what we mean when we call an experience authentic, right? Is a human self-expression, average human self-expression that you find on social media and other mediums. Is this really how well connected to the authentic subjective experience and authentic self is this on average? But so one way to preserve the usefulness of authenticity as a concept is to maybe not root it in output similarity, but in the sort of underlying lived, embodied, first-person perspective of humans as agents. So in this sense, authenticity is kind of inseparable from vulnerability, from the fact of temporality, that we are sort of have a limited time here on the planet as individuals, right? Despite what Xi Jinping and Putin may be dreaming about, we're still mortal, right? Just affirming this here. And the continuity of personal identity, personal narrative over time, okay? So if you define authenticity in this way, in a sort of lived, vulnerable, temporal, and embodied fact of our lives, I think it still would be instrumentally rich concept for discussions of consciousness, because it highlights the kind of difference between mere simulation, functional emulation, what we now can achieve with a lot of digital technologies, and the sort of actual lived subjective experience, which could be a crucial distinction both for protecting the uniqueness of human beings and for evaluating any kind of emerging claims about artificial consciousness and AGI, artificial general intelligence, that we see so much now. So I think taken together, all four talks remind us that vulnerability is kind of a common lens, a common denominator, whether that's in prisons, dementia screening, disability context, or around AI consciousness. And so the challenge in terms of ethics, law, governance, is really how we can protect autonomy, dignity, precisely where sort of decision-making power is weakest and is weakened by vulnerability. So I'd like to thank all speakers for these fantastic inputs, and also the papers that I liked a lot. So I learned a lot in this session, and yeah, would like to give the word to Jose, I think.
Thank you, Philip. Thank you very much. Now I leave the floor to José Antonio Seoane from the University of La Coruña, also high-level expert of bioethics, ethical issues. I don't see him, but I saw him before. So please, José.
Hey, Silvia. Yeah, I'm here. I was listening carefully to the presentation. So thanks for the invitation, for having me here, as well as congratulations for the superb organization and the superb presentation. So thanks for all the 4 presentations, I think, and I do appreciate your oral presentations because you have enlightened in another way the written papers that we, Philip and I, could read thoroughly, but I think the oral presentations underline some issues that are plain relevant. So, due to the tight schedule, I go straight forward to my comments more for you, because we were told to supplement in some sense or to underline some issues that are within your papers, but as well that could be supplement your approach. So to Beatrice, of course, even this underlining in neuroconsent. So a couple of comments. So you are aware, but should be really aware about the difference between the different approaches about self-determination, about personal autonomy, because it's not the same if you have a kind of continental or European continental approach at an Anglo-Saxon approach in terms of self-determination. And without not forgetting the Asian or African approaches, which are stressing the so-called relational autonomy. I know you are aware, but I think it would be very useful to underline this kind of issues in addressing informed consent or neuroconsent. And this is also relevant because I'm not sure if informed consent could retain the predominant role in terms of decision-making. I think we are addressing us in some sense to a kind of systematic way of decision-making. So personal autonomy is not so strong as before, I think. So just this kind of comments that are also related with the freedom of thought as the core right in terms of neural rights, instead of mental privacy, if we talk about the European Court of Human Rights, for example, or even mental integrity in another domestic legislation and other approaches. And let me just a question about, or a point about your written paper that has not so shown in your presentation, which is the difference between the 2 realms that you have addressed, which is prison and healthcare issues. Because in prison, you have some a priori legal limitations and ethical limitations that are not existing in healthcare field. So I think you can make you cannot address both fields as similar in this sense. Well, to Tamami Fukushi, a more clinical and technical approach, but you address in the end ethical, legal, and also political and governance answers, which is quite relevant here. My concern is that your Japanese experience is very valuable, but we cannot spread worldwide because of the difference between different countries. And this is also a problem with the neuro rights or neuroethics approach. Not just that's one. I especially appreciate your relevance on psychological follow-up, because not just the decision-making process, but also to take care the whole process, even before the decision-making. And my concern here is to avoid the so-called neuroexceptionalism. So we have a risk that underline too much these neuroethics or neurolegal approaches and that becoming a kind of neuroexceptionalism. And finally, just a remark that you are, when you, I was listening to you and I was reading to you, and in every moment, it becomes memories about the genetic experience. So this genetics is the same for the biological dimension of our lives, and neuroethics, neuro rights is the same for the psychological, well, a broader one. So, and you have talked about the right not to know and many other genetic discrimination, in this case, neuro discrimination. So I think we could take this experience as a good way to follow up with neuro rights or neurotechnologies. So to Carlos, thanks again for your presentation, as the others. I do not completely agree with social model is the whole basis for the human rights. You are not telling exactly this, but this is a quite common issue in scholarship, that the social model is the foundation of the Convention of Human Rights and Convention of the Rights of Persons with Disability. Without the individual approach also, it's not possible to address these neurotechnologies, because you are not intervening in the social realm, but also in the individual realm. So I think trust a lot in the social model could be a wrong way, only in the wrong way, to address these issues. And I suggest also to take into account the advantages of neurotechnologies for persons with disability. You have explained quite thoroughly in a very well-structured presentation the risks, but neurotechnologies are also a relevant and brand new way to improve participation and persons with disability rights. So I suggest also to underline these advantages, because otherwise it makes no sense to talk about participation. And just a question. So do you think we should suggest some specific disability neuro rights or not? And finally, to Jordana, just in this hard way. So this, a more philosophical or more ontological approach, I do appreciate as well. I agree with your way of approaching based on John Searle and David Chalmers as well. And following David Chalmers and also Clark and Chalmers, I think before addressing artificial intelligence, it would be interesting to address questions about neurotechnology and the so-called the extended mind thesis. Because thinking of the ethical and legal consequences, extended mind thesis suggests, if you address an externalist approach, that we can talk about a kind of personification of these devices. And these devices, and this is also is really a legal challenge, because we're talking about legal personality, legal personhood, and this kind of things. So I think taking into account this extended mind thesis, following your authors as well and your scholars, could be a way of strengthening your approach, not just about artificial intelligence, but any other neurotechnological devices that could be useful to understand how, as human beings, and talking about honoring human dignity, human authenticity, human identity, how can we tackle with these necessary neurotechnological devices for having a dignified life? So how could legally answer? So the extended mind thesis is really a good way also to supplement your presentation. Well, I think this is enough. I'm sorry for just being in such a hurry. And thanks again for your superb presentations.
Thank you, Jose Antonio. So for your comments, thanks also to Philip, to all the presenters and speakers of this session. We are running out of time, so we have to give the break, the lunch break. We will go back at 2:30 for the third session. So thank you very much for your participation and your presence here. Have a nice lunch. We see each other afterwards. Bye. Here in the second part of this conference, Neurotechnology in the Age of Human Rights. So I said at the beginning, I'm just making the transition towards the session and presenting the moderator. In this case, we have Professor Margaret Vetis Zaganelli from the University of Espírito Santo, Brazil. She is full professor of criminal law and an expert in bioethics. I'm very glad that she accepted the invitation, because we had a lot of projects going on together in the past, and so I'm really happy to have her here. So please, Margaret, the floor is yours.
Thank you, Professor Salardi. Good afternoon to all. My name is Margaret Vetis Zaganelli. I am a professor at the Federal University of Espírito Santo, Brazil. I thank Professor Salardi and the organizer of the International Conference for the opportunity to participate as of the section Human Rights, Cognitive Liberty, Freedom of the Mind, and Enhancement. In this session are discussed Professor Miguel Lucait, Professor of Artificial Intelligence and Law at the Pompeu Fabra University, and member of the European Group on Ethics in Science and New Technologies, and Professor Alexia Farano, Professor of Legal Methodology and Law and Ethics of Emerging Technologies, University of Luiz Guido Carli. And our presenters, Dr. Timo Stace, University of Antwerp, Dr. Schurz Ligtar, Tibor University, Dr. Raquel McIntosh, founder and executive director of the Foundation for Bioethics, and Dr. Julia Maria Servida, University of Milan. Each presenter, you have up to 10 minutes to deliver their presentation, and each discussion, you have 7 minutes for their comments or questions. Please, I invite Professor Stacy to start your presentation. Please.
Yes, good afternoon, everyone. I shared my screen. I hope it's working. Everyone can see it. Okay, so indeed, good afternoon. Thank you very much for the invitation and for the interesting presentations already this morning. I will present here a small part of my doctoral research, and today I will go with you into the question as to a positive freedom to engage with neurotechnology. Lots of the debate on neurotechnology often focuses on negative freedoms. How do we protect individuals and society from abuses from neurotechnology? But I was wondering, does human rights law also have something to say about people's freedom or people's capacity to voluntarily engage with neurotechnology? And that all crystallized around the topic of neurotechnological cognitive enhancement. So that's what I will be briefly presenting. It has been an elaborate research project, but I tried to give the key findings in this 10-minute presentation. Okay, so first, as I said, neurotechnological cognitive enhancement. What do we mean by this? First, cognitive enhancement, it's not that of a straightforward terms in academic literature, because there is quite some conceptual discussion about what it really entails. First, there is cognitive enhancement. I, in my analysis, see cognitive enhancement as any intervention that positively affect human mental attributes, abilities, or traits. And enhancement, the classic problem is defining what is enhancement and making the distinction between treatment and enhancement. And I will not go into this any further because it's not the most important aspect of my research. I will limit the research, however, or this analysis to non-medical uses, acknowledging that often the lines are blurry, but for the key aspects of my research, that's not the most important part. So I'll focus on non-medical neurotechnological cognitive enhancement. And what are examples of this? Well, for example, the most prominent are neurostimulation devices, such as transcranial direct stimulation that via, for example, a headset stimulates the brain and then augments or enhances capacities for learning or for concentration, for focus, and so on. Other examples are neurofeedback applications, often based on EEG measurements that inform people about their current state of productivity, their current state of focus, and people can train themselves via the feedback they receive to optimize their mental abilities. So these are some of the neurotechnologies that I focus on in the analysis. And then the question arises, within human rights law, does it offer some fundamental claims or some fundamental freedoms for people to engage with those freedoms? With those technologies, or can limitations be put on the accessibility to these technologies? The framework I use for this analysis is the empowerment versus constraint lens. And this lens, this approach is primarily developed by Bijleveld and Brownsworth in their analysis of human dignity. And very brief, they say that human dignity, depending on the context in which it's invoked, or can be invoked as an empowerment tool or as a constraint tool. So empowerment, in those cases, human dignity is relied upon to reinforce people's claims for self-determination, to reinforce their freedoms, to develop themselves and to engage, for example, with external tools or engage in certain medical procedures. And then there's a constraint dimension of human dignity that is the function of human dignity to limit claims of self-determination of individuals in favor of collective values or to prevent harms. An example of that is, for example, the restriction on surrogacy. Often is invoked the idea of we need to protect harm, the surrogates of any individual harm, but we should also think about the broader societal impact. So often in biomedical contexts or in legal instruments in the field of biomedicine, the constraint dimension is central. Now, the analysis of Bijleveld and Brownsworth really attribute empowerment versus constraint dynamic to the notion of human dignity, but I consider it to be present within the whole of the human rights framework. Many rights and freedoms inherently to themselves have like an empowerment and constraint dimension that tries to look for a balance in certain way. So that's why I use this lens to look at specific subjective rights first to see how this dynamic plays out in their context. Now, going back to the enhancement, the neurotechnological enhancement, when we look at this debate, automatically we think about the human right or the right to autonomy or self-determination. Is it existent in human rights law? It's contested under which status? Is it a standalone right? Is it a general principle? That can be debated, but essentially we can affirmatively say that there is something as a right to autonomy, a right to self-determination existent in the human rights framework that protects people to make choices about their own lives on the basis of their own values and responsibilities. Their own values and beliefs. But then the question, going deeper, becomes, is there also something as a right to mental self-determination? Does this right extend to people's ability or people's claim to form their own mental abilities, their own mental states as they wish, as they see fit? And there are different opinions, but there is a growing fields or a growing string of scholarship that does answer this positively, that there is something as a right to mental self-determination, and there are different grounds. We can see it as an inherent part to liberal democracies. We can see it as a general natural cornerstone of human rights law, or thirdly, we can also see it as inherent to some specific human rights. And the most prominent one would be the right to privacy. The right to privacy, again, the right to self-determination is part of this right to privacy. So it is consistently said also by UN reports, etc., that the right to privacy protects people's right to live their own lives according to their own beliefs and values. And then when we would logically think this through, it would be weird to say that people can live their life according to their own decisions, their own values and beliefs, but then not protect those decisions or the way in which those decisions, beliefs, and values come about. So naturally, it seems necessary to also consider mental self-determination to be integral to the right to privacy, and especially when we also look to the right to personal identity, which is often read into the right to privacy, but also separately protected, for example, in Article 22 of the Universal Declaration. So I think the analysis can, of course, be more thorough, but on a general superficial level, we can say that the right to mental self-determination seems a necessary part of the right to privacy. There is also the argument that it could be part of the freedom of thought, but I think that's not very convincing, or I wouldn't attribute a right to mental self-determination in its positive sense to the freedom of thought. Why not? Well, it just seems not in line with the natural character of absolute rights to have to also cover claim rights to absolutely protect people's active claim to some actions of others. Normally, or more generally, absolute rights protect or prohibit specific, well-defined actions, such as enslaving other people. It's a very limited prohibition of certain acts, and it normally, absolute rights are generally not protecting claims of individuals to act in certain ways. So I think that the right to mental self-determination should be considered to be a relative right underpinning the right to privacy and the right to personal identity. But such a right to mental mental self-determination, does it also protect or encompass a right to cognitive enhancement? Also, this question, I think, needs to be answered positively to a certain extent or in a specific way. I think it does comprise a negative right to cognitive enhancement, meaning that without necessity and proportionality, people should not be hindered in their engagement with cognitive enhancement tools, because it's a little bit contradictory to protect people's right to mental self-determination, but not give them access to the tools that help them to really operationalize it, right? To really enjoy this, right? So therefore, I would argue that a right to cognitive enhancement is implicit or is incorporated in the right to mental self-determination, which is also reinforced by the right to benefit from science and the right to the highest attainable standard of health. But that would bring me to 4, so I'm not going into it in this presentation. But there should be, or I consider there to be, a relative right to cognitive enhancements, and so a relative right of people to engage with neurotechnological cognitive enhancement. And this relative part is really important. Why is it really important? Because that's where the constraint dimension appears. States have an obligation to monitor and regulate scientific and technological advancements, and when reasonable and when necessary, they should take actions to protect public health, public safety, public order, and the rights and freedoms of others. So that's where the constraint dimension comes about within the right to privacy, the right to mental self-determination, the right to cognitive enhancement. So then I looked into what would be the most prominent grounds which states could claim as proportionate or as legitimate aims to impose proportionate limitations. And then I think the most urgent or the most prominent grounds would be integrity and health concerns for the citizens, because as long as we are dealing with emerging technologies of which all the benefits but also the risks are not clear, it is very hard for individuals to make a free and deliberate way a conclusive risk benefit analysis. So this hampers their own benefit of the right to mental self-determination if they are not able to make an adequate free risk-benefit analysis. They themselves, their own right to integrity is at peril. So this would be a legitimate ground for states to implement proportionate limitations. And the same goes for concerns about equality, equitable access, and distributive justice. These are all values that underpin, that are somehow connected in the general pursuit of the human rights framework for equality and non-discrimination. And there are ample examples of concerns that arise in this regard with the wide availability of neurotechnological cognitive enhancement. For example, the implementation or the emergence of an enhancement divide where people would be selected or discriminated against in different societal contexts on the basis of their enhancement status, but also the general change of social identities based on whether or not someone would be enhanced and would be considered normal or healthy against people who deliberately choose not to be enhanced. So there's also much to be said there. Does that mean that states, in the name of equality, should provide everyone with access to neurotechnological cognitive enhancement and really finance and subsidize this access? I would think not. Again, here it would be a negative right to equal access or to equitable access, where states should think about the balances of distributive justice to make sure that people who really need it have access or have primary access to these technologies. So these are potential grounds for limitations, but as I said before, those limitations should always be proportionate and on a case-by-case basis. There should never be or human rights law in any case does not support blanket bans on neurotechnologies because we are scared of them. Case by case, states should be able to show that certain types of neurotechnologies of cognitive enhancers are in a specific case a threat to integrity and that the limitations they install are proportionate. And then finally, we can think then, imagine in a hypothetical case that all the concerns about integrity and health and equality and non-discrimination would be dissolved and that adequate measures are taken to ensure that those interests are protected. Are there then no limitations, and does the right to cognitive enhancement open the free access for all to these technologies? Well, I think then it is necessary to go back to human dignity. It's a very elusive human rights principle, and it does mean many different things in many different contexts to many different people. But I think it is a necessary focal point to capture the full constraint dimension of the human rights framework, because we looked at these subjective rights, integrity, equality, but they don't capture this idea of protecting what it means to be human. All the analysis before about legitimate aim and proportionality, they don't leave any room for this fundamental notion of, do we protect what it means to be human? And therefore we need human dignity to come back into the equation as a foundational dimension that captures the full collective constraint and leaves room for questions such as, do we really want these technologies to come into our societies, as they may make that people are reduced to their neural data and will be transparent and open for manipulation at will. So therefore, we still need human dignity as a final, ultimate touchstone. So in conclusion, there is this complex dynamic between empowerment and constraint when we look at the human rights implications of neurotechnological cognitive enhancement. In prima facie, it seems that people should have the right to engage with neurotechnologies, but there's room for national and international regulatory bodies to put into place proportionate limitations when it's necessary and when it's subject of a case-by-case assessment. The question, or the still open question, or one of the most important questions in my feeling, is, does the fact that these cognitive enhancement tools really work or go through to the human mind heighten the bar for proportionality? Is it so intimate that the bar might be higher than other technologies that, for example, just alter some bodily functions? Well, I think that's an interesting question that remains to be seen. Thank you.
You're muted. Margaret, you're muted.
Congratulations, Dr. Stace. Thank you so much for your presentation. Next, I invited Dr. Sjors Ligtar, Tilburg University, for start your presentation, please.
Yes, let me see. So do you see my presentation on the screen?
Yes.
Yeah?
Now,
okay.
yes.
Okay, thank you very much. So, hello everyone. Thank you for having me, for hosting this talk. So my talk will be about the right to freedom of thought. And more specifically, I will briefly say some things about the absolute nature of this right. And because I only have 10 minutes, I will just briefly go into some of the arguments that I have explored and developed in this paper. And if you are interested, you can read everything back, because it has been published open access with the Human Rights Law Review. Okay, so as we also saw today, I think, and heard from other speakers, since recent years, the right to freedom of thought is gaining increased scholarly interest. And this has mainly to do with, this is mainly a response to the emergence of all kinds of modern technologies that increasingly enable others to interfere with people's inner mental states. And these include, for example, neurotechnologies, but are not limited to neurotechnologies. You can also think of digital technologies and other techniques, but mainly a response to these emerging techniques that enable others to interfere with our inner life. Scholars are increasingly thinking about how should we interpret and apply the right to freedom of thought also to these technologies. And according to legal scholars, but also according to ethics committees and human rights bodies, the right to freedom of thought actually holds great promise to offer robust human rights protection to the human mind in the 21st century. And this is generally, I think, for two different reasons. And the first reason is that, according to some scholars, the scope of the right to freedom of thought is broad, which means that the right to freedom of thought applies to many different types of mental interferences, including mental interferences with emerging technologies such as neurotechnology. And the reason why the right to freedom of thought, why the scope of the right to freedom of thought can be considered to be broad, are, I think, twofold. So first, I think it's generally accepted that the right to freedom of thought at least implies these three negative substantive freedoms. So first, that the freedom from force to reveal your thoughts, so privacy over your thoughts, the freedom not to be punished just for what you think, and the freedom from impermissible alteration of thought. And the second reason why one could argue that the scope of the right to freedom of thought is broad is because, according to some scholars, the notion of thought in the meaning of the right to freedom of thought should be interpreted broadly as well. So as to apply basically to any mental state with content, so including intentions and desires and memories, but also in a way that the right applies to the mental act of thinking and exercising reason as such. And this is quite a broad understanding of the right, and such an understanding, it can be argued, has been endorsed by the Special Rapporteur on the right to freedom of religion and belief. The second reason why many scholars think that the right to freedom of thought holds great promise for offering robust protection to the human mind is because in the law, the right is often considered to be an absolute human right, an unconditional human right, as Timo already mentioned, which means that the right does not allow any exceptions and limitations to the right to freedom of thought. If we consider it to be an absolute right, can never ever be justified. In other words, unlike qualified rights, like the right to privacy or the right to personal integrity, the absolute right to freedom of thought is not open for a balancing of competing interests. It is not open to proportionality testing. And again, this absolute reading of the right to freedom of thought can be supported with reference to this report from the Special Rapporteur. And some authors have referred to the absolute nature of the right to freedom of thought as an uncontroversial yet untested statement. So, and if the right to freedom of thought indeed has a broad scope, which means that it applies to many different types of mental interferences, and if the right to freedom of thought is indeed an absolute right, then this right is plausibly a very, very powerful tool to offer strong protection against a variety of mental interferences, because the right to freedom of thought will prohibit all such interferences when performed without consent, because it is an absolute right. However, such a broad understanding of an absolute human right to freedom of thought also risks overreach. And it could well have undesirable and unwanted outcomes in practice. Because if the scope of the right to freedom of thought is broad, then it will apply to many different types of mental interferences with many different types of mental states in many different contexts. And if the right to freedom of thought is at the same time absolute, it will prohibit all such interferences without any exception whatsoever. And this would mean, if you would apply such a right in practice, that the right will plausibly have radical implications. And for example, it will plausibly prohibit certain practices in mental health care or in education or in criminal justice. And meanwhile, we do usually think that interferences with some thoughts in these contexts can sometimes be permissible and perhaps are sometimes even necessary in a democratic society. And one could think, for example, of influencing thoughts in the context of medical treatment in an emergency situation, where we change a person's thought without their consent. Or we could think of obliging witnesses to reveal some thoughts, like memories of a criminal offense at trial, which we usually think are legitimate practices. So in order to prevent the risk of overreach when we are constructing and reinterpreting the right of freedom of thought, or when we are applying the right in practice, for example, by judges, I think different approaches are possible. Just to mention a few, what judges could do, for example, to avoid undesirable outcomes when applying the right, is just not to apply the right, just to consider complaints about mental influences, for example, under the heading of other rights, like the right to privacy or the right to personal integrity. An alternative approach to prevent the risk of overreach by the right could be to narrow down the scope of the right. For example, to say, the right to freedom of thought does not apply to just any mental state, but only to a specific subset of thoughts, which would narrow down the scope of the right. And an alternative approach, which I would like to explore in this talk a little bit further, is to rethink or refine the absolute nature of the right. So today, I will briefly look into these two general questions. So the first question is the right to freedom of thought really and completely an absolute right? And if so, for what reasons? Or may there be some room for restricted limitations? For example, implied limitations to very specific contexts in order to prevent overreach, in order to prevent undesirable outcomes when we apply the right. So let's first have a look at the first question. And I think if you look at the literature, generally 4 different reasons can be found to support the claim that the right to freedom of thought is completely an absolute right. And in view of the time, I will focus on the first 3, namely that inner thoughts are, according to some authors, beyond the scope of legitimate state power, both factually and normatively. According to some authors, the general comment to Article 18 supports an absolute reading of the right to freedom of thought. And another reason that is often submitted in the literature is because the wording and the structure of, for example, Article 18 of the ICCPR and Article 19 just do not explicitly allow for exceptions to the right to freedom of thought. Okay, so I think regarding the first claim that inner thoughts are both factually and normatively beyond the scope of legitimate state power, Christoph Bublitz has already shown in 2014 that this claim is evidently false. As states can, states will, and states are often, or at least sometimes, allowed to interfere with the inner thoughts of their citizens. One could think, for example, of education, which we impose on children. One could think of practices in criminal rehabilitation or mandatory de-radicalization programs for convicted terrorists, for example. One could think of unconsented psychiatry, propaganda, advertisement, nudging, etc., etc. In other words, as Christoph Bublitz put it in this paper, the modern state is able to peer into the brains and minds of their citizens. They do possess the tools to alter thoughts, beliefs, and convictions, and some states at least do so sometimes. So I think generally the claim that states, that our inner thoughts are beyond the legitimate state power, the legitimate power of states, I think is just not true and therefore not persuasive. And furthermore, I also think that the fact that inner thoughts are sometimes can sometimes be under control of state power is also illustrated by the qualified protection of the right to freedom of thought that is offered in some jurisdictions. If you look, for example, to Article 13 of the American Convention of Human Rights, or to the constitutional protection of the right to freedom of thought in South Africa or in Japan or Canada, then you would see that in these jurisdictions, the right to freedom of thought is not an absolute right. In these jurisdictions, sometimes states are permitted to interfere with the inner thoughts of their citizens, apparently, which speaks against an absolute interpretation of the right, at least under this first reason. Okay, let's look at another reason that is often submitted that should support an absolute reading of the right to freedom of thought, and that is because this would follow from the general comment to Article 18 of the ICCPR, more specifically from paragraph 3. So let's have a look what paragraph 3 of this general comment actually says. So it says that Article 18 of the International Covenant does not permit any limitations whatsoever on the freedom of thought, conscience, on the freedom of thought and conscience, or on the freedom to have or adopt religion and belief of one's choice. These freedoms, so the freedoms mentioned in the previous section, they are protected unconditionally. In a subsequent sentence, the committee adds that in accordance with Article 18, Section 2, and Article 17, which is the qualified right to privacy, no one can be compelled to reveal their thoughts or their adherence to religion or belief. So if we are thinking about absolute protection, what does this paragraph of the general comment exactly say? Well, it does definitely support, I think, an absolute reading of the freedom to hold and change and develop inner thoughts. I think no one will challenge that. But I do not think that this paragraph also supports an absolute reading of the freedom not to reveal your thoughts. First, because it only mentions this freedom after the considerations on absolute protection in a separate sentence. And secondly, I think more importantly, because the general comment explicitly relates the freedom not to reveal your thoughts to the qualified right to privacy, Article 17 of the Covenant. And if you look into the drafting history of this paragraph of the general comment, then we indeed see that the representatives who were drafting the comment submitted, for example, that the right of each individual to refuse to reveal their thoughts was based on the provisions of Article 17, the qualified right to privacy. And since the right to freedom of thought was clearly a private matter, and according with Article 17, no one should be subjected to arbitrary or unlawful interferences with their privacy. And this seems to imply that sometimes non-arbitrary and lawful interferences with the privacy of our thoughts could be permissible. And we also read in the drafting history, for example, that yes, religion is a private matter, just like thought. However, sometimes a person can be obliged to divulge their thoughts or beliefs. And this, I would argue, speaks against an absolute reading of the freedom not to reveal your thoughts, at least in the context of the general comment to Article 18. Okay, let's look at the third reason that is often invoked to substantiate the claim that the right to freedom of thought is completely an absolute right. And this is simply because the wording and the structure of Article 18 or Article 9 of the European Convention, they just do not explicitly allow exceptions to the right to freedom of thought. If you look at Section 3 or at paragraph 3 of Article 18, then we see that that paragraph, which is on the permissible limitations to the right to freedom of thought, religion, and belief, that paragraph 3 only applies to the freedom to manifest religion and belief. And that freedom is, according to this paragraph, subject to a variety of limitations if prescribed by law, necessary and proportionate, blah, 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 blah. However, paragraph 3 does not mention and does therefore not apply to the right to freedom of thought as mentioned in the first paragraph. And from this, some authors infer that because paragraph 3 does not apply to the right to freedom of thought, therefore the right to freedom of thought is completely an absolute right. However, I think logically and methodologically, this claim is at least open for a counter-argument. Because yes, as Martin Borowski, for example, writes in this paper, just a general paper, yes, written limiting clauses, they make clear that the relevant right is amendable to limitation and therefore not absolute. But the converse is, however, not conclusive, because limiting clauses may sometimes also be unwritten. So the fact that paragraph 3 of Article 18 does not directly apply to the right to freedom of thought does not necessarily imply, I would argue, that the right to freedom of thought is therefore an absolute right. Because it may well be that the right to freedom of thought could allow for some implied or implicit limitations. And the same we see back, for example, in the European Convention of Human Rights, just as a general idea. Janneke Geras explains in this handbook that several convention provisions do not contain express specific general limitation clauses, but still they cannot be considered to protect absolute and non-derogable rights. And examples of such unqualified rights that nonetheless are open or have been accepted to be open to implied limitations are, for example, the right to a fair trial in the European context, or the unconditional prohibition of discrimination. And in the international context, you can think of the right to culture and the right to privacy, which all lack explicit limitation clauses, but which are all open to some limitations because limitations have been read implicitly into these provisions. And perhaps that could also be possible for the right to freedom of thought. At least that is what I explore in the paper. Okay, then the million-dollar question, of course, is what are the rules or what are the principles that apply for accepting implied limitations to unqualified formulated rights? And as far as I know, there are no very clear or strict rules for that. And if you look into the case law, it appears to be more an issue of ad hoc legal and moral reasoning. But I do think that if you look at the case law of the European Court of Human Rights, that case law provides some interesting perspectives. Because what does the European Court of Human Rights say? It says that, yeah, when rights are guaranteed implicitly, so without setting them forth in express terms, let alone defining them, yeah, then there is room for implied limitations. Then judges could sometimes accept implied limitations. And I think this clearly applies to the three freedoms or rights that are implicit in the right to freedom of thought, and which are neither expressly guaranteed nor clearly defined in the convention or elsewhere. And another reason that, or another perspective that the European Court of Human Rights provides is that, yeah, sometimes they argue implied limitations can be accepted if a strict unconditional interpretation of a specific provision would reach absurd results. And as we already saw, a strict unconditional interpretation of the right to freedom of thought, at least if we endorse a broad scope of the right, will plausibly lead to absurd results. And because if we apply such a right in practice, a right of freedom of thought that applies to many different mental interferences, while at the same time the right is absolute, strictly unconditional, then applying the right would mean that it prohibits a variety of mental interferences, such as mandatory de-radicalization programs, but also the right may then prohibit some forms of medical treatment, even when there is a medical necessity, or even when such treatment aims to restore a person's freedom of thought. So what we could do, I don't say that we should do this, I'm just exploring possibilities from a legal point of view. What we could do in order to avoid such absurd results from applying the right to freedom of thought is to accept a limited number of implied limitations to the right. For example, in a very specific context of medical necessity, or for example, in the context when changing a person's thought, for example, through medication is necessary to prevent imminent harm to the person themselves or to others. Okay, finally, I think it's important to note that accepting implied limitations to unconditionally formulated rights, like the right to freedom of thought, will not mean that we give up absolute protection of the core elements of such rights. And this is because, in general, as a general rule in international human rights law, in no case may restrictions of human rights be applied or invoked in a manner that would impair the essence of the right in question. So the essence, the core elements of a right should always be upheld. And this also applies to the right to freedom of thought. At least it applies to Article 18 and Article 9 of the European Convention of Human Rights. Basically, it has been argued in the case law that restrictions of either Article 18 or Article 9 must never ever impair the essence of the right in question. So yeah, what could this mean for our understanding of the right to freedom of thought? Well, it could mean that just like other rights, just like the right to privacy and just like the right to personal integrity, the right to freedom of thought also has a periphery and a core. And that interferences with the core elements of the right to freedom of thought can never ever be permitted. They will always lead to a violation of the right to freedom of thought. And this challenges us to think about, okay, but what elements would or should be part of the absolute core of the right to freedom of thought? And some preliminary suggestions could be, for example, that punishing people just for what they think will plausibly interfere with the core elements of the right to freedom of thought. As may, for example, imprinting thoughts with neurotech without consent. And maybe you can think about some other examples. And if this is the case, if this is a compelling way to think about the right to freedom of thought, then perhaps this may imply that scholars should or could slightly shift their focus from trying to define the scope of the right to freedom of thought to also trying to define the essence of the right to freedom of thought, because it may well help us to think in another way about the permissible limitations that are or that could be accepted in view of this right. And Timo has already done some nice work on this, trying to clarify the essence of the right to freedom of thought. And I've tried also to explore this question a bit further from a legal point of view in these two papers. So thank you very much.
Thank you very much, Dr. Lichter. Congratulations. I invite Dr. Rachel McIntosh, please, for start your presentation.
Hello, can you hear me? Good, good. All right,
Yes.
I'm going to share my screen. I did create a PowerPoint here for this, if I can get this. Let's see. And share. That's not what I wanted to share. Here's, whoops. That's my actual talk that I'm going to give to you right now. But I want to show you this. Okay. Here we go. This might be a little janky how I do this. All right. Well, thank you very much. First off, I'm totally honored to be here today. I'm deeply honored. I'm the only US presenter in this category, and I'm addressing a really distinguished audience, so thank you. I'm Rachel McIntosh. My background is in defense contracting. And let's go to the next slide. Let's see if I can play this. Good. All right. Back. This is all messed up. I'm so sorry. Anyhow, let's. I don't know why it's coming in the different. All right. How about I just read this and then I'll show you the pictures. All right. My name is Rachel McIntosh. My background is in defense contracting, and it led the governor of my state, who later became the U.S. Commerce Secretary, to appoint me to the Rhode Island Geoengineering Study Commission. What I discovered there drove me to establish the Foundation for Bioethics and Technology, guided by one principle: progress without principles is catastrophe. Today's presentation is called Sovereignty Begins in the Mind, but let me clarify what I mean by sovereignty. I'm not speaking of state sovereignty or territorial control, but rather individual cognitive sovereignty, the fundamental right to autonomous control over one's own mental processes, neural data, and privacy of one's thoughts. This most basic form of human sovereignty is under systemic attack. Right now, as we sit here, brain-computer interfaces, emotion detection cameras, and AI systems trained on our private conversations are moving from research labs into our classrooms, workplaces, and homes. Your smartphone's eye tracking data, your smartwatch's heart rate variability, even the way you disrupt Wi-Fi signals as you walk through a room, All of this creates what researchers call biodata and neurodata, biological and neurological information that reveals your inner states. This data doesn't just watch what you do, it reaches inside, mapping your intentions, your half-formed thoughts, your deepest emotional responses. And here's the disturbing truth. No democratically elected body ever voted to allow this harvesting of the most intimate signals of the brain. But there's something even more troubling. The infrastructure itself is what we call dual use. The same cell towers, weather radars, and satellite systems that provide civilian communications simultaneously enable military targeting, surveillance, and command functions. This isn't accidental. From Doppler radars to 5G arrays, we have communications, meteorology, and weapon systems deliberately intertwined, blurring the line between civilian service and acts of war. The very infrastructure that promises to connect us is the bloodstream of a technocratic control system. This hits home close to me. I'm in my state of Rhode Island. Our former governor offered us up as a 5G test bed without any meaningful public input. Wireless facilities were placed directly in front of student dorms and working class neighborhoods. Residents had no right to object, no ability to shut them off, and no avenue for recourse. We discovered that the infrastructure promised to be a smart city technology was simultaneously capable of biometric surveillance, behavior prediction, and what NATO now calls cognitive warfare. Systems designed not just to influence what people think, but alter how they think. We're facing something unprecedented in human history. As global fertility rates drop below replacement levels, each individual mind becomes exponentially more valuable. Every perspective, every neurodivergent pattern, every gradation of human imagination is a non-renewable resource. Yet, just as our numbers contract, an industrial apparatus for harvesting our inner lives is expanding. This same AI systems now govern education, healthcare, employment, and we're built using years of our conversations, behaviors, and biometric data, collected without our awareness or consent. Think about this. If we surrender the unfiltered diversity of human thought to algorithmic extraction, we risk engineering a future where creativity is homogenized and dissent is predicted and neutralized before it can even be spoken. But there's hope, and it starts locally. 4 U.S. states, California, Colorado, Montana, and Connecticut, have already enacted laws recognizing neural data as a sensitive category, requiring explicit protection. Chile amended its constitution in 2021 to protect neural rights. This is proof that we can act, but we need more than aspirational principles. We need real, actionable, local, enforceable protections. And here's what we can do. First, education and awareness. You don't need a PhD to understand or to protect your own mind. We must make neural rights understandable and accessible to everyone, parents and teachers, students and seniors. Second, informed consent. Every platform that interacts with human cognition must be transparent about what data it collects and how it is used. No more fine print disclaimers for systems that can read your thoughts. Third, local action. Communities must have the right to opt out entirely from systems that extract neurodata or expose them to harmful radiation. Safe spaces, both physical and digital, must exist where people are free from manipulative algorithms. Fourth, bioethics by design, just as universal design made physical spaces safer and more accessible, digital and neural environments must prioritize safety, inclusion, and human agency from the ground up. The challenge we face extends far beyond individual privacy. With 5G and 6G infrastructure, the Internet of Bodies, and now the Internet of Minds, our environments are becoming saturated with technologies that emit electromagnetic radiation pollution, while processing neural signals and shaping human behavior, frequently without public input or impartial scientific consensus on safety. But here's what gives me hope. The very people whose data helped train these systems without their awareness or consent are now demanding meaningful role in determining how they're governed. And now I'm going to try to get my PowerPoint up so you can see it. All right, let's see, share this again. Okay, let's go up to the top. All right, so there's our introduction. There's me. And your mind is being harvested as we speak. This is one of our meetings. The Foundation for Bioethics and Technology is the group that I put together because I was appointed to the Geoengineering Study Commission, and I was a former defense contractor, and I didn't really believe in the geoengineering stuff. However, by the time we got all these are 4-inch binders, and all these are filled with real budgets, nothing's from the internet, like, it was real documentations. And then what we saw was that what was happening to the environment included aspects that were touching our biodata. So I created the Foundation for Bioethics and Technology. And here's one of our, and that's we started talking about. And big book here is The Battle for Your Brain. That's a big one, big hit. So the infrastructure problem became another big discussion, the dual use infrastructure. This is federal public law, and it's talking about wireless communication networks. And when it overlaps like this, it's a big conflict of interest. In Rhode Island, we got used as a test bed. Nobody had anything to say about it. And it just was placed everywhere. This is on a water tower in URI, University of Rhode Island. And the students were coming out and just because they felt the difference and they didn't know what was up, and somebody started passing these out. But the industry, if it's fun, if the study is funded by industry, they'll say, oh no, there's no effect. But if it's a non-industry study, and you can see there is a difference here. Also, what is being distributed is the lifeblood for this. It's dual use. I don't know how to explain this. It's dual use. You can have military using it. You can have the public using it. You could have the National Guard using it. This is coming out, and it's way over and a pollutant. It's all pollution. And AT&T, Verizon they can't get insurance. It's not able to be insured because it's a pollutant. And these are the levels that it affects your human body. So while that's all going on, the demographics shrinking on the planet, fertility rates are low, and the industrial apparatus is expanding as the population contracts. The bigger picture is this unprecedented moment. They're all built from our contributions. And now it's covering education, healthcare, and employment. But we have these states that have neurodata laws. Chile has its constitutional rights. We prove we can act locally, but we need real enforceable protections. And I'm making it my life's work at this point to help states, at least in the United States. We have the ability to create laws, and we can even do smaller than that too. You can have your condominium association, homeowners association, make rules that you don't want neurodata extraction in your area. So we got a 4-point plan of action with our foundation. One, we've got to do education awareness. You don't have to have a PhD to protect your own mind. You have to have informed consent. We've got to teach people about this. Transparency for all cognitive systems. You need local action, the right to opt out completely, bioethics by design. You have to safety, inclusion, and agency first. This is a toy. That's a smart toy. And this is going to have OpenAI in it, coming out soon. So, and once again, this is the list of this is what a regular cell phone needs, but we're getting slammed usually somewhere in this range, which is it's not good. Anyhow, but the main reason why I'm involved is because I was in defense contracting, and we have this situation with Palantir and cognitive warfare. That's why I'm here today. And my paper that I submitted has over 175 footnotes in it. And it's pretty long. It's shorter than the original paper that I wrote. And I'm very thrilled that it's going to be published. Thank you so much.
Thank you. Thank you very much, Dr. McIntosh. Congratulations.
Thank you.
Dr. Servida, could you please start your presentation?
Yes, thank you. I will just share my presentation. Okay, should be able to see it now. Perfect, thank you. So, good afternoon, everyone, and thank you, Professor Salardi, and the organizers for this great opportunity. I am Giulia Maria Servida, and I am a PhD student from Milan. I have the difficult task of speaking after other very interesting presentations that I've already tackled more or less some aspects I also had in mind. And also, as my colleagues, I speak after lunch. So I will just try to add some pieces and remain in my 10 minutes. Today, I will present on upcycling rights and tailoring laws to neurotechnologies. The outline of my presentation is the following. I will talk about how neurotechnologies are regulated around the world, and I will take into consideration both laws that are already enacted as well as proposals. Secondly, I will outline how they relate to institutional change and draw some geopolitical considerations. And finally, I will conclude on the features that a regulation on neurotechnologies might have. So regarding neurotechnologies regulations, several countries are starting to implement policies and laws to regulate neurotechnologies. And I try to carry out an analysis at the best of my knowledge in a similar way of the Swiss government did to artificial intelligence. And I try to take into consideration the different continents, and for each of them, the different countries or states that are implementing in some way. So whether it be guidelines or hard law or proposals, so in between something related to neurotechnologies. And the result is represented in the slide. So in the map, you can see the countries and the US states that in some way implemented regulations on neurotechnologies. Actually, in Africa and Australia, no countries have a regulation on neurotechnologies, but since they turned out to be vigilant on topics of neuroscience and neurotechnologies, I decided nonetheless to leave them in the map, so to keep an eye on them as well. And the situation is very heterogeneous due to geographical and socio-economic reasons, but also I saw a huge heterogeneity in how these proposals are drafted. And I decided to bring here for today an example of this heterogeneity. And I chose to confront, since a comparative analysis of all the proposals or laws wasn't possible, for time reasons, I decided to compare the definitions of neural data that has been provided in the US laws which are enacted or proposed, and in the European documents. And from the analysis, I saw that the definitions are diverse from each other. So they carry some elements which are similar, but as lawyers know, they are not identical. And so these, I believe, could carry many problems when implementing in a same country laws on neurotechnologies developed by one firm and distributed in different states. So how does this relate to institutional change? The fact that there is a huge heterogeneity demonstrates the fact that there is an attempt to regulate demonstrates that the process of institutional change has started, but the fact that they are very heterogeneous means that we are still in a middle phase, which some scholars call developmental phase, where many approaches and proposals are brought forward, but they still keep some level of ambiguity and questions. And this is what we are currently seeing. And we still need to reach the implementation or convergence phase where there is a particular design, in this case, a design of law of protection that we wish, which is legitimized more generally. And we see, in fact, that different countries have different perceptions of what should be allowed in respect to the regulation of neurotechnologies, and the design that will be legitimized. So the design that, as presented in the previous slide, will be the one we converge towards, will be strongly influenced by geopolitical forces. We have seen how Chile influenced many South American countries to take steps towards protecting fundamental rights in face of neurotechnologies. But now that the global attention towards this regulation is increasing, other states are becoming more relevant as well. In particular, the United States and China are leading nations in brain-computer interface research and development. And however, they tend to have contrasting approaches towards that regulation. Indeed, China, like Asian countries, tends to have a more open approach, favorable to development. Indeed, Chinese laws don't offer direct and explicit laws for neural data, and Asian countries as well, in particular, the example of Taiwan has the goal to become one of the leader nations in AI, in the AI sector. pushing towards liberalization of laws and experimenting, and we can assume it could have a similar approach towards this kind of technology as well. Whereas on the other side, the United States have a more regulatory approach, as we have seen from the worldview map, but it's still heterogeneous. And the European Union is still a bit behind on these general regulations. However, a general cooperation at an international level will be crucial to reach some sort of actual protection of the fundamental rights, which imply in some way neurotechnologies. And a problem will also be the implementation of an international regulation, which involves both high-depth states, which have a bigger discrepancy in between the rights they aim to protect and the actual protection they are giving, and low-depth states. But on the other side, an agreement that involves both these types of countries could bring them to push each other towards a bigger protection. And so here, to recap on this slide, a leadership in research and development of these technologies of a country which is less protective of fundamental rights as China could lead to the development of techniques and regulations that are not implementable within other countries, and leading to several consequences, such as economic and technological advantage to those countries. And finally, I tried to hypothesize what could be the features of a regulation. And for the considerations regarding this aspect, I decided to borrow a term from the fashion industry, which is upcycling. And upcycling means to transform the material or the form of an object, but not the substance. So I believe this approach could be of inspiration also in the case of law, as we should aim to keep the majority of the rights we have and transform their contours and their content through an evolutionary interpretation that keeps in consideration neurotechnologies as well, so as many other scholars suggested. And this approach would avoid the dispersion of rights and laws and urge to create new ones only when they are needed and only when the existing ones are not sufficient in protecting and regulating. And this is very similar to the fashion industry, meaning that also the residual and the new elements are only the ones truly needed, and also has implications from an economic point of view. Moreover, this approach would cohere with what has been suggested by scholars, in particular by Bublitz, that a regulation should cohere with what already exists and not merely repeat it, and reaffirm established human rights, emphasizing their applicability to neurotechnologies. And from an economic point of view and considerations, and here I applied some, I followed some economic scholars due to my part of PhD, which is more focused on economics. And they suggest in reference to contracts, but I believe it could be applied as well here, that a regulation in this case should consider keeping an incompleteness degree almost obliged due to the unforeseeability related to this kind of technologies and the cognitive limits of the human mind. And this would reduce also all the costs related to elaborating very precise regulations that actually are not able to grasp all the different cases that are going to come to us. And finally, it should consider incorporating corporate social responsibility standards, and through these encouraging responsible innovation and human rights impact assessment. Clearly, many more considerations can be drawn in this regard in the future, in respect of both to regulations at an international level, at a supranational level, and national level. But these were initial ones that I made until now, and I wanted to contribute with these. So thank you very much for your attention. And here is some bibliography that helped me arrive to these ideas.
Thank you very much. Congratulations, Dr. Servida. Now our discussion, Professor Lokait and Professor Farana. Please.
Thank you, Professor. Can you hear me?
Yes.
Yes, you can hear me. So thank you, Professor Betty Zaganelli. My name is Laukita, so this is for the sake of the clarity. As concerns the surname, I think we have 8 minutes, me and the other discussant, Professor Alessia Farano, right? So I guess I have 4 minutes and then she has other 4 minutes, or I don't know how it works.
But no, 8 minutes, 7 minutes you, Miguel, and 7 minutes Alessia. Sorry that I interfere, but okay.
Okay, we have this.
Because it was 15 minutes, so but we are running out, a little bit running out of time, but 7 minutes, 8 minutes is up to you.
Okay, good. Thank you very much, Silvia. So thanks to all the speakers. It was great to listen to you. I had the abstracts and only one paper, so the one of Raquel McIntosh. So I will go in order so that each and everyone has a few ideas that came to my mind. One thing while reading your abstracts and another thing while listening to you. Okay, so as concerns the first speaker, so Timo Istes, I'm not sure whether I'm pronouncing it correctly, so bear with me. So on the human rights perspective, it was, again, it's a huge pity that it was only an abstract, right? Because I think there is much more to it, and I could grasp only some of the things. So I was thinking a bit about you. At a certain point, you said that the state should think about the right to cognitive enhancement and who really needs it. And I was thinking, how do you decide who really needs it? So how do you operationalize this? So how you turn it into something that goes from the theory that, yes, the state should give it to someone who really needs it, but how do you do it practically? Okay, because I really believe that we are on the very kind of theoretical level. And what I thought is interesting in your talk is to see the dignity from the perspective of the human rights right to cognitive enhancement and the limitations thereof, right? I think it was really interesting because usually we take the dignity and we look from the perspective of dignity to these new rights. But now I thought, like, why don't we do the other way around? And I think this is where your work was, at least from my perspective, with due limitations, might be interesting. And as well, the idea of the self-determination, of the mental self-determination. I was thinking whether you're thinking a bit about the comparing to the physical self-determination, what we can do with our bodies versus what we can do, should do, be allowed to do with our brain, okay? So the physical determination, for instance, thinking about the organ donation, about the bellies for hire, you can do this, but you cannot do that. So whether these principles could function as well with the brain. The second speaker is your slide heart, the absolute nature. I was thinking about that you were referring to again, it's a pity I didn't have a paper. You were referring this to I like this unpacking of the right to the freedom of thought. And you said it's a powerful tool against interference without consent, but what if we have the consent? And in all those cases, I usually think about the consenting people and how this consent can have a content, right? So I think it's not a problem. It's much easier when there is no consent. Of course, we oppose and all those things, right? But when there is a consent and we know that this consent is not properly given or it's not properly, it's not a real consent. And what makes a consent real in this kind of context? And I had this feeling what you were making references, you were explaining the idea of the absoluteness of the right to freedom of thought. We were always referring to the states, but in neurotech, it's not about the state any longer, right? Or it is no longer only about the state. We're talking about the private companies, which become kind of partners with the states in doing things that they shouldn't do. So I think it's also something we need to think about carefully. The next paper from Raquel McIntosh, I think it's the only paper I have entirely, and it was an interesting paper in the sense that it wasn't that. It wasn't academic, right? Or at least it wasn't typical academic paper I'm used to in Europe, maybe, no? So it was kind of, well, fresh, let us put it that way. And I was like, wow, and this and that. It also gave me a lot of food for thought. It gave me lots of ideas. And I also thought that, is this a paper about the sovereignty, or it's a paper about the control? Because I had the feeling that it's about the control. These two themes, of course, are very much related. And you started by saying, yes, this is not the paper about the state sovereignty, but I thought, and why not? Actually, there is a very nice parallel, right? Because we are talking about the digital sovereignty in Europe. We are talking about the independence, about relying on your own infrastructure. So there is a very interesting parallel with the personal sovereignty that you are referring to. Okay. And I also was thinking about your suggestions. So the educational awareness, the informed consent, which again, I think are all very, very problematic because it all sounds good, but when, like, how to make it real, right? We have the Artificial Intelligence Act. We'll talk about the alphabetization, artificial intelligence literacy, but what does it practically mean and how can we really make it real? Because we fill our mouths with very nice words, but when it comes to the practice, we fail to connect ideas with the reality. And I think this is where we should do more. Of course, these safe spaces and bioethics by design, again, it is, I think your foundation as well is doing a great job in that, but I was wondering how can we do more, really more, and make people aware? Because sometimes I really believe that, we are in the academia, at least from the ivory tower, saying a lot of things, but we don't get to the public, we don't get to the citizens. And I think this is one of the tragedies. And coming back to the fourth paper from Julia, right? From Julia Maria.
Yes, Julia's fine.
Okay, I'm going a bit quickly. I think your abstract was very different from what you were presenting, at least what I got the impression, because in the abstract, you were putting some legal and economical point of view, which about the neurotechnologies, which I thought you have 2 PhDs on that, from the legal and from the economics, because it's a lot of things. And then you were talking about the ethical norms. So I thought, like, you're putting everything together, right? And I wasn't very sure whether I understand what you wanted to talk about, because you talk about the ethical norms, then you talk about the legal governance, and then you talk about the economic point of view. So I think you need to make it a bit more clear what you mean, right? And I also like this, the coherence, the ideas of the degree of incompleteness. So I was wondering whether you refer to the vagueness or what's this degree of incompleteness, and again, what exactly is meant. Again, it's only an abstract, and this is a very short presentation. So these questions, I guess, I wanted to know more, and I couldn't talk about that. And I think one of the ideas that you could actually get the good result from is when you were talking about the corporate social responsibility and the human rights assessments. So why don't we think about the neuro rights impact assessments, right? So we think about how the products, technologies, whatsoever, services impact people without infringing, without violating, without affecting negatively the neuro rights, however we want to understand those rights. Okay, and a general comment to everyone. I think everyone in this session, I think there is a big elephant in the room, besides Rachel, who was a little bit touching upon that, is the dual use, right? The dual use of these technologies. I think it's somehow, well, civil use or military use. We need to think about the military uses, because this is where these uses will be developed and then will, reverberate, rain down on all of us in the civil society. So that's all from me. And thank you again very much for inviting me, Silvia. It's great to see you again and great to listen to you all. Thank you.
Thank you, Professor Lokit. Thank you. Professor Farano.
Yes. Good afternoon to everyone. Thank you very much.
Good afternoon. Good afternoon.
Okay. So first of all, I would like to thank you, Silvia Salardi, for the kind invitation and all the people who joined the seminar. I will start with the first presentation, the one by Timo. It is a complex dynamic, indeed, the one between empowerment and, or we might say, cognitive liberty intended in a positive way, as you suggested, and constraint. When we talk about enhancement in general, the appeal to an intangible human nature, the tricky appeal to this normative idea is always around the corner. And of course, it is very important to take the opportunity to reflect on the current meaning of human dignity, as you suggested in the end, and of human nature. But I also think this is a very risky argument. Sometimes the concern is to protect a certain image of humanity, of human nature, against manipulative neurotechnological interventions. And but I think that it's also important to stress the limits of a naturalistic argument against enhancement and to relocate, I would say, the topic within the political and the legal discourse. And from the political philosophical point of view, this relates, I think, with the presentation by Rachel McIntosh. I will go back to Sier's presentation. Sovereignty begins in the mind. As far as neurotechnology governance is cut out from the democratic validation, we will have a problem, no doubt. I wonder whether the ethics by design approach is the right answer, though. And I'm also referring to what has emerged this morning. Rachel, in her paper, mobilized Michel Foucault's idea of biopolitics. I think biopower and biopolitics are really helpful tools to read today's shifting from government to governmentality. And the exploitation of biometric data and our mental data totally fit this narrative. But what we also learned from Foucault is the warning that by, I would say, pulling aside one question, one big question, by delegating to the authority of science, technology, but also, I dare to say, to the authority of bioethicists, is risky because it kind of deactivates the democratic validation. So the experts become the rule makers. So I do feel the need for a better interaction between neurotechnology and neurotechnology scientists and decision makers, but always under the democratic legitimacy as far as it is possible. From the legal point of view, and I go back to Sier's presentation, I think this was a really valuable contribution to the legal conceptualization of these new rights. So it is really important, in my opinion, to challenge the absolute nature of the right to freedom of thought. Even if I completely disagree with the Bublitz 2014 arguments, I mean, the state has certainly the power to interfere with people's inner thoughts, but not the right. And it puts together I think, very different levels of interference. But this is for another discussion. As for Julia, I learned a lot from your presentation. Thank you very much. And also thank you very much for the beautiful images, as always. And I totally agree with the idea of reaffirming existing rights in order to avoid, as it has been said, the inflation of rights. And on this note, let me just add a suggestion to the debate. I think we should start as lawyers by exploring all the available solutions to protect individuals from predatory behaviors coming from neurotech companies. And this includes also the property rights framework, which allows, in my opinion, more enforceability and also speaks the language of private actors. Sorry for this brutal consideration, final remark. So thank you very much.
Thank you, Professor Farano. Professor Salardi, please.
I've seen that there are 2 questions in the chat. We can do that if we can, if Douglas can read them.
The first question is for Dr. Lighthart. Do you think it would be helpful or detrimental for democracy to use brain scans, cognitive tests, to prevent incompetent and/or malignant people to hold office? To what point does the freedom of thought and identity could be limited by an implicit permissiveness to do harm?
Okay, thank you very much. So let's start with the second part of this question, which I interpret as meaning, okay, could there be situations that the state may be allowed to interfere with the person's freedom of thought in order to prevent harm to the person self or to others? Is that right? Yeah, I think that's a very interesting question, and I don't have a definite answer to it yet, but I tend to think, and I tend to explore at least the argument to say that, yes, sometimes in order to prevent severe and imminent harm to another person, it may be allowed for the state to interfere with the person's freedom of thought. And if you look at current practices, we actually do. If you look, for example, in practices in prisons, for example, when a prisoner gets very aggressive, or when a psychotic person in forensic psychiatry gets aggressive, sometimes we administer certain neuropharmaceutical drugs in order to ease down the patient with the view of preventing imminent harm to another person or imminent harm to the person self. And these drugs normally operate via biological processes in the mind. They may impact a person's thought, for example, a delusion. So from that perspective, I think, yes, sometimes in current practices, we already interfere with people's inner thoughts in order to prevent harm to others. But we don't usually think about such practices in terms of the right to freedom of thought. And usually we think about those practices in terms of the prohibition of ill treatment or the right to personal integrity. And I do agree that it would be very, very valuable, at least if you would like to clarify the scope and meaning of the right to freedom of thought, also to look especially at these difficult cases and try to explore, okay, what are the arguments in favor of it, what are the arguments against, and how should we weigh these arguments. And I think only then, if we face these difficult cases, I think then we can move on and set a further step, set the next necessary step in further developing these rights. So thanks.
And the next question is also from Diego Saldivar. He says, on that note, a question for the panel. How could a hypothetical society using brain data to keep malicious people from power prevent abuse and falsification from malicious actors hijacking the very safeguards trying to keep them out? Let's say someone falsely alleges that a presidential candidate is sociopath.
I can try to tentatively formulate some thoughts about that. Interesting question. It's a very hypothetical question in 2 degrees, I feel. First, the hypothesis that there would be a system in place which keeps malicious people out of power using brain data, and then other parties maliciously taking advantage of that process. But I think that they both actually come back to the acceptability of this first hypothesis. Could we ever allow a system to be in place that uses brain data to keep malicious people out of power? I think that already is a very contentious, would be a very contentious system that already risks violating people's right to privacy and people's freedom of thought, specifically because it might be very, when we would just assume in the light of the right to privacy, for example, the fact that such systems are so vulnerable of being misused maliciously by other people, and that has such far-reaching consequences on other people, already makes that the proportionality of such system can be very much debated, and the bar for such system to be in line with the human rights framework seems very, very problematic to start with. So I would say that the second hypothesis shows why the first hypothesis is already so problematic in the view of constitutional and fundamental rights.
Any questions, Dr. Binder?
I think the questions are finished.
Thank
Have finished. So.
Thank
Now, I see an hand raised by Sears. Is that right? Okay, you want to answer? Yeah.
No, I just had a question. So I had a question in response to Timo's talk. Thank you very much for it. So I was wondering, just a very general question, but so when we talk about, so today again we talk about human rights for the mind, and we tend to frame them into neuro rights, and we tend to talk about them mainly in relation to emerging technologies, specifically neurotechnology. And from that perspective, we think about a right to freedom of thought, a right to mental self-determination. But if we take one step back, so I completely agree with most of the things you said about developing a right to mental self-determination. I'm wondering what would be the implication of such a right be? So if we have a right to mental self-determination, it is a general right. It does not only apply to neurotechnology, for example. Plausibly, it mainly applies to many other different types and methods to enhance our cognitive abilities, such as the use of psychedelics, for example, which is prohibited in many jurisdictions. And you can make an argument against such prohibitions. Do you think that the right to mental self-determination, as you are trying to conceptualize it, could add as an argument against, for example, state prohibitions of psychedelic drugs? Thank you very much.
Yes, thank you, George, for that interesting question, because indeed it affects far more than only the neurotech debate. You already kind of answered or went along the way of my thoughts on this, that I don't see this right to mental self-determination necessarily giving or generating other practices in different jurisdictions. That necessarily this means that psychedelic drugs or other kind of drugs would need to be not prohibited, that they should be available for anyone. But I think it's the right to mental integrity would be an important element for states or other regulatory bodies to take into account, to make sure that they think about it, the existence and people's interest in taking sovereignty or taking control over their own mental abilities and own mental faculties. So I think in that light, regulators should really be able to point to legitimate aims for prohibition and indicate why it's really necessary to limit access to these technologies, to these drugs, and so on, to reach those goals. And often, I think, in the case of drugs and pharmaceuticals, public health and public safety would be a legitimate aim that really plays an important role, but that needs to be made explicit, and also the measures in regard to that aim should be proportionate, and that should be clearly stated and clearly argumented by the regulators. Yes.
Any questions? So I thank you all, and we conclude this section. Congratulations.
Thank you. Thank you very much, Margaret. Thank you to the speakers, the discussants. So we can move to the fourth session that will be moderated by Tadej Spranger, University of Bonn, Germany, and member of the editorial board of the BioLaw in the 21st Century, edited by Triven Publishing. So Tade, the floor is yours.
Yeah, thank you so much for having me. To be honest, when I started working in the field of neurolaw almost 20 years ago, we had a strong focus on, the Libet experiment and free will, whether or not there's a free will, and lie detection methods going to the courtroom and no lie MRI and stuff like that. But as a trained constitutional public lawyer, I'm always curious what the experts have to say. And now we have a really splendid panel, and many experts are talking to us in a minute. So we are a couple of minutes late, but I think this will not be a problem for us in particular, as we are all scientists and we're used to that. So we will deal with that in a proper way. So the first talk will be given by Valentina Valenti and Alessandro Manfredi. And Valentina, as far as I know, she studied law at the University of Calabria, where she obtained her degree in law. And then she was associated with a law firm specializing in criminal law. But she has also been a research fellow at the University of Macerata. And she's also a doctoral student at the University of Magna Grecia in Catanzaro. And Alessandro is as far as I know, PhD candidate who already published in a high-ranking journal. And as I'm also working in the field of data protection law, I'm really I will copy that and I'll read that paper dealing with Article 8 GDPR and the problem of the protection of minors. And both of them will talk about privacy from positive law to challenges in criminal proceedings. Then the second presentation will be given by Martina Greppi, and Martina graduated in San Carlo, and then she completed her law degree at the University of Modena and Reggio Emilia, and she is currently completing her legal internship at a law firm, and she's also working in the field of criminal law in the academic landscape. And she will talk about the neuroscientific rules of criminal sanction in restorative justice system. And then the third and final talk will be given by Riccardo Segate, who is who has a really strong profile, to be honest. He held various visiting positions all over the world, to put it in a nutshell, too many of them to mention them all. He is a social legal researcher and policy consultant when it comes to technology regulation and public international law, as well as bioethics and IPRs. And he's currently a postdoc in epistemic injustice at the University of Groningen at the Faculty of Economics and Business. And then our discussants will be the list of discussants will be slightly changed. As Christina wasn't able to make it here, Celia will take over, and I don't have to introduce you. You are the head of this event, and you organized that beautiful event for us. So of course, everyone knows you. And then the final and the second discussant will be Professor Field, who has a really long academic career. So he graduated in the field of biological anthropology mid-1970s, and at the end of the 70s, he was also at the Columbia University School of Law, where he gained his JD. In 1980, he received a Master of Public Health at Harvard Chan School, and his PhD finally in 1987. Many memberships in all the relevant scientific associations, many presentations, many papers, many books, and so on and so forth. So really a splendid panel this is, and I'm really looking forward to our first presentation. So I hand over to Valentina and Alessandro, and we're looking forward, and the floor is yours.
Thank you very much, Professor, for your introduction. Good afternoon. First of all, sincere thanks to the University of Milano Bicocca, Itexedu, Triven Publishing, and all the organizers of this conference. It's a great honor for me to be here. It's also my first conference in English. Therefore, I would like to ask the audience to be lenient with my spoken English. My name is Alessandro Manfredi. The paper being presented today, co-authored with my brilliant colleague, Dr. Fenice Valentina Valenti, highlights the context-dependent nature of the neuroprivacy debate. It offers an analysis showing how the sufficiency of our current protection is assessed differently in private law versus the distinct sphere of criminal law. The first part of this presentation will examine the private law perspective developed in the paper, before passing the floor to my colleague for the criminal law analysis and conclusions. To frame the problem, the paper's analysis begins with an examination of the dual roots of privacy in the Western world. These distinct origins are crucial to understand our current dilemma. The first is the Anglo-Saxon tradition, famously articulated by Warren and Brandeis as the right to be let alone, rooted in the liberal philosophy of Locke and Mill. It conceives of privacy as a shield, a defensive right of use excluding alios against intrusion by the state or third parties. In contrast, the continental European tradition is grounded in personalism. Here, privacy is not just a shield, but a means to protect one's own reputation and identity, constituent elements of personality. This is visible in concepts like, for example, the German Allgemeines Persönlichkeitsrecht. The papers in that regard shows of both of these paths have largely converged into the same modern definition of right to data protection, as set, for example, by Alan Westin or Stefano Rodotà. This evolution set up our core dilemma. Should neuroprivacy be seen as a modern form of the right to be let alone, protecting us from direct mental intrusion, or is fundamental specification of data protection concerning the control over all mental data? The paper argues that, for now, the most pressing challenges lie in the domain of data, not direct intrusion. In the paper, a critical distinction in that regard is drawn between two scenarios. The first is the active invasion of mind, or brain engineering, the consistent in the direct technological modulation of our neural processes. And while this active innovations realistically looms on the horizon, particularly with invasive technologies like brain-computer interfaces, it is not yet a widespread reality. The second and far more current threat for me is the passive invasion of mind. This occurs not through brain engineering, but through social engineering, fueled by the constant processing of our personal data. Today's consumer neurotech operates in this area, from, for example, smartwatches detecting stress or EEGs for wellness. They don't read thoughts, but infers mental states from a wealth of neural data and proxy data. For this reason, data protection law is presented in the paper as the most suitable legal framework for the current reality of neuroprivacy. However, simply invoking data protection law is not enough, because mental data presents unique challenges. This kind of data, for example, non-pathological emotion, does not fit neatly into the GDPR's special categories of data, ex Article 9, for example, like health data, creating a potential gap in protection. To address this, a more pragmatic approach is proposed in the paper, analyzing mental data based on its multi-dimensional nature. The true risk comes not from the data itself, but from the inferences drawn from it. A useful analogy is the legal distinction between a biological sample, like blood, and the sensitive genetic information extracted from it. The raw brain signal is the sample, the inferred thoughts is the sensitive information. The analysis, therefore, identifies 3 key axes of risk. The first is the source of the data. For example, are data direct neural signals or, for example, indirect bilateral proxy? The second is the level of the inference. And the third is the data subject rule within the data collection. For example, was the data actively generated by the data subject or passively collected, weakening the notion of consent? Based on this framework, the papers advocate for practical tools within the GDPR's logic to mitigate the overruling, like, for example, mental data protection impact assessment introduced by Yenka and Malgeri. This instrument will compel controllers to engage in a form of proceduralized caution, assessing the multidimensional risks ex ante and embedding protection by design. The floor will now be passed to my colleague, Dr. Valenti, who will address the criminal law context and our divergent conclusion. Thank you very much for your attention.
Good everyone. Good evening to everyone. Sorry. First of all, I'm very quickly, because I know we are on late, but I want to say thanks to entire organized committee for having me. So thanks for Professor Salardi, and also thanks to Professor Spranger for introducing me. And the last, also thanks to my colleague Alessandro Manfredi, because he's always so kind, even if we completely disagree about discuss about the new rights, the neuroprivacy, and the opportunity to discuss about the new class and new rights. Well, I think our disagreement is referred to comes from our different background, because when you focus on about civil perspective, it's completely different from the criminal one. As maybe all of us know, one of the very traditional tendencies of human in the criminal science is always dreams come into mind to try to understand what the author of crimes can really want, what he was thinking about. When we talk about the neuro rights, always in criminal science and in general, the criminal proceeding refers to many important profile, from the liability to mental capacity to opportunity to create and use the evidence. So if in the past, try to come into mind what's considered an insurmountable barrier because it was so not possible to come into today, thanks to American companies and very beautiful many others, it this distance between machine and brain are completely now not so far. So now, thanks to brain interface and other instrument neurotechnology, we have a new data, the neural data. And my question, when we come and shift in the criminal proceeding, I think we have many problems. And actually, I don't know if today I can try to answer to all of them. Maybe we can try to think about them. The first thing is, how can we use them, and what is the limit about the self-determination of their owner? Because how many other scholars said in their studies, one of the very main problems is how we can protect the self-determination on the owner. And what happens if maybe some company where the neuro data comes from, especially in the medical sector, are be used for different interests. So not for the medical one, but maybe to be sold to other companies, or maybe for economical interests. So how can we use them? Maybe even they come into the criminal trial to be proved to protect the victim one. So I think that our answer can be a little bit different, because it refers the function, how we can use them. So first of all, for sure, if we want to use data and neural data to try to understand and to come into personality, criminal personality, our Italian legal system already have many rules that limitate this useful, because there is many rules. For example, to the 221 20 for that not permit to use criminal expertise in the criminal trial if you try to understand the personality, because you have to consider and elaborate all evidence in the criminal itself and not the crime of author, because it's completely different. Yes, the terms can be changed after the sentencing, but in the trial we have a limit. And another one is that even the proof is taken with the violation of self-determination, or you try to force in the witness, because maybe with the mental one that he without his consent, because he's willing, you cannot use it. So if there is any two limits that maybe can help us to protect the mental privacy, maybe question can be a little bit different if we move in a European perspective, because actually for the moment, neuro privacy or neuro mental data are not so common in the trial. So maybe for now, our rules maybe can be enough to try to limit and protect the data, because also we have an umbrella right from our constitution to supernatural right that maybe can be enough, but maybe for the future not. And especially actually, if we look to the union legislation, we don't have enough or a complete legal framework that can help us to try to limit the power of authority. Because when we move, and this is why we are completely disagree, when we move from the civil one to the criminal one, we change our term of discussion, because there is not people by people, but we have authority and people. We have the power of the authority, the public prosecutor, to come into your mind and use your evidence. So every single violation of the private intimate sphere must be completely regulated in every single aspect. This actually we don't have even in Directive 681, 680, the 2026 in the union directive, because they don't really have complete regulation, especially because they want to balance the freedom of authority to try to not be influence or try to put limitation on them jurisdictional ones power. So maybe for the future, I think that we need a complete path of guarantee criminal proceeding rules that must be complete necessary balance with the power authority and the fundamental rights. Maybe for do that, maybe a new class of rights, and especially neuroprivacy, must be declined. Thanks to everyone.
Alessandro, Valentina, thank you so much. I would love to ask you several questions, but I'm just the moderator. So therefore, I will keep my mouth shut and hand over to our second presentation by Martina Greppi. So Martina, the floor is yours.
Okay, thank you, everyone. I hope you can see me and hear me correctly. I'm Martina Greppi. I'm a PhD student from Università of Parma in criminal law. And thank you, first of all, Professor Salardi, for inviting me today and giving me the opportunity to discuss about this topic. Specifically, my discussion will focus on the neuroscientific roots of criminal sanction, but from the perspective of the restorative justice system. So I understand this is a very broad topic and in my opinion, extremely delicate, but given the time available, I'll do my best and I convey the very main key points. So let's start from a general premise. For centuries, criminal law has been built on the idea that there is a so-called homo juridicus, which is a rational, free, and morally responsible individual. And since being rational, he's also able to distinguish right from wrong and to weigh costs and benefits while deciding how to behave. And moreover, is someone who can exercise self-control. So since they are capable of self-determination, they can also be held accountable and punished. So from this perspective, from this point of view of someone who can foresee the consequences of their own actions and control themselves from acting, punishment is justified as a deterrence. So theoretically, the threat of a sanction should be enough to discourage any criminal action. But this is not actually how human beings work. This is where neurosciences actually come into stage. Because neuroscience, thanks to the brain imaging techniques, paints a more complex picture of human being and human behavior in general. Our actions are not always the product of cool and rational calculation. Actually, they are often shaped by unconscious brain process, emotions, and biological predispositions. Mere mathematical and mechanistic processes cannot operate by themselves in decision-making because the responses given to a problem essentially depend on how an input is brought to an emotional level and how it's processed emotionally by the neurological system. For example, the limbic system drives emotional impulses, while the prefrontal cortex, which is the executive brain, also has to regulate them, which means that if the prefrontal cortex is kind of underdeveloped or impaired, impulses control weakens. This means that the criminal behavior may sometimes be also linked to neurological dynamics and that are outside our full control, conscious control. So the question is the criminal offender always the rational agent that our contemporary law criminal system assume? Criminological neuroscience investigate this topic. They study how biological and genetic predisposition interact with social environment to produce crime. So just to be clear, there is no something like a crime gene, there is no predetermination for violence, okay? Nothing like Cesare Lombroso. But still, neuroscientists highlight that biology matters. For example, some individuals may be biologically more sensitive to aggression or less able to empathize. And yet, whether this predisposition lead to violence depends also heavily on the environment they live in. The neurocriminologist Adrian Rain describes two different scenarios. When it comes to adverse environments, like people who live in poverty and abuse and marginalization, social factors dominate. On the other hand, when it comes to positive environments, so where there is no kind of social pressure, biological predisposition become more visible. So crime and violence are not caused by a single factor all alone. They are always the result of the so-called biosocial puzzle. But in this biosocial puzzle, biological and social factors fit together, and this means that also biology is a fundamental jigsaw piece of a wider puzzle, okay? Now let's make a further step. Law assumes that people can perfectly know the difference between good and evil, but neuroscience shows that even this moral sense that guides human actions and choices are rooted in a biological substrate. I can mention the famous experiment carried out by Green and Haidt on the so-called trolley dilemma that showed that rational and emotional circuits can produce very different responses to moral dilemmas. In short, emotions are not antithetical to reason. They do not disturb rationality. They are actually more like a fundamental part of the decision-making process. And also empathy as well plays a fundamental role in decision-making. Biologically speaking, empathy is due to the so-called mirror neurons that allow us to feel what other people feel only by watching them. And about that, I can mention the studies of the neuroscientist Daniel Razel on psychopathic offenders. And these studies revealed a gap in the system because he realized that even though these kind of offenders could recognize emotions on a cognitive level, they could not actually feel the emotions, which means that this is the so-called emotion paradox. And even more interesting, he understood that empathy can be strengthened and can be encouraged when through positive environments and positive social interactions. And this capacity is due to one of the most important discoveries of modern neurosciences, which is neuroplasticity, which is the brain's capacity and ability to reorganize itself, to form new connections, and to even generate new neurons, which is the so-called neurogenesis. This means that a change in our behavior is always possible even in adulthood. But this means that environments has matter enormously on our biological composition. Positive social interactions, education, and stimulation can actually foster self-control and empathy. And on the other hand, of course, when it comes to stressful situation and traumas and isolation, like, for example, experience that, such as those that were experienced by people in prison, okay, that can actually damage the brain and reduce the ability to change. So this, of course, is kind of a paradox because those who most need rehabilitation are often placed in environments that make any kind of rehabilitation neurologically less likely. So given this, we must ask, what sense does punishment make if it limits and it damages the very capacities we want offenders to develop? Traditional punishment, especially prison, of course, is mainly a retributive kind of sanction, and it inflicts a sufferance but often fails to deter or to rehabilitate. And it can also reinforce the very deficits in empathy and self-control. So in this scenario, this is where we actually understand the importance of restorative justice. And this is the real core of my discussion, because as we all know, restorative justice not doesn't want to punish the offender, okay? It's more on repairing the harm caused, to rebuild relationships and to reintegrate the offender into society. It works through dialogue and through the admission of responsibility and emotional engagement. And all of these processes actually stimulate empathy and moral reflection and social bonds. So from a neuroscientific point of view, this makes perfectly sense because restorative justice model activates brain plasticity and it encourages positive rewiring. Offenders learn self-control, which is something that, as we've seen, is considered to be natural, but it's not. It's something that we develop not through the severity of punishment, but through social interaction. And moreover, this approach preserves the offender's moral agency because they are not just passive victims, but they are capable of change. So just in conclusion, we show that the crime is a result of a complex interaction between biology and environment, and morality, empathy, and self-control are deeply rooted in the brain on a neurological level, but are also something that can be developed thanks to the plasticity of the brain that lasts throughout most of our lives. this knowledge changes the foundation of the retributive punishment because it invites us to imagine a neuro-informed justice system and that consider biology aspect of our behavior and also uses this to foster rehabilitation. So restorative justice actually has some scientific roots, and they also offer the most promising way forward, punishment not just as mere sufferance, but it opens the door towards a more prosperous future. Thank you.
Thank you so much for the splendid presentation. With regard to the time frame, right on spot. So thank you so much for really beautiful thing. And I can imagine there are many questions and remarks, but we have to go further first. And I will hand over to our third presentation by Riccardo Segate. And Riccardo, the floor is yours.
Okay, thank you very much. Can you hear me? Can you see the presentation? Okay, great. So thank everyone, and particularly the organizers, all the more so as this is actually a published paper. It was published 1 year ago, but for some reason I only presented it once. So I thought this was a wonderful opportunity to present it again. I think it's meaningful within my trajectory, even though it's a self-standing paper. It's not part of a, let's say, of one of my core works or appointments, and it explores whether we should rethink criminal justice, the criminal justice system around findings on epigenetics, along similar lines as the one that the previous speaker was also exploring. This is the published paper with criminal justice ethics. So when I came to research for this paper, I was actually in Dundee for a project on robotics. I was a postdoc there. But as it usually happens, so for context, I'm a lawyer by training, but I also study formally. I'm pursuing degrees on biotech and also engineering. That's because I want to write deeply when I engage with interdisciplinary legal thinking. I don't want to just stay on the surface. And I tend to explore very proactively, even with schools that have nothing to do with my actual work. So I was in Dundee affiliated with the School of Engineering and Law, but then there is the School of Life Sciences, which is specialized on computational genomics. And so this paper stems from conversations that I've had with these researchers, and it really enlightened me in several ways. There is a strand of research also by myself on some cognitive issues related to neuroenhancement, to cognitive bias, generally related to the impact of new technologies or new scientific discoveries on the epistemics of law, international law more particularly. In this case, it's not international law, but on the epistemic implications of science and technology in law. So whether we should accommodate these new developments, and if so, in what ways, and what are indeed the implications for all actors involved. Now, when we think about punishment, right, we ground punishment in a fair opportunity that the defendant had to choose otherwise. In other words, we punish because we ground this idea of punishing in the possibility to do something different from what was actually done. And the traditional purposes for punishing, of course, are deterrence, retribution, but also keeping the public safe, and also the emotional satisfaction of, for example, the parents of the victim, the relatives, and so on. And all of this derives from a millennia-long debate, on folk psychology, common sense, customs, and these have been ingrained into our legal philosophy over centuries, and they've mostly stayed the same, right? But most recently, the natural sciences started to step in very vigorously, and this started indeed with the technologies, neuroscience, neuroevidence, and so on, that were also touched upon by previous speakers, including the last one, the latest one. And so computational psychiatry as well. And some of the implications of this is, for example, rethinking the concept of retribution. If this evidence suggests that defendants couldn't really do otherwise from what they did. And rethink deterrence as well, because if one cannot control it, then you cannot deter the behavior. And also the public order aspect of punishing, because if confinement makes them worse, then there is no point in confining them. There is no point about putting them in prison, right? And indeed, there have been a few proposals around it already, broadening the mental insanity defense, providing a generic partial excuse, alternatives to prisons, milder convictions, reliance on holistic intersectional proportionality appointments by criminal judges, and so on. A lot of literature around this. Now, what's the point of epigenetics? Well, in some ways, epigenetics holds a promise that is even more disruptive. In what ways? Now, violence in epigenetic terms can be explainable as gene expression regulated indeed epigenetically. The idea that punishment could be rethought was already enshrined in the debates around neurorights. The novelty with epigenetics is that some epigenetic traits can be inherited and can also be reversed. So you see that epigenetics may be factored in as an aggravated factor at sentencing, because it could say, well, you are inflicting harm that will last for generations. But it could also be an exculpatory mitigating factor for those defendants that have suffered violence themselves and are replicating violence because they have it written on their genes. There are extreme examples that one can make, right? So one is Mr. Ongwen's, is a very famous case before the International Criminal Court. I'm not telling the story, but I would say violently interesting. This is basically a guy that in this life has seen and witnessed and experienced nothing else than violence. When he was a child, he was forced to drink blood. He was under narcotics. His family was burned alive in front of him. He knows nothing else other than violence since the time he was born. And of course, he replicated that violence as well, doing things that are just as terrible. The case was very interesting because one of the ideas, one of the streams of argumentation, not only for the defense, but from himself, was, look, you come from Harvard, you come from Berkeley, you come here and you judge a man that has known nothing else than constant violence from the time he was born. How can you think you can understand what that means and what the implications are for my responsibility? Now, one interesting thing is that this case was discussed based on folk psychology, very, very superficial psychological evidence, psychological assessments without any natural science counterpart, not even in neurotechnological terms, if you want to put it that way. Just very narrative ways of describing the implications of suffering, of trauma, of violence, structural violence, and so on behavior. And the other one, the most famous, of course, is the Holocaust and Gaza, that look appallingly similar in many respects. So in both cases, folk psychology would say, well, the duress that the perpetrators experienced throughout their lives reverberate across generations as structural hatred, and they tend to be replicated. But epigenetics adds a new layer to this, because it says, well, it might actually even stay written onto our genes. And if it is written, well, then it might also be unwritten. So you understand that we are a step very much further compared to just the neurosphere, which is confined to us as individuals, but is not as naturally grounded as epigenetics. So what is epigenetics? Well, okay, so this is a bit complex, but in very simple terms, epigenetic markers are chemical elements. There are substances that can be added to our genes without modifying the structure of the gene, but allowing or repressing its expression. Okay, the most famous are acetylation and I would say acetylation mostly, but also methylation. So methylation inhibits genes, their expression, while acetylation enhances I would say enhances that expression. A very clear idea, you can get it from here. This is chromatin, and here it's very condensed around the histones. So the histones are not open enough to be read by the the transcriptional machine, which means that those genes will not be transcribed. And instead, here you see that it's more open. Now, there are many mechanisms, but the key point is these are extremely precise natural elements around transcription. Now, how is it inherited? Well, it's inherited in the sense that it appears to be mitotically stable. In other words, we don't inherit only the genes, but we also seem to inherit certain patterns of expressions of certain genes over others in each individual. Then retention times might not be predicted as easily, but that's for another question. Now, how is it reversed? Because epigenetic markers might also be reversed in some way. This is extremely complex, but you don't need to go after each cell, of course, and reverse one epigenetic marker at a time. There are certain types of cells, certain types of tissues that most frequently express certain types of epigenetic markers. In other words, there is certain room for acting on this matter. This is the takeaway message that we have to get from a legal or philosophical perspective. And indeed, you can think about it as a sort of informational machinery that switches on or off the expression of genes. Just think about a transistor. It's the same thing, you know, it switches on and off the passage of information. And this is a very wonderful, I would say, a Nature Communication paper that says, hey, do you think the memory, not the memory of just events, but our biological memory, what our cells remember from what happens to our lives, okay? Do you think that that is only a matter of neurons? Well, think again. There are many, many ways in which many different types of cells beyond neurons store information in a way that we might define as memory. So you see that all the things start coming together. Now, the research questions around this are kind of framed around rethinking the justice system, in the sense that there is a lot of literature generally on epigenetics, nature versus nurture, what that means for law. But my questions more specifically in this paper were, should we accommodate epigenetic evidence within criminal procedures and proceedings? And also, should we rethink more broadly and more profoundly the criminal justice system as a whole? Well, we could do so, even though, so there are, I think, two questions here. Could we do this and should we do this, right? So these are very different questions. On the could we side, I would say yes, though there are a lot of open questions. We have to be careful about the actual implications that can stem from epigenetic evidence. We have already known at the early stages of neuropsychiatric evidence what happens when you submit to courts evidence that they are not prepared to handle. But you know, over decades, I think neuroscience has become a more structured and more structural type of evidence within certain types of procedures, especially in certain jurisdictions that are more scientifically ready, let's say. But there are ways to make it sound over time. So generally, when we might say yes, there is room for epigenetic evidence to enter the court. And another question would be, okay, let's assume that epigenetics means that offenders might be rehabilitated. Should that be consensual, or should that be compulsorily charged to defenders in the event that reversing their epigenome was actually possible? So these are questions, these are open questions, of course, that I explored in the paper. But when it comes to could we, the answer is, well, we could. I mean, theoretically, technically, there is no real reason not to. But of course, another stream of arguments revolves around whether it's socially attainable.
Riccardo, sorry for interrupting, but we are running a bit out of time, so maybe
okay,
you can
right.
Put it in a nutshell. Thank you so much.
Yeah,
Sorry for interrupting.
no worries. So whether it's policy desirable or not, what this means for free will, for example, because one could say, well, but we are going down that usual deterministic thing, right? So there is something genetic, there is something epigenetic, blah, blah, blah. And so this explains our behavior, and so we are not culpable. But epigenetics is a bit more powerful than this, because it says, well, you can choose, for example, to reverse, you can choose to modify the environment structurally, and so on. So it's a step further in many ways. And also societies are structured in a certain way, even if there was no free will, let's assume, but there are maybe good reasons to pretend that there is free will. Otherwise, people would act even less responsibly. So these are all the questions that I explore in my paper. There are also new inequalities. For example, certain treatments might be available to only certain segments of the population, and so on. There are gender implications as well, because one could blame then the mothers for the environment in the uterus and what that means for their bringing. But it could also have implications for men in many other ways. So there are a lot of implications. So the conclusions in my paper. So I really speeding up a lot my second part, but. The conclusions of my paper basically are, okay, science has been long creeping in when it comes to theories of criminal culpability and punishment. A lot of things are not new, because the idea that we are a bit determined, that we can explain, that we can exculpate, blah, 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 this is already explored in the neurosciences. The epigenetics thing is much more revolutionary in potential. There are a lot of open questions, but let's say the potential for it to be disruptive is enormous. So if we treat it carefully, and we also learn from the evidential experience that we had when it comes to neuroscientific evidence, then we might make good use of it, and this will become yet another tool in the arsenal of the criminal lawyer and also criminal courts. So this is again the paper, and I invite you to read it very interesting. Thank you very much.
Riccardo, thank you so much. Yeah, fascinating work. Bringing epigenetics to the legal discussion is something it's really lacking. So, Silvia, to be honest, I do not invite you. You have to wrap up so many things as a discussion. So, yeah, but I know you're capable. You will do that. But it's really fascinating. The whole variety of facets. We touched upon. I'm really grateful for the splendid presentations. And Silvia, the floor is yours.
No, I would like to give the floor first to Robert, because otherwise we run out of time.
You're the host.
I had to take off. I mean, to introduce myself here, because the colleague couldn't, but it's not so necessary that
So
Robert,
okay, Robert, it is.
Okay, thank you. Can everyone hear me? Okay, good. And thank you, Professor Solardi, for the invitation. I'm very pleased to be part of this effort with such distinguished colleagues. My remarks rely heavily on the paper of Dr. Greppi, and my theme is, as an overall observation, Descartes was wrong. There was not a mind-body duality. They are really the same thing, which I think is a point she makes in her paper. And I recommend a book by neuroscientist Antonio Damasio entitled Descartes' Error. This continuum, or this integration of mind and body, what does it mean for criminal law? My conclusion, which I'll come to momentarily, is that it depends on the purpose of criminal law. There are different purposes, and for some that it is more relevant than others. I begin by describing an incident that has become iconic in the history of neuroscience, and which many of you may be familiar with, the story of Phineas Gage. He was a railroad construction worker in the mid-19th century in Pennsylvania, in the United States. He was involved in a blasting accident, and an iron bar went through his left eye, his left frontal lobe, and exited the back of his skull. He did suffer, obviously, physical damage, but it seemed momentarily that there was not much effect behaviorally or emotionally. However, within the next few weeks, his personality changed. He went from being mild-mannered and agreeable to being aggressive and disagreeable, unable to accept advice, abandon plans for the future, and unable to keep a permanent job. He wandered around. He ended up in the country of Chile, where he went from job to job. But after about 4 years, his old personality seemed to come back, and he was able to handle a job as a driver of wagons, which indicated that he had a more even temperament. He then died in 1861. Had he committed a crime during this time, would he have been culpable? Would he have been culpable before his apparent recovery or after it? It raises a question of the integration of brain and behavior. This was the first real demonstration of the role of the frontal lobes. Its left frontal lobe was pierced by the iron bar, and it also demonstrated the continuum of behavior, morality, brain physiology, and brain function. With advances over the last 150 years in science and neuroanatomy, the question becomes more difficult. In particular, the issue of genetics and epigenetics becomes particularly telling. I think this is the biggest advance that complicates the picture. We now know that genes control and have identified some of the genes that control conditions like schizophrenia, Alzheimer's, bipolar disease. Research shows that most psychological traits have some genetic component, but none are 100% genetic. There is always a gene-environment interaction. And as was just discussed, the field of epigenetics is beginning to show us exactly how those interactions happen at a cellular level. What makes it even more difficult is, as was discussed, the issue of privacy, and the information from neurobiology gets at personal thoughts, the most personal realm that we have, even the ability to read thoughts, to predict behavior. And the genome contains particularly sensitive information about our composition. It's immutable, and it implicates even relatives. And the privacy issues become even more acute when we look at the implications for intervention, cognitive manipulation, gene editing, and in the era of AI, these tools become even more powerful. So what does this mean for criminal law? As Dr. Sagate explains, neurobiology and genetics clearly have a role to play. I would propose that we look at what are the three main purposes of criminal law that are generally discussed. Retribution, punishment. Can we punish someone for something that they cannot control, that they have no agency over? Their neuroanatomy, their genetics. I think it's very problematic to apply biology to that. Correction, as Dr. Agripe discussed, in terms of restorative justice, makes sense, but we have to look at the complex interaction of biology and behavior, and how we correct someone who is not acting volitionally, but is acting as determined by biology. I would say deterrence is the issue where biology is most relevant, and where science can be most effective. Knowing the consequences of action, which may be punishment or maybe something more restorative and collaborative, does influence everyone's behavior. Even people with severe psychopathology are generally responsive to incentives and to deterrence. We do need deterrence for society to function, to mitigate the amount of crime. Unlike correction and retribution, this is essential for day-to-day activities in a society. So my conclusion is that deterrence is the area where we should be focusing our biological research. This is where science can be most effectively help and guide the criminal law, and this is our best opportunity to enhance the role of criminal law based on science. Thank you.
Robert, thank you so much. Beautiful, beautiful wrap up. Thank you so much for this. Sylvia, do you want to add something, or with regard to the time, should we maybe now?
We should go to the other session, also in respect of people who are connecting from Japan, and there it's midnight. So I think it's better. So if
this
you
session
don't
is closed. Okay, this session is closed, and of course it's your decision whether or not you want to offer, maybe instead of a 10 minutes break, maybe a 5-minute bio break, so that everyone could grab a coffee. But it's, of course, it's your decision. But I hand over to you.
Yeah, if we want, we can have 5 minutes break and then begin in 5 minutes, as I think the majority of the people are already connected for the other session, but 5 minutes would be okay. Thank you very much. So we see each other in 5 minutes. Thank you, Tade, for the moderation. So we have come to the 5th session, to the 4th session of our for the 5th session. The moderator of this session is Takis Vitalis, who is our editor-in-chief of the Biolaw of the 21st Century book series from the International Hellenic University in Greece. So if he is here now, I leave him the floor. I don't know,
Yeah, thank you. Thank you so much. Yeah. Okay, great. I think the time is limited, so I will skip a short introduction I have prepared, and it is time now, I believe, to visit the comparative aspects of neuro law, let's say, because sometimes we have the tendency, I admit it, have the tendency with the new technologies to forget that we must pay attention also to national legal systems. So on the one hand, we have, of course, EU law and international law, and what is happening here is more or less known, but on the other, law is always embedded in national communities, so we must pay attention to the national legal systems worldwide. So yeah, I will introduce our speakers separately. So first, I would like to invite Francesco Stocci. I don't know if my accent is correct. Correct me if I'm wrong. So Francesco is graduated from the University of Milan, Bicocca, and obtained a doctorate in April 2024 in legal sciences with honors from the same university. And during her doctoral studies, she carried out a research period abroad as a visiting scholar at the University of Zurich Institute for Biomedical Ethics and the History of Medicine. So the title of Francesco's presentation is The Iure Condento Perspectives of Neuro Rights, Regulation versus Deregulation in the Age of Human Rights. Francesco, the floor is yours.
Thank you very much. Can you hear me?
Yeah.
Okay. So thanks for the introduction. Thank you also to Professor Salardi and all the organizing committee for this incredibly interesting occasion. So I will jump right into it because I know we are short with time. So in my presentation today, I will discuss the Iure Condendo perspective on neuro rights. starting from the attempt to dissect a very common argument that we hear in the discussion on the regulation of emerging technologies. That is the argument that I call the argument for deregulation. That is generally an argument that justifies a laissez-faire approach to emerging technologies. And to me, it is particularly interesting to keep discussing this kind of approach or the arguments behind this approach, because in the very recent time, so since the new administration in the US, I think we have seen a strong push for the regulation in all the fields related to emerging technologies. So this argument can be applied to AI, to neurotechnologies, and to other emerging technologies. Just to cut into the topic and into my paper, in general, we can see the argument for the regulation as formulated in the following way. Regulation hampers or stifles innovation. And this very general and broad affirmation is often used to discard any attempt to introduce regulation or any kind of regulation that is not the self-regulatory attempt done by the companies. And to me, I will try to pose three different critiques to this argument based on a linguistic analysis, a more normative based analysis, and a descriptive based analysis. So in general, this idea that innovation is stifled by regulation, it's built on the idea that law poses unnecessary cost to innovation. So putting red tape around emerging technologies creates new cost for innovation, because compliance usually requires some choices, some behaviors, some studies, some resources in general, and these can damage companies, and especially small medium companies. And this is the general idea. However, I believe that this argument is too reductionistic for two main reasons. The first one is that it is based on a generalistic idea of law, because there are different kinds of law, and there can be good and bad written laws with good and bad effect on certain phenomena. So we cannot generalize that. And also innovation, when we discuss innovation as impaired by law, it is not always clear what we are discussing. And here I will introduce my linguistics remark on innovation, because as, for instance, already explained by Salardi in 2023, innovation is often misunderstood as a synonym for revolution, when a revolution is a term that can have two different meanings. A more radical, a more broad sense that indicate a radical change, and in this sense, it is more difficult to argue for regulation through law, because usually people say law is too slow to follow a revolution that moves at such high pace, and for this reason we have to let it develop by itself and then assess the situation. On the other hand, the stricter sense of revolution, it is more overlapping with innovation, and means an incremental advance in our understanding of a certain specific topic or a confirmation of knowledge. And in this sense, the problem lies in the fact that usually when we discuss innovation and revolution as synonyms in the general, in the public eye, I would say, the idea of revolution that is applied is the most general one, and this can create some level of confusion. Another level of linguistic confusion stems from the fact that innovation also can have two different main senses. A more stricter sense, that is the one that is usually intended in the technological debate, especially by those that work in the technical field. That is technical innovation that can be also easily translated in economical factor to be measured. And there is a broader sense that is also the sense in which it is understood by the European institutions. So in our legal framework, there is a wider sense of innovation that also tied with social, cultural, political aspects. So in this sense, we cannot reduce innovation just to a mere technological and then economic factor, but it has to be seen in a broader sense. And even if we concede that innovation should be measured only on the economic side, I present an argument, a more descriptive argument that actually shows that the few preliminary data that we have that are still insufficient, and we have to recognize that, but the few preliminary data that we have seems to suggest that actually strict regulation may have positive impact onto innovation, even when, as for the example of GDPR that I quote in my paper, the legislation is not directly designed to improve innovation, but has other objectives that are normatively justified by our human rights framework. And in this sense, I say that I maintain that a stricter regulation may create what is called in economy the Porter hypothesis. That is an economic phenomenon studied in environment in the area of climate change and environmental issues, where stricter regulation tend to have as a result a change in behavior that is that not only is directly related to a better output for environment, but also to growth in the economical impact of such regulation and in innovation in general. So it is possible to have a positive impact with law into innovation if we want to concede that we should only focus on the economical side. But I do not maintain this. I actually maintain that we should stick to our human rights framework that requires us to evaluate regulation, not only focusing on the economical side of the argument, but also on the social impacts, on the political impacts, and in general on the legal impact of such technologies. And this would be the third critique to the general argument. So once we have discussed and we have found some good argument to reject the idea of the regulation, the other question is how we should regulate neurotechnologies. And so as neurorights is now the main focus of this debate, what we should do with neurorights. To me, it is very interesting, the ideas, the classification used by Timo Istace. Sorry, I don't know the pronunciation of the surname, but I really find your paper on the topic really interesting, in which basically the author present the neurorights approach as a two-pronged approach. We have a neuroright approach on one end, and on the other end, the so-called derivation approach. The neurorights approach is based on the idea that there are some, there can be, or we need to find some gaps in the human rights framework. And when we identify some of these gaps, we can introduce new rights to answer to this lack of rights. On the other hand, the derivation approach is basically the idea of reinterpretation and to reinterpret some areas of underdevelopment within the human rights scholarship in order to protect individuals. So basically, the objective of both the approach is the same. So grant a higher level of protection for the individual, but it is operationalized in a different way. The main critics for both approaches, in my opinion, are that there is still a strong lack of clarity within the content of the proposals. There are different proposals that goes in different directions, so this also builds up on this confusion. And on one end, we have a risk of rights inflation with the first approach, and with the second approach, I would say we have an inflation of interpretation, because also with like a constant enlargement, I would say, of interpretation of a certain right, at a certain point we can say, okay, maybe this right is it has become too vague to be actually properly enforced. So which is the same, basically the same content of the critic of the human rights inflation argument. That is, too many human rights became difficult to enforce. And also there is an interesting claim that has been made in the recent years. That is the universality claim of this kind of proposal has been challenged by some authors, saying that they risk to be too focused on a Western-centric approach. So we also have to be very careful about this. And also some of the conversation today were touched to this topic. So I think it's very interesting. So just to conclude, because I know my time is almost done, I think that for the political situation that we have now, if we have to decide, because I think it's still too early to decide whether which one of the two approaches is better, but if we have to decide and the situation remains the same, I think that the path of least resistance would be the second one, so the derivation approach, because in this case, even though there is a lesser political intention to regulate certain phenomena, it could be the same as for environmental law and climate change law, the climate change topic in general. That is, that we can have a reinterpretation made by judges, by international courts, and pushed forward through strategic litigation, even when there is no political interest by the major countries to follow certain path. And in conclusion, I think that working on the main problem of both the approaches, that is the lack of clarity of the proposal, will help us to decide whether to go onto the first approach or to the second one. And also, I don't think they are actually mutually exclusive. So in a sense, we can maybe find just one gap in the human rights framework, and we introduce one new human rights, for instance, cognitive liberty, and then through this introduction we can justify more easily the reinterpretation of already existing rights in a sort of cascade effect. And so for this reason, in order to choose whether we want to, which is the best suited approach for the future challenges, I do believe that first we have to finish this very complex theoretical work that, as we've seen today, we are engaging with, and it is very important to continue in this path. And thank you.
Thank you, Francesco, so much. Very, very interesting, stimulating presentation. Of course, the huge dilemma is that inflation. What do we prefer, inflation of rights or inflation of interpretations? This is another elephant in another room. But anyway, it was a very, very interesting pattern of lawmaking, I think, and deserves our attention. Thanks again. So, next speaker. Next one is from Japan. Masatoshi Kokubo, who's an assistant professor at the University of Tokyo, Interfaculty Initiative in Information Studies. He writes on freedom of thought, mental privacy, and cognitive liberty. Also about the case studies of the neuroscience technologies of the Japanese medical law journal Fugaku Seminar. He was awarded the 13th Japan Society for the Promotion of Science Ikushi Prize in 2023. And the title is The Possibilities and Challenges of Neuro Rights from the Perspective of Japanese Constitutional Law. Before starting, let me thank you for your patience, because I know that the time has passed in Japan, and we appreciate very much that. So the floor is yours, Masatoshi.
Thank you. So can you hear me?
Yeah.
Oh, thank you. Thank you very much for really generous introduction. And also, I want to express my deep gratitude, and I thank you very much for giving me this great opportunity to the Professor Silvia Solari. And this is my great privilege to have this opportunity among these excellent colleagues. And actually, as he mentioned earlier, it's midnight in Tokyo. Unfortunately, it's not midnight in Paris. But anyway, I hope my brain works properly. Maybe I need a cognitive enhancement for this time. But anyway, let's start my presentation. So today I'd like to talk about the possibility and the challenges of neural rights, especially focusing on the cognitive liberty from the perspective of Japanese constitutional law. So I skipped my introduction. And so when we face the neuroscience technology, the main question there was, how do we accept the phenomenon that mental processes decoded through the part of our body? So, which means we have to think about body-mind problem and more mind-brain problems, because we can see what's going on in our mind through our body. For example, when we see the motor cortex around here, we can use EEG to collect neural activity. And by processing it in our computer, we can decode our speech intention from those kind of neural activities. And also we can use same technology to decode our behavior intention too. And I'm not here to say it's really risky, but it's really good thing for some people like ALS patients or people who have paralyzed issues, especially when they use their limbs. So the question here is we have to take a balance between risks and the potential of those kind of technologies. And thinking about why we can do that is probably because we have experienced the cognitive revolution in our psychology or natural sciences. Basically, this is the paradigm shift. When we see our mind, we understand it as our information processing. So in that sense, we see our nervous systems as some kind of informational system within our living organisms. And its body, the system foundation is biochemically driven electrical circuit. We call it nervous system. And also we see the system function as information processing that is realized by the electrical signals. So that is why we can decode our intention and cognitive function through collecting the electrical data. And also we can bridge our nervous system with other external systems informationally. The most core technique here is, of course, as you know, brain-machine interface or brain-computer interface. And that's what we are facing today. So, but it's really, even if it's really amazing and it's really good for many people, it's not the reason that we have to think about it, especially as the domestic legal scholars. But here's the intersection of constitutional law and this kind of phenomenon. And at first, generally, it's really important and an urgent task for law to establish some kind of red lines when we face those kind of neural technologies. But it's basically same when we're facing the genome technology or informational technology or AIs. What is difference here is we see many new rights or freedoms that is proposed to accept this kind of phenomenon. For example, some people say we have to establish new rights or we have to establish cognitive liberty when we deal with this technology properly. And fortunately or unfortunately, UNESCO or Human Rights Council or many international organizations try to incorporate those kind of new concepts, and they began to finalize their recommendations. But once their recommendation is published, as a member state, we have to comply their content from the perspective of domestic legal jurisprudence. So here is the intersection of constitutional law and international discourse. And that's why I'm curious about what is cognitive liberty, and do we have to change our constitution, or just we have to retranslate our constitutional understanding? And also, our current trades raise a question regarding its relationship relationship with domestic substantive law, because many companies try to socially implement those technologies so rapidly. For example, as you know, Neuralink began the human trials in 2024. And in Japan, we have new medical BMI, which is approved by the Japanese government as a class 2 medical devices. And actually, this is my former lab of neuroscience, but their clinical application began in many hospitals in Japan already. So this is the intersection of a constitutional law scholar and the neuroscience phenomenon. Let me briefly summarize what we are facing. So when we see the neuroscience technology from the domestic constitutional law perspective, we can divide them into two categories of technology. First one is neuromonitoring, so-called neuromonitoring, which is the area related to the information we can withdraw from our nervous system. And we can also divide this area into three subcategories. I skipped the detail because of the time limitation today. But first one is probably the most easy one, is just a visualization of our structure or function of the nervous system. That's all. And the second degree of more risky information is decoding, which is deeply related to neurodecoding. We can withdraw the cognitive function or mental process information from that. And also we can use those technology to predict our future too. And in short, in this area, we will have to think about mental privacy, informational privacy, or due process of law when we use those information in a trial or in social life. And also we have to think about freedom of thought, especially they reveal our belief or religious belief or thought and something like that. On the other hand, the other category of technology is neural manipulation, which is directly interfere what's happening in our nervous system. And these also divided into three subcategories based on the purpose of use of those technologies. First one is treatment. Treatment is a relatively safe area because most of the treatment is under the supervision of doctor or professionals. But on the other hand, enhancement is quite tricky because amateurs or even they don't know a whole about neuroscience can use enhancement technology so freely because they are not falling to the restriction of medical device restriction or something like that. And the most risky and tricky area is intervention, which is the technological use against their wills. The forcibly administration of antipsychotic drugs or something like that. Anyway, this is the area of neural manipulation. Is the problem here is to interfere with what's happened in our bodies. In that sense, we have to think about human dignity, personal autonomy, plus those things that issues we see in the neural monitoring too. And also we have to think about a more basic and a more great impact here, because when we're talking about legal theory, there's unchanging and universal modern theory there. So in the modern theory, we appraise the value of self-determination, but on the other hand, we also praise the value of personal dignity or human dignity, which is not overcome by their self-determinations. But especially human science, life science technology enables interfere with biological phenomena beyond human control once before. For example, genetic testing or genome editing. And also, of course, neuroscience technology will be added in this list. So in that sense, in short, neuroscience technology is tilting the balance between self-determination and the dignity toward the former, and interfering with the nervous system is the foundation of consciousness, could raise serious issues concerning dignity or personal autonomy in that sense. So here is the overview of problem that we are facing. And of course, we have some kind of proposed answers already. First one is neural rights, but from perspective of domestic legal scholar, it's quite useful framework for understanding the assessing the impacts of technology. But on the other hand, it is kind of moral rights, not legal rights. So I want to focus in on the cognitive liberty, which is relatively rooted in the jurisprudence discourse or legal discourse. So cognitive liberty once before was the freedom to neuroscience technology, which is Richard Glenn-Bohr of various sentences argued in early 2000, which is the the retranslation of the right to self-determination in that sense. And a recent argument is especially proposed by the Farahani, which is focusing the freedom from neuroscience technology in the name of the right to safe mental privacy or freedom of thought. It's quite hopeful because it focuses on the nervous system's information processing because they use the name of cognitive. And it could be the neuroscience technology friendly concept in terminology and also has the potential to serve as a platform for interdisciplinary discussion. But we have to think about how to incorporate this tricky cognitive liberty concept. Let me use the case as of the Japanese Constitution. We have Article 13 of the Japanese Constitution, and which guarantee the right to privacy as a part of the right to self-determination, and it is considered as a relative right. So we can retranslate this article to include mental privacy. And we also have Article 19 of the Japanese Constitution, which guarantee the freedom of thought and conscience. We call this freedom as freedom of inner thought. And we understand this right to protect our whole explicit mental processes. So it is considered as absolute right too. So we can retranslate this article to include freedom of thought. In short, we can adapt the cognitive liberty or new rights, part of new rights by retranslating the given rights in the Japanese Constitution, which is good. But on the other hand, we are facing two remaining issues related to the cognitive liberty. First one is an ambiguous line between absolute protection and relative protection. So Farahani distinguished robust thought from others and it gives absolute protection to the former. But due to the definition of robust thought being based on an informational view, because Farahani arguing what kind of information we draw from the nervous system is the essence, so it can be broken down into neural activity, which is a physical chemical phenomenon, and which is a direct target of technology interface. This is the first issues that we are facing. And on the other hand, the framework itself places excessive emphasis on self-determination. The aim of cognitive liberty or new rights seems to be obtaining informed consent, but it's really extremely difficult to acquire proper consent, especially when we are facing so advanced technology like neuroscience technology. And also, the consent model itself is often failed in the information of privacy. So we have to learn the lesson from here too. And even with the individual consent, there are no area where the use of technology should be absolutely prohibited. We have to think about this issue too. So to overcome these issues, I want to propose to focus on objective values behind those subjective rights. That's why, because in Japan, we have understood that freedom of inner mind gives absolute protection to the thought.
Sorry, we have two minutes, please. 2 minutes.
Okay, thank you very much.
Sorry about that.
Okay, thank you very much. I'm sorry. Thought to protect and support personal autonomy. So using neurotech, which makes it impossible for the individual to continue to exist as being with personal autonomy, would be prohibited. On the other hand, in Europe, some neural scholars, for example, Christoph Bablis, have pointed out that there may be cases where the use of neuroscience technology should be prohibited in the light of human dignity. So this is the hypothesis of to overcome the issues, but we have two remaining tasks to do. First one is, can we identify the specific neural activity that is related to those values? And the other one is, what is the difference between those two core values? In Japan, we see the personal autonomy. In Europe, we see the human dignity. What makes difference and what outcome is derived from this difference is the question. So to conclude, it's time to dig into the detail of cognitive liberty, not arguing the name or right or liberty or something like that. And also it's time to think about dignity or autonomy in scientific terms to ground these values on the structure and the function of the nervous system to make our argument practical. And also let's conduct comparative research on the concept of personal autonomy or human dignity between Europe and Japan. So that's all for my presentation. Thank you for your kind attention. Thank you very much.
Thank you so much, Mr. Tochiya, and fully agree with your final recommendation. We need to compare the different legal systems with so basic with regard to so basic concepts like human dignity. It's for sure it's something that deserves our attention. Thank you again.
Thank you very much.
Stimulating presentation. So next speaker is Claudia Nibali, a PhD candidate in advanced studies.
Taki, sorry, we have first Diego Bourbon.
Diego Bourbon is first.
Yeah.
Yeah. Okay, sorry, Diego. So Diego Bourbon is a professor and researcher at the Center for Studies in Genetics and Law and director of the research group in biological sciences and law at the Università de Colombia, professor of medical law, neuro law, artificial intelligence, and new technologies. So Diego holds also a Master's in Philosophy for Contemporary Challenges and Master's in Applied Neuroscience at the Institute of Psychiatry, Psychology, Neuroscience at King's College in London. His presentation is about neuro rights and misstep in legal evolution. Diego, the floor is yours.
Thank you very much. It's a pleasure to be here. And I want to start very briefly by showing you some pictures I took in Switzerland. So this is Switzerland, this is Celpense. But because when you travel to Switzerland, two things are going to happen to you. The first thing is that you're going to be absolutely amazed by the beauty of the Alps and the lakes. But you have to be careful, because if you're not careful enough, you might make a misstep. And in this presentation, I want to make the point that maybe, just maybe, neuro rights are a misstep in legal evolution. So we all know that the initial proposal was made by Yenka and Andorno, which was followed by the proposal of the New Rights Foundation of 5 new rights. But I want to make the case that there are at least 6 good arguments to think that maybe those proposals of new rights are not specifically a good idea. So the first one are the conceptual problems. So many of the concepts of the New Rights Foundation, but also some of the proposals of Yenka and Andorno, have a very broad and complex philosophical debates behind those concepts. Just take into account, for example, the definition of a new right to free will. Free will is a very complex philosophical problem that we've been debating for the last 2 millennia without any solution. And nowadays in analytical philosophy, we have the compatibilism, incompatibilism, libertarism, and we haven't reached any point of good discussion and any conclusions at all. So does it really make sense to translate a very complex philosophical concept into a new right called free will? And maybe the answer is no, and especially no if we already have a right that protects us from manipulation, which is basically what the New Rights Foundation plans to do, and it's called informed consent, autonomy, freedom rights, and bodily integrity, for example. But consider other concepts as personal identity, as enhancement. These are very complex concepts that their conceptual definitions are not really easy to operate in legal practices, and especially not in our countries where judges are not prepared to do not just neuroscientific reasoning, but also philosophical reasoning with these very complex ethical and philosophical debates. But also consider the ethical dilemmas under some of the concepts of the New Rights Foundation, as, for example, the problematic right to equal access to mental augmentation. In bioethics, we have this very complex problem between what's nature, what's enhancement, what's therapeutical, and what's not. But this new right to equal access to mental augmentation seems to pretend to create a new social fact or norm to give people the access to enhance themselves beyond medical or therapeutical purposes or applications of neurotechnology. Does that really make sense, as we haven't really debated this, or take into account what happened 20 years ago in the debate of genetical modifications? All around the world, we concluded that genetical modifications beyond human nature and beyond medical applications were prohibited, and that transhumanist applications of genetics technology would not be able to be applied. So we have this problem of nature and transhumanist applications or therapeutic and between enhancement, and it's not a yet solved debate, and perhaps that's something that we might consider before legislating in favor of a new right to enhancement and to the application of transhumanist uses of new technology. Consider also the financial implications of creating a new right to equal access to mental augmentation. When you create or legislate a new human right, especially if it's a positive right, which means also it's a prestational right or a social, cultural, and economic right, that means that someone has to pay for it. And who has to pay for it? Maybe the state. Now, the question is, do we really have the financial resources to pay for a new human right that does not have applications of public health, of therapeutic interventions or medical purposes, but rather of enhancing applications of new technology? And I also think that's not the case, and especially it's not the case in Latin America, for example. We don't even have the minimum basic resources to finance public health systems, nor the basic human rights means. But it also seems that this right is maybe favoring the interest of big enterprises and corporations, because it would entitle, basically, that opens the door to finance with public resources, that means taxpayers' money, the numerous acquisitions of technologies whose purposes are not therapeutical, nor medical, nor of public health, in the name of a new problematic new right. But consider also the problem of necessity. Do we really need new list of rights? Is that really the case? Because current national and international conventions and constitutions already protect freedom, consent, freedom of thought, privacy, information, physical and mental integrity, bodily integrity, equal justice, and non-discrimination. Perhaps we don't need new list of rights, but rather the development of interpretations of existing rights and the development of specific legal frameworks, nor new list of rights. Bulitz says widely that if you expand indefinitely the list of rights, what you're making is expanding or inflating rights, turning those rights and in general all the rights into symbols and empty rhetoric, and that it would be unfortunate too if international organizations would support the narrative of the insufficiency of human rights. And I think the narrative behind the New Rights Foundation, New Rights Initiative is dangerous. In what sense? Because the New Rights Foundation is basically telling us that all that we have built in international public law and international human rights law is so meaningless, so unimportant, that we are currently unprotected. And I don't think that's the case. But also consider the proposal of Jenka and Adorno, who says that all of the new rights they propose are relative. That means that you can violate new rights in the name of public safety or public interest. And I wonder whether this is really protecting us, not just from companies, but also from the state. They say in the 2017 paper that considering the non-invasive and painless nature of brain scans, that there would be prima facie good reasons for thinking that their non-consensual use would be justified under special circumstances, like believing that someone is going to commit a crime or is involved in planning a serious crime. So I wonder, is this really protecting us from the state or from enterprises? They say specifically that the right to mental privacy and to mental integrity does not ipso facto implies the absolute character of these new rights. So if neuro rights are so relative that you can weigh those against public safety or public interest, do they really protect us more? The principle of progressiveness and the principle of non-regression in human rights means that everything you do in human rights terms needs to expand the protection, not to be regressive. And we already have absolute rights of human dignity, that is a right, a principle, and a guarantee, but also the right to freedom of thought, that the essential nucleus of the right to freedom of thought is also an absolute protection. So it seems that even the rights we currently have protect us more than the proposed neuro rights. And I want to end by showing what the landscape is in Latin America, because we have a big mess in my region. We have 18 different bills. Of those 18 different bills, just 6 have been approved. And of those 6, just 3 are legally binding. But I'm going to give you an example. I published this paper, which is basically challenging the inconsistent framework of neuro rights in Latin America. But there's a specific case, and it's that we don't really know what we're doing in Latin America as in many parts of the world. For example, we have a parliament that made this new bill, which creates 13 new rights, that confuses mental privacy with brain data, that confuses identity with autonomy, that confuses free will with autodetermination, that prohibits the intervention in medical circumstances. So if you get into an accident and you go to the emergency room, no one is going to be able to operate or to help you in the absence of consciousness. And they also prohibit hypnosis and suggestions. And for what reason, we don't know. And if you see the sources of information of this bill is Wikipedia, opinion blogs, and also it has 69% of plagiarism. So is this really good policy making? Is this really good regulation? Is this an example of what a new rights legislation should look like? And I think it's not. And that's why I published a paper that's called What a New Rights Legislation Should Not Look Like. And the model law of the Latin American Parliament is an example of what it should not look like. Maybe, just maybe, new rights are now the land of speculative ethics and alarming claims. We need regulations, but maybe regulations based on evidence, not on sci-fi or dystopian features of unregulated new technologies. And that's why we made a survey last year on the INS 2024 annual meeting, and of all the assistants to the meeting, just 2% said that definitely we need new human rights, just 11 that probably yes, and the majority said maybe we don't need new list of rights. So I want to end by the way I began this conversation. Well, maybe policymaking is like hiking. If you see red flags, if you see that the weather is not good, you might as well try other alternative routes. And that's why maybe we don't need new list of rights. We might need as well new laws, new interpretations of existing rights, international conventions of law principles, and we might as well need some reforms in specific laws, for example, privacy laws, to say that neural data is sensitive data, regulation on consumer neurotechnology, and perhaps the uses in criminal law. So my reflection is, let's think beyond new rights, because we still have time to get regulation right. Thank you very much.
Thank you, Diego. Very, very interesting and real, genuine criticism to the inflation of rights. And yeah, you remind us that privacy is not an absolute right, like freedom of thought is supposed to be, or freedom, or all this mental self-determination, let's say. So privacy is not an absolute right; it's a relative right. I guess there is a contradiction maybe here, and we need to face it and to find a solution. On the one hand, we have an absolute, supposed to be an absolute right. On the other hand, we have a relative right, privacy, and mental privacy, I suppose, is included there. So thank you very much for your presentation, Diego. Very nice. And our last but not least, of course, speaker is now Claudia Nibali, a PhD candidate in advanced studies in human rights at Universidad Carlos III de Madrid. She holds a master's degree in human rights with a thesis focused on the ethical and legal implication of neurotechnologies and the emerging concept of neuro rights. So this topic, she continues to explore this topic in her doctoral research also. So the title of her presentation is Between Ethics and Law, Cognitive and Moral Enhancement again, in the Neurotechnological Era. So Claudia, please take the floor. Claudia, can you hear us? I don't know if...
I think she left and she might re-enter. Let's wait a little bit.
Yeah, okay, Douglas. So
She re-entered.
okay.
Can you hear me now?
Yeah, Claudia.
Perfect.
Yeah,
Sorry, because
can you hear us?
okay, so
Yeah,
I'll
wonderful.
share my presentation. Can you see my presentation?
Yes.
Yes. Yeah, now it's perfect.
Okay, perfect. Thank you. So, good afternoon, everyone. As the title suggests, I'm going to present an analysis of cognitive and moral enhancement. In my research, I take as my starting point that the proposal of the New Right Foundation to recognize a new right to guarantee a fair access to mental augmentation. And I argue that this proposal is highly problematic, above all because it omits an extremely important step that must precede the legal recognition of any claim, that is, its ethical justification. I argue that mental enhancement could only be ethically justified if we were able to consider it as an unavoidable requirement for the free development of all individuals. However, it seems rather to be an instrumental need for the life plan of some individual in specific circumstances. Nevertheless, we cannot say the same about moral enhancement. To give you some details about this, I have organized my presentation into 4 parts. First, I will offer several definitions of enhancement, considering how the concept has evolved over time. Second, I will focus on the process that must precede the recognition of any human right, emphasizing the importance of the ethical justification I have just mentioned. Third, I will present some reasons to argue that cognitive enhancement is not ethically justified. And finally, I will conclude that moral enhancement, by contrast, will be ethically justified, even though for now it seems preferable to set aside moral bio-enhancement and instead rely on artificial intelligence systems which, without replacing our decisions, could support us in the process of reflection and deliberation about what is right. Defining the concept of enhancement is not an easy task. The most common approach is to define enhancement in contrast with therapy. However, as you can see on this slide, there are also other approaches that try to clarify what enhancement means. All of them reveal the presence of a strong subjective component. Nevertheless, the aspiration to improve the human being did not begin with neurotechnologies or pharmacological enhancement. These are simply new instruments in the service of an old goal, that is the flourishing of human beings and the free development of personality, taking into account the weakness of the will, which made it hard to achieve such a fulfilled life, or this life in accordance with virtue. What is new today is the discovery that these cognitive, motivational, and moral limitations, which can make it difficult to follow one's own life plan, are at least in part rooted in biology. This is why the proposal of cognitive and moral enhancement comes in.
Moral by-enhancement entails the use of biomedical technologies to modulate neural activity in order to enhance moral capacities, and cognitive by-enhancement refers to the improvement of certain features of cognition, either through pharmacological means or through invasive and non-invasive neurotechnologies. The main problem is that the improvement of mental functions might not be available to everyone, creating new forms of discrimination. So, drawing attention to this risk, Juste and the other scientists of the Morningside Group propose expanding the current legal framework by introducing the right to fair access to mental augmentation. The main problem with this proposal is that it ended up establishing a right to enhancement while ignoring, as I mentioned before, the ethical justification that must precede the recognition of a new human right. To be ethically justified and therefore become a new right, a claim must coherently align with the ultimate goal, namely that as many people as possible develop to the fullest extent possible the life plan that each of them has individually set for themselves. And this means that such a claim should be understood as a generalizable and desirable aspiration for everyone, or be understood as a new basic need that must be protected. That is as an essential requirement for the free development of every individual. And it must not harm the interests of those who do not wish to make use of it. In summary, the starting point is that the moral objectives or ends of individual must be generalizable, that is capable of being presented and as reasonable and desirable for everyone. This means clearly that not every aspiration or desire can be transformed into law, because at the same time, the freedom of choice of each individual must respect the moral development of all others. As a result, the first step is to evaluate whether it is possible to speak of objective enhancement or whether the subjective criteria that shape its definition push us to question any attempt to define it objectively. The second step is to ensure that the freedom to use enhancement technologies beyond the therapeutic realm does not harm the interests of those who do not wish to use them. Or in other words, that this freedom of some does not undermine the rights of others. Regarding cognitive enhancement, it could be incompatible with the cultural legal system of different countries, and this will not allow global acceptance. Moreover, even if we admit that in our society and for certain functions, an increase in intelligence could be considered as an objective enhancement, it is not clear whether it will also be morally desirable. And it depends on whether the enhancement is so powerful, so disruptive that it transcends the normal evolution of human beings. In that case, it will not be ethically justified. The last problem has to do with the question of material limits, including scarcity, and this in turn is divided into two problems. The first problem is that the right to equal access to mental augmentation would entail a new human ability to demand the possibility of being enhanced, and the state will then be forced to finance with public funds the introduction of these technologies. And the second problem is that it could undermine the right to health of others. The problem is that if the use of enhancement outside the therapeutic field were admitted in a situation of scarcity and limited resources, this would restrict access to therapeutic treatments. Regarding moral enhancement, it could be ethically justified, first because it is possible to define objective enhancement independently of the context and the moral theory adopted. For example, Douglas refers to the strong aversion to certain racial groups or the impulse toward violent aggressions. Second, because moral reasoning and moral behavior are clearly essential requirements for the free development of personality for as many people as possible, or in other words, for achieving this ultimate goal. Why? Because as I mentioned before, the starting point of this discourse is these motivational and moral limitations that may hinder the possibility of acting in accordance with one's own life plan. And moral enhancement makes it possible to overcome these limitations. Finally, even if such improvements were not widespread, they could still contribute to general well-being. So the fact that only some will decide to resort to moral enhancement does not seem to cause harm to the interest of others, whereas this does happen with cognitive enhancement. That said, let me make two final points before I close. First, just as with cognitive enhancement, not all enhancements are the same, and therefore not all of them can be ethically justified. I want to stress that here I'm only defending the kind of moral enhancement that does not undermine autonomy, but rather promotes it. Second, that saying that moral enhancement is in some cases ethically justified does not mean supporting its unconditional implementation. One reason is that by strengthening pro-moral emotion or diminishing counter-moral emotions through neurotechnologies or pharmacological means, we could interfere with brain areas that have multiple functions. So to conclude, there are not only insufficient ethical reasons to recognize a new right, but it would also be impossible to guarantee access to enhancement technologies by extending the scope of other existing rights, such as the right to health. Second, moral enhancement could be ethically justified, but only if it does not compromise personal autonomy, or in other words, only if it is voluntary and it aims to help a person act in accordance with the values they have freely chosen without imposing them from outside. Nevertheless, since it is still not possible to intervene in the neural process linked to moral judgment without also affecting other areas and functions, it seems premature to rely on neurotechnological solutions for moral enhancement. Thank you.
Thank you so much, Claudia. Indeed, moral enhancement raises a lot of questions, and maybe it's premature to discuss about moral enhancement for the moment. Thanks again for your presentation. Very, very stimulating. So let's move on now to our discussions, and first I will invite Professor Federico Gustavo to provide his comments. Federico Gustavo is from the University of Milan, president of the Italian Society of Neuroethics. He currently works at the Department of International Studies of the university, and he does research in public law, end-of-life decision-making law, neuro law, and individual duties in bio-law. So please, Professor Gustavo Federico, the floor is yours.
Thank you very much, Professor Takis Vidalis, and I also want to thank very much Professor Salardi for having invited me this afternoon to provide some comments and discussion to the astonishing speeches we have heard in this session. I know that I have just a few minutes and time is running to the next session, so I will just put some comments, I say, on each of the presentation. Having said that they are all very, very interesting. So starting from Professor Stocchi, I think that his distinction between the new rights approach versus derivation approach is very intriguing, and I agree with him that probably the EU seems to move in favor of a new rights approach, probably pressured by the US, the same European Union will change in the future to a more derivation approach. So here my comment is, what will be in the future? What will be in the future the how can I say, the type of document, the type of regulation the EU on one side, or in general the international law on the other, could follow in regulating neurotechnology. What I'm trying to say here is that we may distinguish, in my opinion, between three different approaches. A sort of constitutional charter approach, such, for example, the UNESCO Charter on Bioethics, a risk-based approach, which is the constitutional, we may say, approach followed by the EU in approving the Artificial Intelligence Act, a sort of constitutional dimension based on risk evaluation, or an intermediate, such as the UNESCO latest draft of Declaration on Neuro Rights and Neuro Law. So what will be the pattern followed by EU in regulating neurotechnology? Probably a risk-based approach, probably an intermediate, like the UNESCO latest declaration. Then moving to the presentation given by Professor Kokubo. I met both Stocchi and Kokubo in Munich during the last neuroethic meeting, so it is a pleasure to see them again. I found very intriguing the idea to, how can I say, to evaluate, or better to re-evaluate the dimension of individual dignity as a specific barrage against a too wide consensus liberty, a too wide cognitive liberty uniquely based on informed consent. So probably in regulating neurotechnology, we have to find some barrage grounded on an objective dimension of the dignity, of individual dignity, in order to curtail the amplitude of the liberty, of the cognitive liberty uniquely based on the informed consent. Here my question will be, under the Japanese constitutional law, what is the distinction between individual liberty or individual dignity, or human dignity? And second, the absolute dignity of the individual as a barrage against too much liberty in deciding how put in danger our cognitive function, is a sort of moral/legal self-duty, or it is a protection per se, which means given by the society? And that could be an open question. And finally, for Professor Anniballi, if I'm correct, in the position paper, probably much than in the presentation, at the end there was a sort of open question if we may or may not use the AI system in order to promote moral enhancement more than intervening by drugs or other biochemical or electrochemical means. Here, to Professor Annibaldi, I have, two remarks. The first one, I agree with her. It is time to put rules on moral enhancement. And under this point of view, probably the draft declaration on neurotechnology adopted by the committee of the UNESCO is a little bit weak on enhancement, on neuro enhancement. There is a paragraph quite generic, in my opinion. And the second point, if we deliver to the AI the task to promote moral enhancement in dialogue with the user instead of using neurotechnology. If you use artificial intelligence technology to promote moral enhancement, what about the bias of the algorithms? What about the data training rules we need to implement in order to provide fair data set to train an AI to become a moral enhancement sort of teacher in dialogue with the user? And also be aware of the red lines. We cannot exploit the vulnerability. So if we have to use AI to promote moral enhancement in dialogue with the user, we have to be very careful not to exploit vulnerability, even moral vulnerability, and we have to be very careful in data training and in biases of the algorithms. That is enough for me, just brief sketch, brief comments, and thank you again to our chairman, to our speakers, and to the organizer for this very, very interesting conference.
Thank you so much, Professor Pizzetti. You have so valuable insight. So now it's our next discussant is Anita Molo, research fellow in private law at the Università degli Studi di Napoli Federico, due PhD in private law of the Università degli Studi Sor Orsola Benincasa in Napoli. So Anita, the floor is yours.
Thank you so much. Thank you to Professor Salardi for this very interesting conference. And I know that the time is very short. So firstly, I would like to congratulate to all speakers for the comprehensiveness and depth of the topics covered. And I would then like to make two comments, short comments, general comments to all speakers, which are almost same two comments of Professor Pizzetti. So firstly, I would say that I fully agree with the critical perspective on the theory of neural rights, because the tool of normative interpretation allows legal experts to determine the specific meaning of a law by considering first the literal meaning of the words used in the law and then the intention of the legislature, so the purpose and the reason of the law. By correctly applying this criteria for normative interpretation, many normative texts, both national and international, such include new cases related to the use of neurotechnological device, and this in a broad perspective that goes beyond neural rights as formulated in terms of human rights or fundamental rights. So the point, therefore, is not to introduce new rights, but to make them effective and enforceable in practice. And this leads us to consider a second important aspect. So if it's true that the need to introduce new rights is justified considering complex technologies that have characteristics that distinguish them from any other devices, then it's product safety legislation maybe that needs to be looked at more closely. Within the European Union, all technological products must comply with applicable laws and meet the requirements established for this purpose. So the new European risk-based approach, as Professor Pizzetti said, has introduced regulation of technological products through impact assessment and preventive risk measurement, laying the foundation for broad protection of fundamental rights, complementing existing legislation, and in particular product safety, privacy, and cybersecurity standards. So in these perspectives, two are the main ways of managing risks relating to technological devices. The impact assessment system of fundamental rights, such as data protection impact assessment in the GDPR and fairness risks impact assessment in AI Act, to offer a proactive means of evaluating and mitigating potential risks, but also the design of technological devices and AI system training, which are so important to impose obligation aimed to ensure that technologies are not only technically robust, but also socially and ethically aligned with human rights standards. So this approach is important because effective regulation from the point of view of risk measurement provides the legal basis for the effective enforcement of fundamental rights and not just for the prevention of harm. So techno-regulation involves a technological interpretation of rights already recognized to individuals, so rights that exist and have specific characteristics in a particular technological context, even if they are already recognized outside that context. So it would be more appreciated to consider specific products regulation that complements existing legislation on this point, specifying how fundamental rights in relation to neurotechnologies apply and are equally applicable, as has already been done for electronic health data with the new regulation, with the creation of an ad hoc data ecosystem, which could also be created in relation to neurotechnology. So in conclusion, we believe that this approach involving an ex-ante protection and a risk assessment system can better protect individuals regarding neurotechnologies and the risks they pose. Thank you.
Thank you so much. Very, very useful remarks and valuable insight too from Anita Molo. Very quickly, big thanks to all of you, our speakers and discussants, for conveying so rich content in so limited time. So again, I think we managed to keep the time it was not very, very easy task. Thank you. So I will hand over to Sylvia.
Thank you very much. Thank you, Takis, for moderating this session. Thank you to all the speakers and discussants. So we now go to the last session of our conference. I present the moderator, as I did for the other sessions. So Professor Francesca Poggi, who is a colleague because she is a legal philosopher at the University of Milan, the other state university in our city. I am very glad that she accepted the invitation, so I leave her the floor to introduce this session. Thank you, Francesca.
Good afternoon. Thank you very much, Silvia, for organizing this very wonderful conference. And welcome to a section about BCI, immersive systems, neurotechnology in the workplace and in games, ethical and legal questions. We will have just 3 speakers since Julia Scott was unable to attend. So I introduce you our first speaker, who is José Miguel Dieguez Rodriguez from the University of Vigo. He will present a talk entitled, Do We Need the New Neuro Rights in the Workplace? Analysis from a European perspective. Please. Is Diego here? Yes, I can see him. No, Diego, sorry. José Miguel Dieguez Rodriguez.
Yes, sorry, can you hear me? Okay. Let me just share the presentation. Well, good evening. I would like to begin by sincerely thanking the organizers for the considerable effort they have devoted to bringing this conference to life, and also for affording me the opportunity of sharing this space with such eminent scholars. In this presentation, I wish to address whether the challenges posed by neurotechnologies in the workplace make necessary the recognition of new rights, or whether an updated interpretation of the existing ones is sufficient. To that end, let me begin with a brief overview of the applications that are currently emerging in the use of neuro devices in workplace. Most of the devices promoted for workplace use belong to the sphere of occupational risk prevention, consisting primarily of electroencephalography systems. These wearables are designed to detect early signs of fatigue, distraction, or drowsiness, and have already been used. As I was saying, they are also being explored as tools for measuring stress level or excessive cognitive workload, sometimes requiring no more than 2 channels incorporated into earbuds to obtain such readings, as we can see in the image. What is especially significant about the smart protection personal equipment is not only their immediate preventive function, reduce detecting dangerous states before they materialize, but also the capacity to generate data that can inform wider organizational decisions. This line of research, referred to as neuroergonomics, seeks to analyze patterns across the workforce to reconsider work rhythms, schedules, and environments in ways better adapted to human capacities. Yet, these seemingly beneficial applications may act as a Trojan horse. While justified in the name of prevention, the data collected could later be repurposed for secondary aims, such as performance evaluation. This leads naturally to our question, and this question is the existing European legal framework sufficient to address these challenges? And in first place, could we change the order? I try to find some help from the administrative staff, move to another room to have better connection, and if I can, I make my presentation in the last place, because I fear that is going to be
I think it is a good
all the
solution.
time full. So.
Okay, thank you.
Okay, thank you very much. I'm so sorry.
Don't worry,
I'm so
it
sorry.
can happen. So now I leave the floor to our second speaker, Diego Saldivar, who is an independent researcher from Spain, and he will present a talk entitled Neuro Rights Applied to Neuro Games. Please.
Buonasera a tutti e a tutte. Vi ringrazio per avermi invitato. Now, just give me just a second to share my screen. All right. Let's see. Share the entire screen. Yeah. There we go. Can you see my screen? Yes, I suppose you can. And I suppose you can hear me, right? Perfect. All right. So, let me see. Well, hello. As Francesca said, I am Diego Saldivar, and I will be presenting Neuro Rights Applied to Neurogames, an industry perspective. I am a video game developer who shoehorns neurotechnology into game engines for fun and therapy. I'm about to publish 2 such neurogames in the following weeks, so add me on LinkedIn if you want to receive any news about it. This QR code here will be available at the end of the presentation, so do not worry about that. And so let me quickly define the working keywords in this presentation. Neurogames are video games that use neurotechnologies as part of their game mechanics. So far, so good. Neuro rights, as we have been discussing for a few hours now, are a new international legal framework for human rights specifically aimed at protecting the brain and its activity as neurotechnology advances. These rights have been developed and championed by the Neuro Rights Foundation. Picture here is Dr. Rafael Yuste, one of its most prominent advocates. The Neuro Rights Foundation proposes a set of 5 neuro rights, which we have been discussing so far, to be enshrined in every country's code of law. I believe that some of them can be directly applied to neurogames, but not all of them. Not completely. I'll briefly present my conclusions on this subject matter, and I encourage you to read my article about it once the conference papers have been published. Sorry. The first neuro right is defined as the ability to control one's physical and mental integrity. Third-party institutions should be funded to actively oversee and test, before commercial release, any neuromodulating game to ensure its safety even after publication. Said institutions should actively track any changes stemming from the use of published neurogames and also alert the population and governing institutions of any abuses and trespasses to the right to identity. The second neuro right is defined as the freedom of thought and free will to choose one's actions. This would mean that neurogame designers will have to be very mindful in the application of neurotechnologies and their ludonarratives. That is to say, in the way the neurogame mechanics reinforce or counter the game's story and narratives, for they may be having a greater impact upon an audience, allowing the designer into a much more vulnerable side of the player's mind. The third neural right is defined as the ability to keep thoughts protected against disclosure. While institutions already exist to oversee and protect privacy concerns, these are not present in all countries, nor are all existing institutions bestowed with the power to punish privacy violations. Neurogamers' privacy can be protected by current privacy laws and institutions, but society might have to make a much more concerted effort to strengthen the influence of said institutions wherever neurogames are available. As has been discussed before, maybe neuro rights may be a misstep. How do we approach this in general, even without a neuro rights framework? Now, I'll skip the fourth neuro right and instead discuss how the fifth one fits neurogames, because I believe the fourth neuro right might not completely fit neurogames. The fifth neuro right, thus, is defined as the ability to ensure that technologies do not insert prejudices. Given the medical adjacent nature of neurotechnology, even if used for entertainment purposes, neurogames have the potential for misuse in a much more structural manner. Not unlike social media abuses we are tragically familiar with nowadays, which also require a structural effort to regulate and a concerted cultural shift to avoid. Now, let's see. The fourth neuro right. I believe that this fourth neuro right might not completely apply to neurogames. This neuro right is defined as the ability to ensure that the benefits of improvements to sensory and mental capacity through neurotechnology are distributed justly in the population. As has been discussed before, this might not be immediately feasible because of financial constraints and other constraints when it comes to ensuring everyone has accessibility to technology. While this neuro right mostly does not apply to neurogames as a commercial venture, there is a use case in which it could apply, however. On the one hand, ludic neurogames, games that you play for fun, just like video games, need not be treated like a medical necessity and should be allowed to compete in the market like any other luxury. On the other hand, this stipulation might not apply to therapeutic neurogames, gamified neurofeedback, and other clinical applications where virtual worlds and BCI are required as part of treatment. Following transhumanist philosophies, any technical innovation that can relieve human suffering should be universally available. As to how we get there, that's an entirely different story. And I also believe that neuro rights might benefit from additions, expansions, and specifications, even though this might be a little bit of a misstep from a legal point of view. In the case of neurogames, I would propose the right to be protected from abandonware. You see, neurogames, as they continue to penetrate deeper into the mind and even the brain itself, well, these neurogames should not be chained to long-term corporate greed. Any ludic neurotechnologies that are no longer being actively exploited by intellectual property holders should be allowed to be maintained and updated by interested parties, if only because forcibly retaining neurogames in the abandonware category would, at best, deprive the world of a cultural artifact and, at worst, leave users with an invasive piece of scrap metal just stuck inside their bodies, which is not optimal. As for invasive neurotechnologies in and of themselves, companies and governments should guarantee either long-term support or the safe removal of invasive neurotechnologies once they can no longer receive technical support. On that same vein, while it would be irresponsible to promote biohacking for the general public, the right to self-repair and to seek long-term technical support from unaffiliated third parties should be guaranteed via the safest possible means. And those are my views as a neurogame developer as to how neural rights could be applied to neurogames. This is, of course, an early exploration, and further discussion is, of course, necessary to build a better future for all of humanity, as we have been discussing for many hours now. And with that, I thank you very much for your attention. And yes, now I would leave the virtual podium to our next speaker, in fact. Thank you.
Thank you very much. Thank you, Diego, for this stimulating talk, which contributes to our previous debate on the necessity and the content of new rights. And now it is the turn of Alessia Del Pizzo from the University Nicolò Cusano. She will give a talk entitled The Right to Remain Opaque, Neuroscience, Intentionality, and the Concept of a Legal Mind. Alessia, the floor is yours.
Good afternoon, everyone. Thank you for introduction, and thank you to Professor Salardi, University, and all organizers for the invitation. I would also like to thank the other speaker for their very interesting contribution. Let me start. My main message on my speech today is this. Neurotechnologies from EEG to BCI and fMRI integrated with artificial intelligence algorithm are step-by-step turning what was unspoken into data, making part of our mental life computable. According to recent study, what used to be unexpressed can now be measured, made into data, and used to draw conclusions about our mental states. This raises a clear legal question. What, under the law, can we know or even infer about someone's mind? My thesis is that we should recognize the mind as an independent legal asset and establish cognitive opacity as a constitutional limit to any inference about unspoken mental states. It's important to start with the premise. In the current state of research, the neurotechnologies do not read will in the legal sense. They measure neural correlates. They can detect signals that in simple tasks and controlled settings are associated with certain context or intention. But there is a gap between neural preparation and legally relevant decision. Neural preparation is an early brain activity that gets the body ready to act. These signals are general, show only high chance that an action may happen, and the person can still stop the action. They do not show the person's reason or goal. A legally relevant decision is something different, is a conscious choice with a purpose. It's shown in a word of action and it stays under the person's control. If we mix up these two levels, we risk taking a simple brain signal as if were legal intent. For this reason, the law must protect the line between what can measure brain signal and what can be know a judge about a person, so intention and decision. Two ideas guide this approach. First, the concept of legal mind. The mental sphere is something the law protects itself, is not just personal data. Second, cognitive opacity, a clear limit on access to unspoken mental states. This limit is not only about how much data we collect or about consent. It comes before any collection of signal, before decoding, and before any prediction about what has not been expressed. This view is based on our rights, human dignity, mental and bodily integrity, privacy and data protection, and above all, freedom of thought in the forum internum. By forum internum, I mean the inner core of thought, free from outside interference. What is not expressed cannot be forced out or put under mental monitoring. This translates into a three-level framework: unavailable core, reinforced category, relational sphere. About the first, unavailable core, discover unspoken mental states, intention, emotion, memories, disposition, and any prediction about them. In this area, access, decoding, and prediction are forbidden when they touch the inner core of thought. The ban apply even with the consent because the law does not allow people to give up what is protected in the core. About reinforced category, outside the core, users are allowed only in exceptional cases based on a clear legal basis and only after strict test of necessity and proportionality. In practice, should no less intrusive alternative exist, carry out strong impact assessment and apply high technical safeguard. For example, design for minimization, on-device processing where possible, full traceability. In this condition, if these conditions are not met, the user is not allowed. Third, relational sphere. When a person chooses to share mental content, for example, through a BCI in a clinical setting, the use is allowed but tightly limited. Purpose limitation, communication only, no profiling, data minimization, only necessary signal, and a ban on predictive use and control across the whole chain, including the model. This is the substantive framework, but without testable technical rules, it remains abstract. I propose three practical tools. Non-inference by design, define permitted usage in advance and embed technical block in the model and data to prevent interferences about unspoken mental states. Transparency and proof, clear notes on what the system does and does not do, immutable logs, full traceability, and if trade secrets apply, provide testable checks to show banned features are off. Third, rights that follow the model. If a modeler retains personal traces, right to delete, restriction, objection, and rectification must apply at model level, removing personal footprint from its behavior. As we move from principle to practice, we need strict standard when neuro AI enter in high stakes context, court, hospital, workplace, school. A result counts only if we know the signal source and the handling, if we know the error rates, if it's work outside the lab with real people and devices. Above all, no reverse inference. A brain pattern alone does not prove a truth or an intention. In this condition, if these conditions are missing, evidence must be excluded or used, paused until science law provide solid grounds. This is also the direction of regulation. European law protects the dignity, integrity, and privacy, and freedom to keeps an absolute inner core safe. The European AI regulation ban manipulative practice and emotion inference, and they require documentation, logging, and ongoing monitoring for high-risk system. The shift, in my opinion, is clear from data protection to mind protection in a new dimension of privacy, a modern use excluding alias. In practice, public buyers and certifier should accept only systems that show non-inference by design and a credible cognitive right impact assessment, no emotional recognition. And require independent neuro audits with incident log to check compliance over time. I will end with one message. The unexpressed mind, the inner core of truth, is off limits. Neither public interest nor consent on their own justify capturing, decoding, or predicting that core. Cognitive opacity needs design, control, and proof across the system life cycle. Thank you.
Thank you very much for this detailed proposal that I'm sure will be discussed also in detail by our discussant. And now I think that Jose Miguel Dieguez Rodriguez has solved his problem. Did you do?
I hope so. I hope so.
Okay, we cross our fingers and the floor is yours.
Well, I'm going to skip the first part because I think that we are going to win some time with this. As I have said, the current neuro devices available in the market for for workplace are almost related with safety and security. For example, to measure fatigue or to measure stress. We have seen ergonomics, and the important point is our legal current legal framework, ready for these challenges. If any reason justifies adopting a specifically European lens to analyze this question, it is the data protection regime with the GDPR as its keystone. Under its definition of personal data, it is difficult to conceive of any processing involving neurotechnologies that would fall outside its scope. And the obligations imposed on controllers are far-reaching. They must establish a lawful basis for processing, ensure transparency through clear information to data subjects, respect principles such as purpose limitation of data minimization, guarantee accuracy and integrity, and implement technical and organizational safeguards. But above all these obligations, I want to highlight the requirement of conducting a data protection impact assessment whenever processing is likely to result in a high risk to the rights and freedoms of natural persons. This mechanism, designed to move a narrow conception of privacy, compels controllers to evaluate necessity and proportionality and to identify risks not only to data protection but also to other fundamental rights, such as freedom of thought, freedom of expression, or non-discrimination. The assessment must describe this agent's processing and its purposes, evaluate its necessity, identify the risks, and outline the measures adopted to mitigate them. As we can see, we already have an extraordinary breadth extraordinary broad regime, sorry, so broad as some authors as Nadezhda Purtova has called GDPR the law of everything. And I would like to add to his naming that maybe the problem is not only that GDPR acts as the law of everything, but that data protection authorities that are usually not very well equipped, not counting with the best experts in their countries, are acting like the judges of everything when they are not judges at all. And the challenge, therefore, is not a lack of regulation, but the danger that data protection, by its sheer magnitude, may overshadow and absorb other fundamental rights. Still, the GDPR is not the only instrument applicable to neurotechnologies, and in the European legislation, are established additional guarantees to ensure that only safe and reliable devices may be deployed, without which the right of workers to health and safety could not be effectively secured. For example, under the medical devices regulation, electroencephalography and functional near-infrared systems intended for diagnostic purpose are classified as Class 2 as medical devices, with Class A being the least regulated and Class 3 the most regulated one. And a much more rigorous regime applies to neuromodulation, because regardless of its purpose, medical, non-medical, for any kind of purpose, all of them falls into Class 3 of the medical devices regulation. Moreover, when such devices function as protective equipment with the aim of preventing workplace accidents, they also fall within the scope of personal protective equipment regulation, which requires all PPE to meet essential health and safety standards and undergo a conformity assessment before being placed on the market, with third-party evaluation mandatory in the case of equipment designed to protect against fatal risks. Another cornerstone is the Artificial Intelligence Act, because analyzing brain data requires AI techniques. Workplace technologies fall within its remit. Where they are not covered by the provisions in Article 5, they are classified as high-risk systems. Compliance for this kind of system is demonstrated through a conformity assessment leading to a CE marking, either through internal control or by a notified body. The Act also establishes outright prohibitions, most notably the ban on systems intended to infer the emotional states of natural persons in the workplace. And in order to clarify the scope of this prohibition, it is worth to say that the European Commission has recently issued its guidelines on prohibited artificial intelligence practices. And although stress is not expressly mentioned in the AI Act, the guidelines treat it as an emotion whose recognition in employment context is as a rule forbidden. They further specify that no exceptions apply in recruitment or probationary period to this rule. Nonetheless, the framework allows a narrow opening for medical or safety purposes, but only in situations where elevated stress or loss of concentration poses a tangible safety risk, such as, for example, when operating hazardous machinery or handling dangerous substances. And even then, it must be demonstrably necessary and proportionate, time and scope limited, preferably preceded by expert assessment, and insulated from any repurposing from productivity or performance control. So even if it is not clearly established in the AI Act, the interpretation of the European Commission is yet with already with the AI Act any processing of emotional data, it can be heart rate, it can be cognitive data, for productivity or performance control will be banned by European law. This is not the same case that for fatigue recognition, because Recital 18 clarifies that emotion recognition does not include physical states such as fatigue or drowsiness, thereby placing such applications outside Article 5.1 letter F. This, in my opinion, aligns very well with the Framework Directive 89/391, which obliges employers to safeguard health and safety in every aspect related to work and to evaluate all risks present. So I understand that not only external risks, but also internal risks coming from the own body of the worker. In certain cases, maybe proportionally deployed neurotechnologies could therefore be not merely permissible, but practically required, where they represent the most effective means of preventing risks linked to physiological states. Even so, the general obligations attached to high-risk AI systems still apply, and proportionality demands a strict necessity and careful limits in constant monitoring may itself become a source of techno-stress. So this analysis suggests that neurotechnologies do require targeted legal adaptations. For example, while the AI Act excludes emotion recognition for productivity purpose, there is no specific European Union rule expressly prohibiting the use of brain data for such sense. Nonetheless, the GDPR, in conjunction with the right to fair and just working conditions, suggests that even in the absence of an explicit ban on the use of brain data in the workplace, whenever processing is unrelated to preventive purposes, this is going to be understood as unlawful for being against fair and just working conditions. That is a fundamental right recognized in Article 31 of the Charter of Fundamental Rights of the European Union. But even in that case, it would be better for security of the economic operators to have a clear rule determining this one in the same sense that the AI Act bans the use of emotion recognition. In parallel, the development of robust certification standards is essential, ensuring that wearable neurotechnologies are not only safe, but also accurate and reliable. And a different perspective must be considered if effective tools for cognitive enhancement were to emerge. In such a scenario, the liberal conception of cognitive liberty elaborated by Babbage, understood as the individual right both to modify one's own mind and to refuse external interventions, will acquire renewed relevance. Babbage itself has acknowledged the difficulties such a liberal approach will face in practice, because large-scale recourse to enhancement could intensify inequalities and generate pressures on individuals to enhance themselves simply to remain competitive, thereby undermining the very autonomy that cognitive liberty seeks to protect. One might argue that the problem of unequal access could be mitigated if cognitive enhancement were incorporated into public health systems guaranteeing universal coverage. Yet, the immense financial costs such a program will entail make it difficult to envisage in the near future. And even if in the best case scenario we can think of this kind of right secured by social security policies, this is not going to make disappear the invisible, extremely hard competence between workers to keep the pace, keep being the best candidate. So I don't see a future in which employers must need to force employees to be cognitive enhanced because they are going to do it voluntarily just to keep fighting for the best jobs. Just for finishing, I think that it's important to highlight that a recent report of the European Parliament Research Services has pointed out that individual liberty and freedom to conduct a business, both of them fundamental rights recognized in the Charter of Fundamental Rights of the European Union, guarantees the right to commercialize invasive neurodevices even for non-medical purpose. So the solution and the balance to this problem, it's going to be very complicated in the future, because maybe we have to choose between formal equality before the law and social equality, having to modify these formal liberties in some way. So it's a very complicated question that I humbly recognize that I am not able to resolve right now. Thank you very much for your attention.
Thank you very much for this analysis of the workers' right in front of these new neurotechnologies within the European normative framework. And now it's a moment for our two discussants. The first discussant is Francesca Gasparini from TechSedu and from the University of Milano Bicocca. Thank you.
Thank you for the introduction, and first of all, I want to thank you, Professor Salardi, for inviting me to this very nice event, and also all the presenters. First of all, I want to say that I am a computer scientist, so I will comment the contribution from my perspective, which is a very technical perspective. I want to underline one aspect with respect to the risks of adopting neurotechnology that probably was not so expressed, was not so clear from the previous contribution. I read also the paper, so I also refer to what I read within the papers. And I found several times risks related to ethical issues, like being able to recognize the brain patterns that are related to behaviors of the subject, and thus, for instance, if we can recognize a certain bad behaviors, should we act in order to stop that person, for instance, in certain social work, for instance, if we don't want him to work with the children because we recognize a certain pattern in his mind, or other issues related to the fact that maybe we can have malicious intent with respect to what we can do with these decoding the brain waves. And this is, of course, these are all important problems, important issues, but they imply that we are able to properly decode the brain waves, to properly to have signals of high quality. I really appreciate the talk of sorry, I don't remember the name, but yes, Alessia Del Pizzo, that introduced the fact that what we are considering are signals. So we are working with signals, and if we do not have signal of high quality, we probably would not be able to understand the thoughts of a person, decode the pattern from the brain. So these are risks, of course, but I think that these risks are not so present in normal life. But there is another risk that is related to low-cost devices, consumer devices, that is related to what happens when the feedback from this technology is not adequate. I want to clarify this point. I think every one of us experienced the frustration when we talk with Alexa, for instance, and we do not receive the proper answer. But here the point is we have a completely control of our signal, because it's our voice, it's our command. This is related to words that can be easily interpretable. But when we have brain waves and the feedback coming from the device is not clear from the subject perspective, the point is not that Alexa is stupid. Maybe the problem is related to the subject himself or herself, because I would probably not be self-confident about my ability of using my brain, maybe, or maybe I can, yes, refer the problem not towards the device, but I will revert the problem with respect to my not good capability of controlling my mind. So I found that this risk is higher than other risks related to being able to decode high quality signal. This is related to consumer devices. And so I would like to understand how this problem could be like considered with respect to all the possible levels of regulation that we have introduced. And another point that I want to underline is that we are continuously monitored by several devices, and one of them could be a smartwatch that is able to collect our data related to physiological signal that can provide us information like our level of stress, our level of attention, and so on. So these devices are currently adopted within also working environment, and I trust them at the same level of other devices, neurotechnological devices like the Muse one, which is a very commercial one. So probably we need to also consider enlarge the idea of what we should regulate, not only what is coming from our brain, but probably also other kind of signal. And I talk about signal because I mainly work on signal. So this is my technical point of view.
Thank you very much, Francesca, for contributing with your technical perspective. I think that surely it is crucial to take into account such perspective in order to understand problems and obviously also propose new solutions. And now we have a second and final discussant, who is Aurora Saibene. She's also from TechSedu and from University of Milano Bicocca.
Thank you for the introduction, and thank you for the invitation, Professor Salardi. I'm also going to say that I'm a computer scientist, so I'm also the technical part of the audience here today. And let me just build up on what Professor Gasparini was saying just a few minutes ago. So basically, I think we have to distinguish between different realities. So in a case, Professor Gasparini was pointing out the reality that is outside of hospitals, for example, so wearable devices, and, actually we can infer information from other people, like unspoken mind, also from other type of physiological signals besides the neural one. So that's a point that we should consider. Moreover, we have the clinical kind of environment that we should also consider in our speeches. And let's say that there are different kind of levels that we should consider when talking about this kind of legal problems and ethical problems. And technical problems, I would say, because also here there is a matter of acceptability from the users of these devices. So usually when you go to the medical field, you accept more or less the kind of treatment that are given to you. But of course, if you can decide yourself what kind of devices to buy, you may think about taking it or not. So from more of a commercial kind of point of view. And what I'm arguing here is, are the commercial, for example, commercial available neurotechnologies up to the challenge of having that much risks injected in those kind of devices? I mean, are hardwares and software sufficiently advanced to have such a dystopic kind of vision that has been envisioned right now? I understand the risks, but right now, what is exactly the advancement of the technology for it? And also here is something related to the fact that algorithms are in this case, opaque. So besides having the opacity of the person, so trying to build up on an opacity, as Alessia was saying in her speech, maybe the opacity should be removed from the algorithms more than asking the people to be opaque to the system, because the system needs the data from the person to understand what it's doing. So basically, it's like, I'm giving the data, I want these results from the machine, but you shouldn't have my data because my data are actually biometrically insecure in a sort of way. And actually, I understand the fact that it should be safeguards, but how much can we insert as safeguards before we actually remove information that we need to make the computation? So actually think everything is on trade-offs and also on the concept of responsibility. So when responsibility comes in and who will be responsible for our data and how we manage it. So these actually are my 2 cents, and maybe even if there is the possibility to have some answers from the audience and the speakers, it would be very nice. So this is my 2 cents right now. So thank you.
Thank you very much, Aurora, for your comments and for outright so very good overview of many different problems that are involved in this discussion. Silvia, I think that now, please tell me what to do.
I don't know if there are urgent questions. Otherwise, I think it has been a long day, and unless there are questions in the chat, but I do not see it. I do not see them. And Douglas can confirm me, perhaps.
Yeah, there's no question. I
No
mean, if there's
question.
time, I have a question for Diego Saldivar.
Ah, yeah, you have a question. Yeah, please.
Yeah, I just have a quick question or a consideration. I loved your presentation, by the way. It's good to have a different perspective from a person that is not necessarily involved in the legal scholarship. Do you by any chance have also reflected if in the case of minors, for example, if it will be required maybe some sort of special neural rights protection in gaming because of their adaptive mechanisms or anatomy? Thank you.
Yes, thank you for the question. Actually, I do discuss that briefly in my master's thesis for neuromodulating games. They are mostly in a laboratory in Washington, but it is clear that younger minds are far more flexible. And even if you don't have invasive neuromodulation, just having any kind of technology near a very young mind can reshape it. We have seen that happening with the tablets, making children a little bit less likely to get a book and much more expectant to touch a screen and make it react, etc., right from a very, very young age. The same could happen if you give a 5-year-old, a 6-year-old a neuro game with just a brain-computer interface that reads brainwaves, right? Their mind will adapt to that. And if they do that from a very early age without proper adult supervision or without a bit of a pedagogical approach to it, where the kid is taught a variety of skills instead of concentrating on one, there might be a danger of hyper specializing the brain at a very early age, which might not be very cognitively advantageous when it comes to later ages, where critical sense is supposed to develop, where the sense of artistry and creativity is also supposed to develop. If they have been hyper concentrating on a specific way of making things work with their mind. And that's just without neuromodulation. When it comes to neuromodulation in and of itself, we already have laws trying to protect the exposure of neuromodulation at an early age, because there are risks involved in leading the brain into forming specific kind of connections or behaviors from an unnatural point of view, right? Because this is not natural. This doesn't happen naturally, of course. So, of course, we also have, as to take that into account in theory, as I said in the chat, it might be a bit too late if we start trying to build safeguards when technology does become advanced enough for us to start becoming worried about it. right? So if we start right now thinking, okay, what are the current problems that we see? What are the problems that we can anticipate according to the history that is available to us? Then how do we protect our future users as when it comes to medicine or video games? How do we protect them from either misuse or from accidental malignant results, right? Because sometimes you don't expect things to happen in a bad way, but just nature proves you wrong. So I hope that I answered your question there when it comes to these kinds of things. And I'm very glad that I had that question. I'm actually very interested in that topic.
Thank you very much. Thank you very much.
So I think we can close the conference. Thank you very much to all the people that remain till the end of this long day. And thank you to Francesca Gasparini, Francesca Poggi, Aurora Seibene, and all the speakers of this session. Thank you to Douglas, who supported me a lot during this day in the in the backstage, but he was present. So bye-bye. Have a nice evening.
Have a nice evening. Bye-bye.
Thank you. Have a nice evening.
Bye-bye.